Good afternoon. It is 5 p.m. and we are calling this work session to order. This is a special meeting of the Kent School District Board, which is held in public to comply with the Open Public Meetings Act. The purpose of this special meeting is a work session to discuss the Open Public Meetings Act, OPMA, and the Public Records Act, PRA, with legal counsel Curtis Leonard. At this time, we will call for a roll call of board members. If I say your name, please indicate your presence by saying present. Director Song?
Present.
Director Cook?
Present.
Director Clark is absent and excused. Director Farah is also absent and excused. However, he may make a debut with us here in the middle as he would be online for that. And then I am present. And first order of business, let's call upon Mr. Leonard to begin our presentation today, please.
Good evening to the board. Good to see you all today. I want to start off with a little bit of an introduction. We've had this presentation before, so it's a review. But to the extent that we have new board members that maybe were brand new to the board when we first covered this, it's a good review. And so we're going to be going through some materials in OPMA and public records. But I first want to start with a little bit of an introduction. And this is a question that was forwarded to me by both Director Cook and Director Song about, what's the role of the board attorney? And, how do we think about the role of the board attorney? Who do they represent? And are there ever questions about who the board represents? Is there a conflict of interest if the board attorney does work with the school district? And so what I wanted to do is at least share some information related to my role as the board attorney and who do I represent. I pulled this information from WASDA, which is the School Directors Association, which governs school boards and provides a lot of resources to directors and school boards related to this question. They have a publication from 2022 related to, it's called School Law, or Basics of School Law. And in their section, and I'll send this to the board so you can see it. I don't have it in your materials now, but I'm going to share some of the information. It says, generally, each school district will have an established ongoing relationship with one or more attorneys. Individual board members do not ordinarily deal directly with the district attorney. Rather, the superintendent usually does. So I'll just pause there. So I do have the ability to interact with you individually, but a lot of times my contact is the school district, superintendent, deputy superintendent, and I don't always communicate with the board. But in this district, I do. I mean, I do come to the board meetings. I certainly communicate quite a bit with President Markell. And so there is that relationship, even though a lot of times I'm working more with staff. I'll continue in the publication. It says, regardless, the attorney represents the board as a whole, not the superintendent or any individual employee of the district. And that is an important distinction. I represent school boards, probably around 50 school boards in the state, and I've never represented an individual employee. I don't represent a school a superintendent. I've never represented a superintendent or an individual employee in my role. In fact, if there ever was a conflict, I wouldn't be able to represent the superintendent or any individual employee. In fact, that employee would have to seek their own counsel because I represent the interests of the school board generally. And it says here, it continues in the publication from WASDA, if there ever is a conflict between the board and the superintendent, the attorney will work with the board, not the superintendent. And that's how I view my role. Moreover, it continues, the attorney does not represent individual board members. Once again, the attorney represents the board as the governing body of the school district. So I just wanted to share that information because there had been questions about my role or questions about, hey, Curtis, you represent the district. What about the board? Does the board have their own separate attorney? And I just wanted to communicate to you that that is my role representing the board. And certainly I want to be available to answer any questions related to that if you have any questions, just so we understand what my role is here. But to be clear, I do not represent any individual employees either in the district or on the board. Any questions related to that?
Yeah, I guess I have one question. So When it comes to a situation where there's a conflict between the district employee and the school board, the priority goes towards the board, right? With the conversations had with the board, is there any client-attorney confidentiality, or is anything shared and communicated amongst the board to the district council? Is that information also able to be shared with the superintendent or any other district employee?
So a lot of times, it's a great question, Director Song. It'll depend upon the nature of the information. If the information potentially could be adverse, meaning there's a potential for an adverse relationship between the superintendent and the board, the information that I share with the board would not be able to be shared with the superintendent. That would be confidential.
Okay, and that language still seems a little vague to me. When we discreetly define what those parameters look like, are there specific case studies or examples that we can reference so that the board has some form of reference in identifying what would be considered confidential versus what information would be shared with the district employees?
I would say, generally speaking, is if the parties potentially could be adverse. And an example would be what we've just engaged in. And I'll say adverse, meaning there could be differences of opinion or difference of position. And in the negotiations with the superintendent's contract, I use the word adverse. It doesn't necessarily mean it's adverse like in a court proceeding, but adverse meaning the superintendent could secure his own counsel to engage in that process, right? Because there's differing interests. There could be the interests of the board and the interests of the superintendent. In that circumstance, if the board is in executive session to discuss the details of the superintendent's contract, that attorney-client privilege, meaning the relationship that I have with the board, and as we covered before, does not extend to the superintendent. So in his role as the superintendent, his authority is limited in that I'm not advising him. He has his own counsel. And so that information would not then be disseminated to the superintendent or any other employee in that manner. In fact, that attorney-client privileged information would stay with the board.
Okay. And then under whose discretion is it to make the determination that there's a potential conflict that could be defined or identified as adverse?
That's a great question. I have my own ethical obligations that if I feel that there's a conflict, I am ethically bound by rules that govern attorneys that I have to disclose that there's potentially a conflict, okay? And a situation in which that does occur is if an individual has a conflict, meaning superintendent or an individual employee, I am duty bound to disclose to them, look, I'm not your attorney. I represent the school board, okay? And I can't advise you. In circumstances in which there could be adverse, it would be employment situations where it could result in discipline or performance issues would be an example. Contract-related issues would be an example. Anything that potentially could result in a lawsuit would be an example. Those would be examples in which I couldn't represent the individual employee if I'm representing the school board.
Okay, thank you.
Great questions. All right, I think we got my mic worked out. All right.
Seeing no additional questions, I would like to just point out too, thank you for talking about the OPMA. This is a renewal of going through the information. And just to also reiterate to all the board, yes, you probably will hear it again because we've already talked about this also during our last retreat meeting too. So so thank you for doing the formal, and we have on this important topic, we have discussed it many times.
We have, and we probably will continue to discuss in the future as well. And so what we're going to do is we're going to start talking about the OPMA, and we're going to talk about the requirements of the OPMA. We are in open public session right now, and we're going to talk about the difference between exempt sessions and executive sessions. And we're going to talk about what a serial meeting is and why our emails are extremely important in terms of what we send, how we reply all. And these are things that keep the organization safe from violating OPMA. We don't want to violate the OPMA. We want transparency. And what the OPMA stands for is that all meetings of the governing body shall be done in public, with persons, and all persons shall be permitted to attend any meeting where the governing body of the public agency, any meeting. And so that's provided in our CW.
And basically, the scope of the OPMA includes, of course, school boards. We are under the OPMA. Our meetings have to occur in public unless we have some exceptions, which are found in executive session. And then we're going to talk a little bit about exempt sessions. Those are meetings that actually don't apply to the OPMA or fall under the OPMA. And interestingly enough, courts in the legislature, they are not subjected to the OPMA. And I don't know why they exempted themselves, but they didn't. But it does apply to us, so that's what we have to worry about. As a matter of, if you look at the bottom of page 2 on slide 4, and I'm going to go ahead and advance slides. I might not have that. Carolyn, if you could help, that would be great. I would say there are some high-functioning boards that get confused about what is an exempt session versus what is an executive session. And they are different. And I'm going to start first with exempt sessions. Exempt sessions are sessions in which the OPMA does not apply, meaning you don't even need to announce that you're having a meeting. The most common, there's two really common ones, and I would tell you in my role here as the school board attorney, we've convened an exempt session on these items. Quasi-judicial matters, which would be when the board is reaching a decision. And you can think of, judicial meaning I'm reaching a decision or the board's reaching a decision. That means you're collecting evidence in a hearing. It could be a hearing under board policy like we did under 3205 or 3207 or 3210, where the board's reaching a decision. Those are considered exempt to the OPMA, meaning we convene as a board, we don't need to announce, we don't need to do public notification, and it's an exempt session. How do we know if it's quasi-judicial? You're reaching a decision that's going to be sent. That's what I mean by quasi-judicial. The other main one is collective bargaining activities, updates to collective bargaining, or matters involving collective bargaining. It could be a grievance meeting or an arbitration meeting in which we're discussing matters relating to a CBA. Those are also exempt, okay? I see a lot of school boards mess this one up, and they do it as an executive session. We'll get to those here in a second. It's not an executive session. It's an exempt session, okay? And that's a clarity piece there.
So just curious.
Yeah, Director Cook.
Just curious, when the board meets in exempt session, are there any ways that the board would not indicate that they were meeting to the rest of the board?
No, I mean, look, it's not considered a meeting, but it looks like a meeting. And so I would want some formality associated with it. And I would want to make sure that the public is clear that, one, we're not talking about other items that would be appropriate for open session or other items that would be appropriate for executive session. And so there is some sort of formality. I would expect the school district to invite board members, all board members, to attend. It shouldn't be less than. I would expect that to be the expectation, and that we stay on topic. And so if we're in an exempt session and we're talking about collective bargaining, we're only talking about collective bargaining. Even if we get off topic and we want to talk about an item about an executive session, yes, that's appropriate to talk about in executive session, but it would not be appropriate to talk about in an exempt session.
Is there any time that you would remove a board director from going into exempt session or knowing about an exempt session that was being held?
Other than what we know of the 1669 resolution, other than that, in my experience, no.
Have you ever heard of any other district in the 50 or so that you've had that did do such things?
I can't think of anything offhand, Director Cook. I mean, if there was a conflict, if any individual board member felt like there was a conflict, I'd have to see it. It's pretty rare, I'll tell you.
Would it not then also be that board director's choice to then recuse themselves, not others' choice to recuse them for them?
It hasn't come up as much. I don't have an answer because it hasn't come up a ton. I mean, the example that I give is the spouse that's on the bargaining team or are part of the bargaining, and that's the example that we've talked about before at the dais before. And I've had that situation come up, and I can't remember if they recused themselves or what the situation was, but they weren't involved in those conversations.
I see. So the only time that you've ever dealt with that, it was when there was a direct conflict of interest with an employee that worked within the district, and they were talking about that employee's contract?
That is my recollection, but don't quote me on it. It's been a while since I've even had any of those conflicts.
I understand.
It's been a while.
Thank you.
All right. We sometimes ask what a meeting is, and
I just want to interrupt that. I would like to invite Director Farah. He is joined us. Thank you, Superintendent Bell, to letting me know that. And we just can't see him, but he is listening in with us.
All right, thank you. Welcome. And we do want to expand our definition a little bit about what is a meeting. Sometimes we think a meeting is just where we're collectively sitting together at the dais, and that's a meeting. The legal definition of a meeting is more expansive than that, and we need to be careful about potentially conducting meetings electronically or when we're not all physically present in one location. A meeting simply means when, with collective intent to meet, a majority of the board members collectively transact the governing body's official business. And that can happen, that might inadvertently happen on accident when you're all together, and that's why we want to be very careful. That can inadvertently happen over an email or over electronic means. That can happen what's called a serial meeting, in which we transact business talking to one another separately, and then it's almost like we were collectively there in time and space. But the key factor here is when we intend to meet with the majority of the board members to transact government business. And this could also, it applies to anything, even if it's not called a meeting, like a work session. Like today, this is a work session, and this is a meeting, even though we don't have a discussion or resolution and proposed, it's still a meeting. A meeting is considered a meeting even if action is taken. Physical presence of members is not required. A meeting might occur via phone or email. A meeting does not occur if there's no quorum, so if there's less, that's likely not a meeting, but I'm going to caution you about what is called a serial meeting, which I'm going to show on this next slide.
Can you define action?
Yeah, we're going to get to that. In fact, I'll do that right now. How about that? So action, a couple of slides ahead, slide 12. Slide 12, action is more than just adopting a resolution. Action can occur receipt of public testimony, even deliberations. This is probably the one I want you to be most careful about. Because if you're talking to one another and you're just trying to get everyone's input, even if you're deliberating over it, it's considered action. Well, Curtis, we didn't take a vote. We didn't reach a decision, but you're deliberating, or the next one, having discussions or considerations. That can be considered action, even though you're not taking what's called final action. Final action is where you actually take a vote. So as you can see how a serial meeting, or if you're talking to board members individually, one-on-one, could turn into the official business of a public agency, even though you're not all meeting together. Well, we were meeting in 2x2s, and we were all discussing this. We have to be very careful, because a lot of these conversations, deliberations, and discussions could happen in open session.
Which one, like, I'm just curious, the second to the last one there says evaluations. Which evaluations would apply there?
I pulled this from OPMA's evaluations. I think is more evaluations of a problem or of a situation. It's more in that discussion consideration. Evaluations of a public employee, probably also considered action, but are protected under executive session.
And
A great question.
Just one question on the on your role here. When were you, I guess, hired as a board director or as the board's attorney, and when did they vote on that?
So if I recall, and we'll have to check the archives, there was originally, so hiring legal counsel does not require a bid process. But I was originally hired as part of a bid process, I believe in 2013 is what I recall, and I interviewed with the board directors and put in an actual application and a bid process, and was selected. Don't quote me on the year. And it was when I worked for a previous firm.
I see.
And,
So,
and while interesting questions, I don't think it's specifically on OPMA, which is what the topic is of hand. So if we could stick to OPMA,
sorry, I was just basing it off of what he had talked about at the beginning. So that was his presentation, not mine. Thank you.
Okay, so serial meetings, this is one that we just need to be aware of, is having conversations individually. I mean, if you're sharing information that is germane to a big decision, you know, I'm going to invite us to do as much of that in open public session. That's the easiest thing. You have a discussion piece, you have the ability to do that in open public session. I would prefer that that's where we do the majority of our discussions, unless we're in exempt or executive session. A serial meeting can occur where members of the governing body have a series of smaller gatherings or communications that results in the majority of the board taking action. And again, by definition, we saw on that other slide, that could be discussions, deliberations, considerations, evaluations, even if the majority is never part of any one communication. Such meeting can violate the OPMA because it amounts to taking action as defined in the RCW, outside of an open meeting. And those can happen outside without technology. But one of the things that I just want to put on your radar is that kind of reply all communication. You know, we've all heard the horror stories where we reply all. We certainly, as board directors, can't control the way communication is sent to us. It can all be sent to all board members, but we can control our response if we reply all. And if we reply all and we are taking a collective position, or even if it's your individual position and it's part of a discussion or deliberation and it's sent to all board members, there is a threat that you are conducting a serial meeting. So we want to be careful. I will also state we can't control if members of the public email you collectively or individually. And I would point to we have established board protocols in terms of how we communicate with the public. Because what we don't want, two things, a serial meeting. Second, 5 individual positions being sent out. And so I would defer to appropriate board communication protocols, which is we allow the board president to address communications to the public to the extent possible, especially where the board is taking and responding to questions to the extent that we can. So I just want to put that on your radar because we can certainly have the ability to communicate individually with members of your constituency, but we need to be careful as to not take collective positions or engage in the member of the public without really going through our communication protocols. Okay. I covered this just quickly, which was emails. I just can't stress this enough. Let's just be careful. Director Cook, do you have a question about this?
Yeah, so if, say, we did have a serial meeting of some sort, and one of us included, say, a lawyer, does adding a lawyer to the email chain automatically make it a privileged communication without any sort of discussion about it?
It potentially could be both privileged and a violation of OPMA. How about that?
Okay.
So, simply including me on the correspondence does not absolve it from potentially being an open public meeting violation.
I see. Thank you.
Right? So, that said, in an instance where we were talking about items like in an exempt session, if the subject matter is such that it's exempt, like if we are trying to deliberate over a decision of a hearing that was conducted as exempt because it's quasi-judicial, then those communications would be exempt from the OPMA and it wouldn't be a violation, and it's also attorney-client privileged, okay? So it would depend upon the nature of the communication, and that exempt category is the exception in which I likely will communicate with the entire board potentially on, like, say, a hearing decision because it's exempt. But I'm going to be very careful as to not broaden that to anything else.
I'm going to ask a really silly question.
There are no silly questions, I promise.
I'm not very good with email. If the public emailed the board and BCC'd people, and then we replied not knowing people are on there, just to say like, hey, we'll send this to the board president, they'll reach out, does that break OPMA?
So if you reply all and there's BCCs, you will see whether there's BCCs. But if you were just to reply, and
Sorry,
Director Cook,
I'll answer that
maybe
just
you answer,
because I
maybe you know
have
what
some
he's asking.
experience in this space. If someone BCCs, you won't even know that they were there.
Yeah.
they will have an email sent to them as
Yeah.
if they had individually sent them an email outside of the entire group.
No, I know how that part works, but because like technically they're on that email, regardless if we have the visibility, because it's the original email sent, does that qualify as OPMA violation?
I would say likely no. I mean,
Okay.
I still would be careful anytime reply all. If you're responding, forwarding it to the board president for communication, hey, can you respond to this?
Yeah.
You know, I likely am okay with that as not being a serial meeting. I'm more concerned about discussions and deliberations happening,
Okay.
but it's a great question.
But when you reply,
Yeah.
just hit reply instead of hit reply all. And then any of the BCCs would fall off.
Okay.
Again, there wouldn't be any BCCs. BCCs don't flow. Like it's completely independent. You wouldn't even see
If
them.
person A sends you an email with a BCC on it, if you just hit reply, the response would not go to the blind copies that
You
happen.
wouldn't even know that there was a blind carbon copy.
Whether you know about it or not, it still doesn't happen.
Well, I
But-
think I have my answer,
Okay.
so thank you.
That's fine.
We might be over my head too, but
Yeah.
I believe that that's correct. on the-
Reply is much better
BCCs.
than reply all.
Another important point is passive receipt of emails or information is not considered a meeting. And so if information is being sent to you, that's not considered a meeting. You're not deliberating, you're not considering, you might be considering in your own mind, but you're not considering over email. And so anytime you receive information, I'm not concerned. It's the actual response, it's the reply all, and so we need to be coordinated in the response to that because that potentially could constitute a meeting. And so that's why we have board communication protocols. That's we want to know who's on point to respond and how are we responding. And if the only communication is this is going to be responded to by the district, I'm not concerned about that being a decision being made. That's okay. All right. I also want to let you know that this kind of idea of serial meetings applies to other technologies such as text messages or Facebook or other social media that we could all dream of that exists that may or may not exist at this day and come into existence tomorrow. It applies. So that could be Facebook comments, that could be anywhere else where we are potentially conducting business deliberations as more of a quorum or on a topic in which it's done in a serial manner.
So just to make sure I understand this one, just the idea of a board member putting information on social media of which other board members are viewing and part of, whether they respond to it or not, it could be potentially a violation?
Yes, I mean, by itself, technically no. But if other board members interact and take similar action, it would. Because
fault
that's
on-
the serial nature of it.
The fault on that would come on the person that's responding, not on the person that posted the information in the first place, no?
I would want layers of protection to be careful. You know, I mean, I would want to be careful, and I would want each individual board member has this responsibility, the one initially posting it and anyone interacting with it. And I know there's this push and a pull between we want to be responsive to our constituents, we want to be able to provide them information. I will just caution you on Facebook, YouTube, and whatever else that we can put out comments. It can be a minefield when it comes to the OPMA. And if we're not watching it when we post and we interact with that post, in the comments, you can create an OPMA violation.
So along those same lines, let's say we had a situation where there was discussion had in executive session, the materials that were in executive session were voted on, and then decided that we wouldn't share that information in public. Who would have the authorization to remove that from executive session and bring that to the public? Would it need to be a majority of the board, since the board cannot do anything by themselves, that it has to be a decision made by them together?
I'm not sure if I'm understanding the question. So executive session, we have an executive session on a topic. No decision is made or a decision is made? What was it?
Either, well, it doesn't matter, just information is provided,
Okay.
let's say, and the information that's provided is then taken out of that and moved into a public space.
You shouldn't do that.
Yeah, I mean, it would be helpful to know, I know it's a hypothetical and it might be rooted in in an actual situation. I would say generally, if it's information that's protected under executive session, it should remain in executive session.
Until the board decides to waive the executive session and/or privilege?
There are components of decisions, again, it's sometimes hard to give you without having a specific example, because there are portions of decisions where there are portions that are executive session protected and portions that are open session. For example, I'll give you an example, and it's contained in his materials. Discussions about the superintendent contract are privileged, and those negotiations happen either with council or the discussions happen in executive session. But there are portions of that decision that are done in open session. For example, the extension of the superintendent's contract is done in open session. So while there are components that are protected, the actual decision has to happen in open session. Same thing about hiring a superintendent. A lot of those negotiations or evaluations of the superintendent, those happen in executive session, but the actual action taken has to be done in open session. In fact, it's a violation for you to vote to hire a superintendent, or even to say, what do you think about this guy? You know, a lot of those conversations about should we extend him need to happen in open session, that actual vote. And there's a little bit of a fine line there, right? Because a lot of the conversation is appropriately under executive session. So that's an example where you would take a vote in open session. It doesn't waive the privilege of what you engaged in previously. But there are components that could be under executive session and components that would be over in open session.
And so just to clarify on that one, even though a portion of it is brought to open session, the information that was had during executive session and/or exempt session, I guess, but either one, that does not get to come to, just because of portions.
It doesn't open the door to say all that information is now free game. Because we approved the contract or because some additional information was shared, it doesn't open the door from my perspective. Those are still protected under appropriately executive session.
Given your example, the superintendent's review, the end product, is created in executive session as we discuss it as board. And the actual review is public information. As far as I understand from recent legal challenges that were brought against the district for not providing it, in which case we settled.
I'm just going to say it depends.
Yeah.
It depends. And there's a legal analysis that I could get into, but it probably won't be worth our time here. Okay. There's a legal analysis in which I would say the general rule is that performance evaluations are not a matter of public concern. They're protected. Meaning, if someone wanted to ask for, I want a public records request for all teacher evaluations, they're not a matter of public concern and they would not be discoverable. Not only the evaluations, the scoring rubrics, all of the information that's specific to that employee is protected under the PRA as an exemption.
I see.
Okay. There is a little bit of a grayer area that's been litigated before related to the chief executive officer. So I'm going to put that aside. I'm not going to definitively state in all circumstances. It will depend upon the nature of the request and the information that's being requested.
I see.
So it'll depend. And we will, if those requests come, we'll make sure that all parties are interested in the response, have the ability to weigh in prior to releasing information, because I'm weighing both the interest of the public to have the information and the right of privacy of the individual.
Yeah.
Right?
Yeah, I get that. So here's a for instance in that case. The review, in this case, was provided to the public as was determined by legal counsel to be provided. And when that was done, is that item required to have a vote, to have it removed out of executive session, since it was placed in executive session by the board, and the board members, president or otherwise, don't have the option to remove it from that session without a vote of the board? Am I understanding that correct?
I don't think it requires board action.
So could any board director then pull it out whenever they like?
I'm not sure if I'm understanding the nuance that you're pointing to, but I don't think it's a board determination at all.
So who would determine that?
Generally staff in conjunction with council.
So you're saying that the board is the only one that can go into executive session, right? Like, we have to be involved to go into executive session. We're also the ones that have to determine whether or not we're voting one way or the other. So we come out and we do all of that talk in public, and then we bring that information out, which prior to it being brought out was considered executive session and privileged information, whether attorney-client privilege or other. And then it's brought out into the public. That action can be done without any knowledge of the board?
Again, I'm not sure of the actual example in which you're referring to, but generally,
Well, in this
wouldn't
case,
it would be done as a Public Records Act, and it would be done through an examination of the PRO, the Public Records Officer, in conjunction with legal counsel, determining whether it's a public document. And generally, I don't put the board, it's not a determination by the board. There's no board action that determines it be exempt or not from the PRA. Nor do I need the board to weigh in on it. So I'm going to move on just because I can probably talk in more detail about it, but generally it's not board action that's going to determine whether it's a public document or not.
if it's not a public
Independent of
document,
what-
though,
But here's what I would say. We're conflating two things, which is an open public meeting and an exemption and a public record, whether it's exempt from the PRA. Those are two different bodies of law. The PRA, the Public Records Act, and the open public meeting. You could have a meeting that's appropriately convened in executive session, and the documents, the question of whether or not they're exempt is a separate question. Because those documents, it's a different law that exempts those public documents. And so it's not as simple to say, well, the board's in executive session, so those documents are protected under the OPMA. No, they're protected under the PRA. Separate body of law. We would look to our PRO in consultation with legal counsel to make determinations about public documents.
so following along with that line of thought, legal counsel is providing their counsel. They're deciding whether or not something is an appropriate thing to be brought out into the public. Legal counsel is, like yourself, is brought here as the board's legal counsel. It is not the district's legal counsel. It isn't any staff member's legal counsel. So if they're being given advice, how do you square those two? How do you make it so that the board, since you haven't included them in this discussion at all, they don't know that it's happening, but you're saying that they're the only ones that you actually serve. So to me, it seems like you have two masters at that point, and you're not involving the one that actually, like in your own explanation, would be the client, right? The client is the board. The client is not the district. It's not an individual board member, regardless of their status on the board. It's the board as a whole, no?
So here's what I would say, and it goes back to kind of that paragraph I read from WASDA, which is, 99% of the time, the interests of the district, an individual staff member, superintendent, administration, and the board are all aligned. And so unless I view a conflict, I'm operating under the assumption that the interests of the district are represented both by staff members and by staff that have been hired to do the job and by the board. And in 99% of the cases, those are aligned. In fact, what WASDA says is, most generally, even though I'm the board attorney, I'm likely dealing with the superintendent, is probably who I'm dealing with. And the superintendent has authority under RCW and WAC to bind with the district and make decisions of the district, and that is most likely my contact person. Only in a limited set of circumstances is there a conflict. It's most likely conflict, not that everyone has to agree, it's most likely a conflict where those situations that I gave you previously, in which either the performance of the superintendent or the superintendent's contract, or in other circumstances in which they need to hire their own counsel, that's when they're adverse. Not necessarily in that there could be a disagreement between the parties, or we could do it this way or that way. That doesn't necessarily make the district and the board adverse to one another, nor does it produce a conflict of interest.
So how,
That's just any organization potentially could have differences of opinion or things that occur that aren't necessarily conflict. Conflict is meaning you're representing both sides of an issue that are adverse and potentially in a court or proceeding.
so obviously, we have a pretty tense board here at times. And we've tried to work on those relationships some, but that's still the case. And given that, how do you determine which things would be appropriate to be brought to the rest of the board for them to determine whether or not they want to allow you to continue forward with your course of action or choose a different path?
Yeah. So, I look at, when I look at the interests of the district or the interests of the board, I look at a collective position. And so I look at the majority position. And if there's a one board member or two board members that have a position that's different than the majority position, I do not represent the minority position. Generally, I represent the majority position. And so I'm looking for consensus to see what is the direction of the district or the board. And a lot of cases, I'll ask. If a board member came to me and said, can we take this position? I would say that sounds like an area that would require some discussion from the board.
See, and that's where I guess I have a little bit of difficulty, right? So as you're aware, this board has changed hands quite a few times. And the expectation that the board members would come to you with this ask, right? Because they don't know that it even is something they could ask. Wouldn't it be prudent, given your longevity with the board, with the district and the board, to be more open about here are the things that you need to do, and every time you're not sure whether or not the board is in agreement on something, wouldn't it behoove you to make sure that it is? Because in this situation, you outlasted multiple superintendents even, and so during that whole period of time, you have all these different entities that come through here, different members of the board, different superintendents that come through, employees, staff members, everything else, and I don't remember ever having that conversation, about any of the things that have been brought out of executive session, brought out of our attorney-client privilege. Every time that it's been done with no knowledge of my own. I don't know about the other board members, if they had discussions without me. That is certainly possible. Maybe the majority board, as you talked about, made this decision on their own without discussing amongst the entire board. But that seems like that would fall astray of the intent of creating the board in the first place.
So I'll speak to that in this way. Yes, I have worked with the Kent School District for many years as the board attorney, but also as a consultant. My role on the board and the district has changed over a period of time. And my involvement most recently was after a period of time in which the district had secured individual and legal counsel within the district. And so I can't speak to really the last 3 years, probably, or 4 years, in which I was not providing daily legal advice as board counsel. So there was a period of time in which I was as merely a consultant, because you had inside counsel. So I can't speak to more recently. I know that I was brought back on to provide more direct after previous counsel left, and so I can only speak to my involvement since May. Really. In terms of, I believe that, and again, I might not know the situation in which we're talking about, but I will state this without knowing the specific situation. I would want to be very deliberate about when we're releasing information that's considered private or protected by attorney-client privilege by anyone in the board. And that's why I give that directive every time we are in executive session about being very mindful of the information we're releasing. Because I want to maintain attorney-client privilege. I want to make sure that we're adhering to those rules. And so without giving, and maybe we can talk offline about your specific concern, but I would say definitively on the record, I want to maintain privilege. Definitively on the record, I don't want to waive that. I want to make sure that all the board understands those obligations and is in lockstep on that, even though we don't agree on everything.
Yeah, I 100% agree. I think the board should have a discussion about that to make that determination of whether they would like to waive executive privilege or the attorney-client privilege. I haven't seen that of this board so far. Maybe that's something that we could change in policy.
Potentially, or maybe I need to know what circumstances we're talking about, because I'm not aware, and I would say that I would want to be involved in those conversations about when we're releasing privileged information.
I mean, I can give you examples. Every single time anything's been in executive session that's been brought out of executive session and put onto our docket to be able to be discussed. It has never been discussed amongst our board to make that decision to pull it out of executive session. I've never been involved in that conversation. I don't know if Director Song has had that experience. I don't know.
Oh, was that a question for me?
Have you had an experience where the board discussed something that was done in executive session and decided to pull it out of executive session?
I can't recall in this moment now. But I do have a comment. I think this is a good segue if we can skip to the executive session.
Yeah, let me, and I appreciate it, Director Song. We are running short on time. I'm going to hit some highlights, okay?
Okay.
I do want to just talk about final action, and this talks a little bit to the idea that when we are making a final decision, that actual decision by actual vote of the majority of the board members has to be done in open session. And that means we can't, in an executive session, pull the board and say, hey, which way are you leaning? Let's do a little, tally just to see which way we're leaning to extend the contract or whatever the item might be. Secret ballot, we can do the discussion in executive session, but the action must happen in open session. And those are circumstances where a protected item would be advanced to open session for voting, and it doesn't waive privilege. That's an example. Okay, so I'm going to skip over the cases. We talked about communication protocols, just really quickly about travel and gathering. When you are at a WASDA conference and you're all there, you can be together and you can be at high school graduation, but just be mindful that you can't take action, and we have to be very careful about discussions, deliberations, because that can be considered action. And in certain circumstances, we'll announce it as a public meeting just to be safe, but even then, I do not like the appearance of us being in a meeting, even at a social gathering, and having 3 or more board members in a corner talking. It doesn't look right, and I want to be careful. So even when we are traveling, even when we're at a meeting, I want to be careful about that because of the perception of what it looks like, okay? But certainly, yep.
Just to clarify,
President Margell.
last year's WASDA meeting, we all had a nice dinner one night after one of it. We talked about kids, food we like,
You're fine.
vacations. I can't remember all the topics, but these were the highlights.
So you need to be mindful that if you're going beyond kids and vacations and you're starting to talk about, hey, what do you think about, even the levy and things like that that would potentially be appropriate for public session, you need to stop. Okay? And that's just, I know you can have that line there of, someone needs to call and say we're getting too close to that line. Director Song, what number were you on when you looked at, can you look at the number at the very bottom of the individual slide?
Slide 20, page 10.
All right, we're getting there. All right, so we're going to skip a little bit. This is in regards to 24-hour notification requirements. The only thing I'll say about special meetings is we can modify the agenda on regular meetings. We can't on special meetings, and so that's just something to be aware of. So when we have a special meeting, we can't modify that agenda because of the notice requirement. If it's a regular meeting, we can. We can modify the agenda. Yes.
One question on that, if we had an emergency situation, say while we're already meeting and something were to happen, I assume that we could add it at that point, no? There
is an emergency special meeting, which is another category where it's injury or damage to personal property. Time constraints could lead to injury or damage to personal property. Statutorily, it does not include response to a teacher strike. That needs to be appropriately done. But there are certain circumstances like a natural disaster or something else that could trigger this. Okay?
Or the stuff going on in Highline right now.
Yes, potentially. I'm not their attorney. I don't know if that would, but it potentially would be on the radar. All right, Director Song, executive sessions. These are mentioned in statute. This is different than the exempt session that we talked about earlier. We have a checklist of things that would be potentially executive session. I'm going to give you that list here. It has to be announced. The board has to go into open session, convene, and then go into executive session. There are a couple of questions that have come up about this that I want to be very clear on because there have been some really interesting questions like, what if we end early? What do we do? Can we just go home? I want us to be able to, I don't want members of the public to be waiting around, come back, and then see we're all gone. Okay, so I really want, to the best of our ability, to stick to the timelines that we're publishing. A lot of districts and boards do it differently. Sometimes it means we just keep extending If we're going to go longer, then we extend, rather than doing it the other way where we're done, we have 45 minutes to kill, and we don't have anything to do. I would rather err on the side of being more conservative and then extending it and coming out into open session saying we're going to extend for another half hour, rather than being done early and then going home. Because of the perception that well, where did everybody go? Did they meet without us? What happened? Okay?
Could we not change our, because we don't have to have executive session in the middle like we do, right? We could have executive session at the end so that there wouldn't be that problem of us running against a clock issue, right? Like we are right now.
I will defer to the board and the district as to how to do it. Generally, that's usually staff usually figure out how to do it. There are many, many ways to do it. Boards do it different ways.
I was just wondering if that's if we had to do
I
it in a
will state,
particular
though,
way.
having an executive session after a board meeting means you might be in executive session at 10:30, 11 o'clock at night, and a lot of times we try to be efficient and do those earlier, and I certainly can support that. All right, the purpose and the time it ends must be announced before exclusion or before the start of the meeting. You can extend with further announcement. You cannot end early and go back into session early. You really need to be careful about that because of that reconvening and then adjourning the meeting. That's actually considered action, and you're taking action in open session.
And that requires like a quorum or whatever to be able
To
to
go
take us
out
out
and,
of
yes,
it.
exactly. So these are the justifications and reasons for an executive session, and these are all straight from statute. The ones we probably look at most, qualifications for public employment or review the performance of a public employee. Again, that final action has to be done in open session. Usually that's done on a consent agenda or a personnel report. Also, we have two real estate items, offering price for sale of real estate or considering the site or selection or acquisition of real estate are ones that we at times see. And then the last one is to discuss with legal counsel potential litigation. And potential litigation just doesn't mean it could result. It needs to be either specifically threatened, reasonably believed that could be commenced, and or public knowledge regarding discussion may result in adverse legal consequences. In this circumstance, you must have legal counsel present. There is no catch-all, well, this could result in legal action, so we're going to be an exec sesh. No, you would have to have legal counsel there, and I would be advising you if this potentially could meet one of those three. Either specifically threatened, reasonable believed that may have been commenced, or the public knowledge could actually put the district in an adverse legal position.
So in that case, you're saying that the review of the performance of the public employee, the actual final action of providing the review and being done with it still has to be done in open session. Is that right?
Okay, so the evaluation itself, when there's action associated with it, there's a case, an OPMA case actually, in which, so the extension of the superintendent's contract has to be done in open session. The performance evaluation itself doesn't, you don't have to say we're giving him does not meet in open session. That doesn't have to be announced. That's still protected under the protections of an executive session. So whatever the final summative rating is and stating what it is. And this interesting case stood for the proposition, and I have it here somewhere, but I probably skipped it, is the superintendent's contract had an automatic provision that stated if he exceeds expectations in certain categories, his contract is automatically extended. Okay? And that was problematic because what happened is the conversations appropriately about his rating were done in executive session, but what happened was that automatically renewed him in executive session. So if you can think about that division, the conversations about his rating, normally we don't have that in any staff member's evaluation now, so there's no problem here in Kent. But if you look at that dividing line, it's the conversations about the rating, the conversations about the public employee and their performance, the finalizing of the evaluation would be done in executive session. The extension of the contract would be done in open session. The termination of an employee, open session, on the personnel report. The circumstances that gave rise to it, the investigatory materials, the deliberations, executive session. The final action on the board report, on the personnel agenda, open session.
And there is no, that one's louder. There is no vote in the executive session to get it out of executive session onto, it just, if it's the matter of course of what it should be in open session, it just goes there.
It just goes, correct. There are mechanisms in place in which that happens.
I think that answers one of your earlier questions.
Not really, but thank you.
Okay.
I
We'll
have a
try again later.
verbiage question. So number 5, no, that's my number 5. To discuss legal counsel litigation or potential litigation. In healthcare, we have terms that kind of have rough numbers associated with it. So when we say potential, who makes that discretion and what's the definition of potential?
So another great question. I would be looking at specifically threatened would be one area. If I've received an email from an attorney or someone that is threatening legal action against the district, for sure, that checks the box for me. Okay, and in most cases, it's likely going to be that because the matter has been specifically threatened. Number 2 would be reasonably believes to have commenced or, could commence. They're potentially going to appeal an adverse decision, something like that. It's not theoretical. It's not just the idea that if we took this action, it could result in litigation. For example, we're having a conversation about the appropriateness of certain helmets to be worn and protection of helmets on, I theoretically could say this could result in litigation if it's wrong, right? But I would say that that isn't specifically threatened or reasonably believed to have commenced. And so a lot of those conversations about liability just generally, I would say would not be right for an executive session generally.
Okay.
Does that make sense?
Yeah, but
Liability
who
generally-
makes that determination?
Well, I would say if I'm being invited to participate in an executive session related to legal counsel, I, as board counsel, would be advising to make sure we're not violating the rules of this. And I would not be involved in a conversation in which I'm going to be in an executive session in which litigation hasn't been threatened. And usually that would come through me if there are emails or threats, demand letters from an attorney, that's automatically going to put it on the list. There is a little bit of a crossover of evaluation of public or complaints against a public employee. A lot of times it would likely defer to one of those categories, especially if it's the performance of an employee or if they've done something wrong. It's probably going to be categories 3 or 4.
Okay. I think my main confusion is just that last bullet point, public knowledge regarding discussion may result in adverse legal consequence. Can you just give me an example of what that would look like?
Maybe the discussion of property for purchase, and that if we said that we're going to bid 100,000 on something and people knew it was going to be 100,000, then other people could come in and ask for higher amounts. So like the discussion of, is that?
Yeah, I mean, certainly category 1 would also apply to that last bullet point. I've not used that 3rd bullet point as much as a justification for an executive session. I would tell you generally, if I'm providing advice that's attorney-client privilege information, if it were waived and it puts the district in a bad legal position, but I struggle to know exactly what situation I would be exercising bullet point 3. It's generally going to be really 1, where there's a threat
like a
of legal
specific
action.
threat that was made.
Yeah, I would be very, very careful about relying on number 3. I would want there to be an actual threat or something that potentially could come.
So how do we meet about something that we think would qualify for that without talking about it in public? Would that be like president and you? or-
Generally, legal matters come to the board through either legal counsel or through staff. And so a threat or a claim or a tort claim or an issue is brought to staff members via email. That's then brought to me as the attorney, and I say, you know what, this is specifically threatened, let's get the board involved. That is the limiting factor. Generally, we're not just bringing anything that potentially could be legal in nature just because it's legal in nature. I would say 95% of the time it's specifically threatened. There has been a threat, a tort claim, attorney has been retained, and there is an actual potential issue. But it's a great
Thank you.
question. We are at time. Your materials are here. If you need reading materials later on tonight, they are here for you and you can read them later. And certainly I can be available to answer any questions that you potentially have about any of this material or any other questions you might have. Of course, we want to make sure we do that appropriately, either in an executive session or an open session, but I can be available one-on-one as well. And that concludes my remarks.
It is 5:59, and we are adjourning this work session. The work session is adjourned for an executive session for 30 minutes. The purpose of the executive session is to discuss the performance of a public employee, potential litigation, or the legal or financial risks of a course of action. It is 6:31, and we are calling this regular meeting to order. Our executive session adjourned at 6:29. First order of business for our regular meeting is we're going to have a roll call of our board members. At this time, I will say your name. If you are present, please indicate so by saying present. Director Song,
Present?
Director Cook,
Present.
Director Clark,
Present.
Vice President Farah, who is attending virtually,
Present.
and then
Can you guys hear me?
We can. Thank you.
Yes. Thank you.
If you could just be cognizant, though, of background noise and mute yourself when appropriate to just keep that clear. And Director Clark, would you say the Pledge of Allegiance for us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening. This is a meeting of the Kent School District Board, which is held in public to comply with the Open Public Meetings Act. We welcome the public's participation in the board meeting and thank those of you who have come to this meeting and those who are viewing our live stream. The purpose of the board meeting is for the board to conduct its business in public. During the meeting, the board will listen to, but not respond to, comments from visitors. Whether made verbally in person, verbally on video, or written, comments are limited to a total of one per person. One per person per regular board meeting. One additional comment per person may be submitted for a public hearing topic if there's a public hearing on the agenda. All forms of public comment are subject to Chapter 4256 RCW Public Records Act. The public may comment at regular board meetings in a manner authorized by state law. All comments must adhere to Policy 1420 and Procedure 1420P. If you wish to make a comment to the board, comment forms are available for completion prior to the meeting and must be turned in no later than the beginning of the legislative report. No forms will be accepted once this report has begun. Comments are limited to 3 minutes. Public comments will be heard after the opening, during preliminary communication from the audience, at specific agenda items, and during final communication from the audience. Students will be the first to speak on any topic. Please state your first and last name prior to the beginning of your testimony. Abuse of public comments personally directed towards the board, staff, or students will not be tolerated. The use of specific names or personally identifiable information of board, staff, or students is not allowed. Board members or KSD staff members may interrupt or terminate an individual statement when not adhering to Procedure 1420P. All comments, whether verbal or written, must adhere to the standards of civility as defined in Policy 1400, Meeting Conduct, Order of Business, and Quorum. If you're seated in overflow room, there is a brief delay in the live stream audio. We will allow extra time for you to make your way to the boardroom after your name is called. Individuals with items for the board or superintendent must provide them directly to safety services staff. Approaching the dais during the board meeting is not allowed. Any items turned in will be provided to the board and superintendent following the meeting. Director Cook, will you please read our land acknowledgement?
Yes. We acknowledge we are gathered upon the ancestral lands of the Muckleshoot Indian tribe, who historically lived throughout the area between the Cascade Mountains and Puget Sound.
Thank you very much. We now move on to agenda review. Superintendent Vela, are there any changes to the agenda?
President Margell, there are no changes to the agenda.
Great. Is there a motion from the board?
Move to approve the agenda.
Second?
A motion has been made and seconded. We are now open for discussion. Seeing as none, we will move to vote on the motion to accept the agenda as presented. All those in favor, please raise your right hand and say aye.
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 The motion passes 5-0. Oh, I'm sorry. I thought I saw a hand. My apology. Okay. We're going to redo that vote. All those in favor
Can we
of,
do a roll call vote on this one?
on the agenda?
Yes, please.
We are now voting on the agendas presented. Director Song,
Aye.
Director Cook,
Nay.
Director Clark,
Aye.
Vice President Farah,
Aye.
and I vote aye. The motion passes 4-1. We now move on to Section 2.0, our proclamation of National Hispanic Heritage Month. Director Clark, would you like to read that for us, please?
Whereas September 15th through October 15th is celebrated throughout the United States as National Hispanic Heritage Month, providing an opportunity to honor the contributions of Hispanic students and leaders of the Kent School District in our community. And whereas this year's theme, Pioneers of Change, Shaping the Future Together, encourages to ensure all voices are represented and welcomed to help build stronger communities and a stronger nation. Whereas in the Kent School District, the Hispanic community now constitutes 23.5% of the district student population, with more than 5,900 students identifying as Hispanic. And whereas the Kent School District is committed to the promise that regardless of where students come from or what they look like, all are afforded an equal opportunity to graduate from the Kent School District as young adults who are globally competitive learners prepared to excel in college careers and in life. And whereas the Kent School District is dedicated to working together to address the challenges still facing Hispanic students in equity and access so they may prosper in school in King County, in Washington State, and around the world. Now therefore be it resolved, the Kent School District Board of Directors recognizes September 15th through October 15th, 2024 as National Hispanic Heritage Month, with the intention that Hispanic heritage be recognized, discussed, and celebrated in Kent School District schools and classrooms during that time.
Thank you very much, Director Clark. Our next section is our Proclamation 2.02, September Attendance Awareness Month. Director Song, would you like to read that for us?
Sure. This is for the Kent School District Proclamation, September Attendance Awareness Month. Whereas good attendance is essential to student achievement in high school graduation, and we are committed to reducing chronic absenteeism rates with a focus starting as early as pre-kindergarten. And whereas chronic absence, missing 10% or more of the school for any reason, including excused and unexcused absences or just 2 or 3 days a month, is a proven predictor of academic struggle and dropout rate. Whereas improving attendance and reducing chronic absence takes commitments, collaboration, and tailored approaches to particular challenges and strength in each community. And whereas research shows that chronic absence as early as pre-kindergarten and kindergarten is associated with lower third grade reading scores, 6th grade course failure, and an increased dropout rate for 9th graders. Whereas chronic absence can be significantly reduced when schools, parents, and communities work together to monitor and promote good attendance and address hurdles that keep children from getting to school. Now, therefore, be it resolved, the Kent School District Board of Directors proclaims that our schools will stand with the nation in recognizing September as Attendance Awareness Month, where hereby commit to high student achievement and reducing chronic absenteeism to give all children an equitable opportunity to learn, grow, and thrive academically, emotionally, and socially. Signed this 11th day of September 2024, Board of Directors, and Secretary to the Board, Superintendent Israel Vela.
Thank you very much. Two very important proclamations. We now move on to Section 3.0, and this is our preliminary public comments.
Ms. Antello.
Thank you for your patience. Good evening, President Margell, members of the board, and Superintendent Vela and Ms. Curry. We have a number of comments received this evening. I'll begin with what was received online. We had 3 video comments submitted for item 6.02. We had 5 written comments submitted for item 6.02. Those were provided to you today in SharePoint, in addition to hard copy there with you at the dais, both video and written. Tonight, In person, we have comments for the preliminary 30-minute section. We'll begin with a student comment. We have a topic for 5.01, a comment for 5.01, and a number of comments for 6.02 in person. I'll provide those to you at this time.
Thank you. Ricardo, it's an R or P. Panata? I'm sorry if it's hard, we have those little teeny pencils. Yeah. Thank you very much.
Good to see you, board, once again. My name is Ricardo Peñamolin. I am here to speak on behalf of how well the board has done. The board specifically has done an amazing job in getting student engagement. For also, I've noticed a big difference in how the community goes beyond and supports the district. In my experience back in Federway, it was way different and it wasn't as engaged as Kent. And what I've noticed is that you guys really prioritize how students go beyond communities and support us in our events or how we go to sports or things like that in general. And I appreciate that. That has been an amazing thing that you guys have done for us as students. And I wish you guys would continue more of that, of community engagement. Thank you.
Thank you very much. Layla Jones?
All right, good evening, President Margell, members of the board, Superintendent Vela. My name is Layla Jones. I am the current Vice President of the Kent Education Association, and I'm here just as to raise concerns that our educators have, that our community members have, our families around staffing this current school year. Currently, we are in the process of an IVT, which is never fun. It's always a huge impact to the educators and the students in those classrooms that have to be displaced or reshuffled. Right now in our elementaries, many of our schools are staffed to hard cap. Grades have had to be closed down already. More so concerning than the hard caps is the amount of split classes we have, particularly the ones that go from primary to intermediate. The skills in primary are unique to primary, including teaching phonics and reading, and when we go and combine that with intermediate students, that makes it infinitely harder to do those things well. It is concerning that there are those many splits this current school year. It's not only limited to the elementary schools here in our district, it's also our secondaries. We're seeing massive overloads in our middles and our high schools as well. These are extremely concerning to us because we know that many of our members and our educators are going to be asked to take 0.2 contracts, which means they lose planning. And that is not good for their mental health, their ability to, be able to manage their class sizes and class load throughout the day, but also it's not good for kids. So I would be remiss if I didn't say that none of these solutions are good for kids, and much of this is avoidable. And I know there's maybe going to be some glad handing happening here a little bit later this evening, but I just want the board to be aware of how our buildings are feeling the stress of some decisions that might be made here at the district office. That's all.
Thank you, Layla. Again, thank you. We have no response to our comments, unfortunately, based off of our district policies. Adriana Gonzalez? Adriana?
Hi, I'm representing a student that couldn't be here, and I'm just reading their letter to the board. As a student, I want to sincerely thank our superintendent for steadfast support of our programs like Central Rendu and the high school's mentoring program. These initiatives have greatly improved my focus and made school more enjoyable for me. My mentor has played a crucial role in helping me communicate better with my parents and offering guidance during tough times that my peers might not understand. The partnership between my teachers, counselors, and mentors and parents has given me a bright outlook on my future. Thank you.
Thank you very much. Maria Hernandez.
Good afternoon, members. My name is Maria, and I'm a youth navigator, and I am speaking today on behalf of a parent who couldn't meet here. I'll read it in Spanish, and she'll be translated in English. Hola, mi nombre es Alexandra Chávez. Soy padre de familia de uno de los estudiantes de la escuela de Kent Meridian. Escribo esta carta para dejarles saber que estoy muy agradecida por el programa que tienen para ayudar a los estudiantes con sus tareas y ayudarlos para que siempre estén al día con sus obligaciones y ser mejores en su rendimiento escolar. El programa siento que nos ayuda e incluso a nosotros como padres para estar más informados de lo que están haciendo nuestros jóvenes en las instituciones.
Hi, my name is Alejandra Chavez. I'm parent of one of the students at the Kent Meridian High School. I wrote this note to let you know that I am so thankful for the program that you have for the students. It helps the students with their homework. They help them always to be up to date with their obligations and be better and with their scholarship programs. I feel that including us, we have well informed of the what our youth are doing in schools.
Thank you. Ned Delmore.
Good evening, board members. My name is Ned Delmore. I'm a senior advisor at St. Vincent de Paul, and I'm grateful to be here to say a few words in support of our school superintendent. I met him 11 years ago when he was the assistant superintendent and I was the executive director of St. Vincent de Paul. From the onset of our contact, he listened patiently, asking questions about St. Vincent de Paul's mission, how we do our work with vulnerable families and youth throughout the Kent community and beyond. He wanted to know about our community outreach through our home visits, and he wanted to learn about our youth programs at Central Rendu that centered on our Spanish-speaking neighbors and families. He was serious and passionate when he spoke of the students and families of the Kent School District and was looking for ways to collaborate. I did not know him at all, but I could sense his desire to learn about the work of our community organizations. He was curious and inquisitive about improving the lives of his students and families in the district. I mentioned a bit about my work history as a juvenile court administrator and working for a board of Superior Court judges, all elected officials. I remember telling him then that in the eyes of the judges, there was no substitution for stable leadership. Our superintendent has teamed with board members as well as receiving community input to create a new strategic plan that supports students and families for years to come. This is stable, forward-thinking leadership. When you take a deeper look at our superintendent, the city of Kent is his home, this is his community, and these are his students, families, and staff. This is where his heart resides and belongs. These are some of the values that I have personally witnessed as the leader of our Kent School District and broader community. These are the same values that I believe this board possesses. The Kent School District is in good, stable hands with our present superintendent. Thank you for listening to me.
Thank you very much. The next speaker that I have is Mira Roach.
Good evening. My name is Maria Roach, and today I am speaking as a community leader, a City of Kent resident, and a parent of a Kent School District alumni. We all know the effects of the pandemic, which hit hard our communities. Parents, community leaders, public servants, like our board members here today, as well as Kent School District leadership and staff, have worked tirelessly, recognizing that we cannot do this important work of educating our children alone. It takes all of us working together and creating new partnerships to rebuild our communities and lift the future opportunities of our children. We all agree that our children are our future, and that it does not matter what language they speak when they come through our doors. They are all equal in dignity and deserve the best opportunities to excel and to thrive in school and life. Our children are an extension of their families and communities in which they work, play, and serve. Under the guidance of our superintendent, Kent School District staff, and this board, our school district has become a leader in this work. As a parent of a Kent School District alumni, I have seen, lived, and experienced this firsthand and can testify to this truth. In many ways, I am here today to say thank you. Thank you for trusting us parents. Thank you for believing that our community-based organizations are here as partners in this daunting task of raising our kids in a post-pandemic, diverse world we're blessed to be a part of. And thank you for working together to put forth a strategic plan that recognizes the importance and value of community partnerships to achieve our shared mission of educating our children and supporting their families. In a global economy, we do well to welcome, educate, and partner with each other to support every student's success. As the old adage goes, it takes a village to raise a child. Well, the village is well represented tonight. It is all of us here tonight, working in harmony with a common purpose and goal. I commend this board and our school superintendent for working tirelessly to ensure our shared Kent Village is strong for our children. Thank you.
Thank you. I'm sorry, I'm pausing right now because I do believe that we just got some additional, and I was wondering if there's student comments, and if we could put them now since we still have 16 minutes of time for our students for preliminary. Okay. Darius Kalani Taylor.
Yeah. Good evening, school board. My name is Darius Kalani Taylor.
My name is Cooper Carter.
And we are seniors at Kentwood High School. We just wanted to bring up an issue that has been happening to us and our friends at the school for all 4 years that we've been there. During lunches, especially, we face a lot of harassment. We think it's, because we're queer. Yeah, we're queer. we face verbal abuse and we get things thrown at us. And I think that tolerance is something that needs to be more stressed at home and in the classrooms, because this is a big issue and it's something that could be easily solved. That'll be all. Thank you.
Thank you very much for your comment. We now move on to, that was the, let me just explain. That was the conclusion of the comments for our general at the beginning. There is time and there are several comments that are coming before specific agenda items. We now move on to section 4.01, the superintendent report, and I call on Superintendent Vela.
Thank you, President Margell. In my opening comments today, I just wanted to share that I have a couple of shout outs or recognitions across our district. I also have a tribute that I'd like to share tonight in light of this day, this important day. So first of all, I want to start with, I cannot believe it's been 10 days, 2 weeks since the start of school. Lots has been happening throughout the school district, but most importantly in our classrooms every day. One of the focus areas that we've looked at over the years is attendance, and today Director Song read a proclamation that's very critical to the success of our students. And I just wanted to share a few of those proven research areas that actually speak to consistent and high attendance. The first is it is a powerful indicator of academic success, as I mentioned earlier. Secondly, it is also important in the social-emotional and cognitive development of students as they continue to receive interactions daily, consistently. And finally, the key piece to attendance really is those relationships that they build with adults, not only the friendships that they make, but the adults that they have to be able to connect with on a regular basis. So I wanted to share that and thank Director Song for that proclamation and our board. The other piece I wanted to remind folks about is that this fall, or this in autumn, it is unfortunately a time when colds, flu, and those kinds of things start to approach, and that it directly impacts attendance. And so just want to remind us all that to remember to make sure everyone washes hands, gets adequate sleep at night, et cetera, for students. And if they're feeling sick, that they are taken care of at home, and make sure that we help with the recovery as much as possible. But just a reminder there. The other recognition piece really is the teams that I recognized a couple weeks ago in my report, and that was our teams that are touching in every way, shape, or form the accurate count of our enrollment. That continues today, and we're not new. This is not new for districts. All districts around us that are facing either declining enrollment or increased enrollment, whichever that may be, they're in that same process. They're making sure that they are utilizing their systems to be able to help them with that accuracy. And a shout out goes out to our neighboring school district who is dealing with that right now, and we wish them well in what they're doing, because it's very important. The other shout out I wanted to make was really to our Kent Educators of Color Network. I wanted to thank you for hosting an ice cream social last week. Even though I was not able to attend, I did hear from my staff who was able to attend. It was they expressed enthusiasm about the relationships that either that they had already made and were continuing to build upon, but really those new relationships that they were able to make. And they look forward to continuing to do that in the future. So thank you for hosting and the invite. We look forward to even more. I also wanted to thank Director Cook for also attending. I understand that you were there, so thank you for attending as well. The other piece I wanted to share tonight is really our core business. And our core business is about students. And students is about the success of students. And a shout out to several schools that I'm going to be mentioning here shortly. But I wanted to give you an idea of kind of our state system, which is called the Washington School Recognition Program. It honors K-12 public schools across the state that are either closing the achievement gap or showing growth for specific students or student groups. And that's over a period of 2 years. And so I wanted to share that as a context and give this recognition to the following schools, which we received this summer. Grass Lake, Jenkins Creek, Lake Youngs, Daniel Elementary, Kent Elementary, Kent Laboratory Academy, Neely O'Brien, and Ridgewood Elementary. Again, over a 2-year period, showing growth in a variety of areas, whether it be a student or student growth, or at the school across the whole system. And so I wanted to make sure that I was staying true to our focus, which I've shared before, moving from the boardroom to the classroom and the things that happen in the classroom every day for our students. So thank you to all of our teachers, all of our support staff, all of our operational staff who made that happen. The other piece that I wanted to do, as I mentioned earlier in my opening comments, is give a tribute to Patriot Day. The significance of 9/11 has not left us, although it is not a legal holiday. I'd be remiss if I didn't point that out to us, as always, and make sure that we remember the legacy of those lives that were lost on September 11th, 2001. And we continue to come together in collaboration through the acts of kindness and service in their memory. So please join me in a brief moment of silence. Thank you. And that concludes my report.
Thank you very much, Superintendent Vela. We are now about to move into our legislative update. I just like to give this announcement because it's also our last opportunity for people to turn in any comments. If you did want to put in a comment card, they would go right into the blue bucket in front of Ms. Zentello on the back table over there. With that being said, we are moving on to section 5.0, legislative update. And Director Clark, could you please?
Yeah, I'm just trying to build the big picture. We are about to enter, as Washington State School Directors Association, an approval of a package of what we want to take before the state legislature. But I wanted to take an outside source, the Seattle Times and their editorial board, and forgive me, there's a lapse here. What I'm going to read to you from here was actually in print last fall. So there's a time delay, but there's a connection. It talks about the McCleary fix. And the McCleary fix was school districts came and got tired of the lack of fairness and distribution of wealth and how schools are run. And they sued the state. And the state, in fact, acknowledged that they had a problem. And so they made a pledge to try and go forward, and for a brief period of time did shove a significant amount of money trying to address that, but then things fell apart. 6 years after the legislature's McCleary fix to right-size education funding, many Washington students continue to languish academically, and high poverty districts receive about $880 less per pupil than more affluent areas. That is far from the spirit of the McCleary lawsuit settlement. Part of the problem comes from the unusual way Washington channels monies to schools, tying dollars to enrollment rather than the cost of specific student needs. The latter is how most states dole out education funds. To be sure, many schools made great strides under McCleary, at least financially. In 2008, after the class action lawsuit was filed, Washington ranked 42nd out of 50 states for the amount it spent on education. By 2020, after the legislature poured $7 billion into schools, Washington has raised its rank to 19th, just a hair above the midpoint, but an indicator of how far we've been lagging behind. All right, this is from August 12th of this year, and it's the editorial board speaking about the race for superintendent of public instruction for the state. And in it, in demographics alone, Washington's K through 12 schools have changed radically. The portion of low-income students has increased by 35%. Teachers are educating children who speak 242 foreign languages at home, nearly 50 more than in 2007. We're using an outdated prototypical school funding model to try and take care of kids in 2024. They just don't match up, said one superintendent. It's like trying to use a geometry equation to solve a calculus problem. Said another, what used to work isn't working any longer, structurally, behaviorally, and academically. Reichdahl was the state legislature when the prototypical schools model was initiated in the 2011-2012 school year, and he has been reluctant to tinker with it. He is also an ardent supporter of its mechanism for driving extra money towards districts where the cost of living is higher. And then just for one more backdrop on this. You are facing on your ballot, I believe it's Initiative 2117, which would repeal the capital gains tax. That actually was passed a year and a half ago, and it created a pool of money which was being collected, of which the K through 12 school system would have been a major beneficiary. So you can see what the state legislature was saying. We know we're not where we need to be, but we have to have the funding. We got a mechanism and we're pooling it, and hopefully this would go forward. But of course, if the voters vote that down, that goes away. So just trying to tie this all for you. Thank you.
Regarding the legislative agenda from our government in Washington State. What were your thoughts on the Washington State Innovates program that they're working on? Chris Reichdahl spoke about it a bit recently. I was just wondering what your thoughts were on it.
Well, if my understanding is correct, that's a specific program that aims at very specific projects within certain school districts, so it's not universal. Clearly, there has been all kinds of wandering. I hate to even bring up the topic of charter schools, but that was one of the original ideas behind charter schools, was to actually create innovative programs that didn't have to strictly fulfill what the rest of the school districts were doing. So I don't have great detail on that beyond that.
Oh, I guess I was talking about what they were actually talking about. What I saw here was equitable access to strong foundations. Did you not see that part in the legislative work that you've been doing?
Well, first of all, the prototypical school model was intended to basically bring an equitable system to try and build a structure that would allow all kids a reasonable, well-rounded education, just like our goals are stated. But equity, unfortunately, doesn't come out the way we currently do it, because you still find yourself relying on levies and bonds. And I'll use bonds as an example because this is real simple. If your White River School District, very close to us, they don't have the taxable property. And so what it would cost the homeowner to just deal with the rise in property taxes to match the matching fund coming from the state building fund is catastrophic. And so they have to find other approaches to try and deal with that. Well, that's not fair and equitable. So it's a huge, complex system, And there are all kinds of fixes that we have to work on.
Okay, I guess I was just referring to the program that they're looking at, the Strong Foundations, which is for our youngest learners. It's impacting the pre-K kids and how we don't provide enough support to the teacher's residency in Washington State, and how we can try to improve that. Improving equity, like you were saying, but in specific, talking about the Strong Foundations initiative, which is, of course, speaking to the pre-kindergarten programs that we have. And I was just wondering, like, what your thoughts were on that whole program, what they're doing, and how they're making progress.
Well, very clearly within this school district, the program in the preschool has worked very well. That's measurable, and we can see that. In one of the WASDA proposals is universal preschool. But again, that's a money-laden problem. And of course, it's exacerbated by the size of the school district. Clearly, with 295 school districts, you literally have a school district that only has 8 kids in it. Well, I'm fill in the blank from there.
So
it sounds like this is actually a topic that there's maybe some detail on it, and I love that the enthusiasm around it. Maybe we give Director Clark the opportunity to maybe discuss it with you or look through it, and then we can bring it to our next legislative update.
I mean, that would be great. I guess I had assumed that he was in there, so he would have heard it. But I guess I'll speak to it a little bit since I'm actually reading up on it here. Well, I mean, this is discussion of that now.
We have public comments. This is not an area that has specific discussion. I just want to make sure that I'm following the agenda as given. And so, but we could have it during either your board report, unless I want to make sure I'm following with it, because I don't have discussion on this one.
Mr. Dillard?
Yeah, you are correct, President Margell. It'd be more appropriate in that section, and where there is public or where there is individual board comments. Certainly, you can have those comments there.
Yeah, sounds great. Thank you.
I think it sounds like an interesting topic. Thank you. We do have a public comment on this section. Phil Schley? Shaley, thank you.
Thank you. I'm Phil Shealy. I'm a Rotarian, a 30-year member of the PTA, which I dropped out of about 7 years ago. Ran the backpack program for 2 years by myself through the Rotary, and was the interact advisor for Kentwood and Matson. Missed 3 meetings out of the whole year, both schools. I have a simple little comment to make. Initiative 2081, the Parental Rights Initiative, which was supposed to be on the ballot on the 5th of November. The legislature went ahead and made it law June 5th. In the Seattle Times, there was an article that came out and said that the OSPI office had sent out a letter to all districts to ignore the law. I've been down here this summer, could not get an answer if the district was going to follow the law or not. I was given a phone number, called, and got no response. After sitting in here, I realized you're probably can't give me an answer either due to your restrictions. So the problem is, if there's a letter saying to ignore the law, and yet that there is a law, how do I find the answer to that? They won't give it to me in this building, and I know you won't give it to me here. How do I find the answer to something as simple? It's just, yes, we're following the law. No, we're following the letter. That's all I have.
Thank you, Mr. Schley.
Okay, and with that response, I'd like everyone to know, they're ignoring the law. They have to be, because they can't answer the question.
We now move on to section 6.0, discussion and approval. Is there a motion from the board?
I move approval.
I still didn't get an answer how I find out the answer, because they won't tell me in this building, and you won't tell me. I know I'm out of line. I don't give a shit.
I move approval of the Kent School Board 24-25 legislative priorities for Washington State School Directors Association General Assembly.
I second.
There's been a first and a second for item number 6.01, Kent School Board 2024-2025, legislative priorities for Washington State School Directors Association General Assembly. We are now open for discussion.
This was worked through in a special board meeting last week, and so we reviewed and discussed and were asked to prioritize, which we have done. So we're just formally approving what we've already done.
I guess so. For me, I just want to go ahead and read through them real quick, just because, you know, it's important that our public is aware of what we're discussing here. And obviously, many of you were not available to be at that meeting that we had previously. The items that we're talking about and that we're suggesting that we bring to the legislature for what we deem to be important and hopefully is following along with what our community wants. First is full funding for prototypical school models. We also would, number 2 being require simple majority. That's speaking to the bonds and passing them. So currently we have to have a supermajority, which means it's a very hard task for us to get to that point to be able to pass our bonds, which are the ways that we typically are able to replace buildings, to improve buildings, those sorts of things. 3 is universal preschool, which I think is great, and it's something that the legislature is already discussing, and I'm glad that we're making it a priority because I think it's very important. 4 is expanding basic education, which of course we want to do just to make sure that we're able to support our students across the board and make sure that we're holding them to a standard that improves over time so that our students are getting better over time and that we are making sure to improve ourselves in how we teach them as well. Number 5 is artificial intelligence. I think everyone kind of gets that one. It's a bit of a difficult thing that we are trying to navigate, but we'll get through it. Number 6 is accountability to the community. I think that one's very important. I think coming back to you in situations like this where we can provide the information that we had discussed in other meetings, that we make sure that the public is aware of all of this information. Number 7 is pedestrian and bicycle safety. That obviously we've had some really sad occurrences of, this one speaks a little bit to me. The community that my children went to school had multiple students get hit by cars. And it is terrifying, you know, to send your kids out and not know 100% that they're gonna be safe, right? We're all scared for that. And so we've had other things similar to that in other parts of the district as well. And it's something that I think we should try to work on. And, you know, getting funds from the state legislature can help with that. I don't know why, 7 has 3 because they were equally rated. The next one is student access to supports, activities, and services. That's another one that the legislature is also promoting. We also have number 9, I suppose, is school-based mental health. That's something that currently we have a lot of support through other agencies, which is really good, but we can do better. And so having that directly in the schools so that the students know exactly where to go when they need to get support for their mental health makes it much easier for them to understand what it is and also have the same person there. So that when they go in and they're seeing someone, that they can go back and know that they're gonna have that same relationship going forward. The next one there is special education, which of course speaks to many of us here, you know, being a disabled combat vet of the United States Air Force. I totally understand the bureaucracy and the difficulty that we have in how we're able to access the support structures that we need, and we need to do a better job. It should be coming from us. You know, the district should be reaching out to try and support those kids before they even know they need the support. At least that's my opinion, and hopefully we can work towards that. The next one is state funding for full breadth of co-curricular activities. That's why we don't have buses that take kids from sports or other extracurricular activities, is because we don't get funding for it. Currently, the state doesn't provide that funding. I think it's very important. I know when I was going to school, 30 years ago or so, we had some of that. We had some buses that could take us home, that we didn't have to worry about it. So, you know, it was far more equitable in that time. You know, it was different. Obviously, we have far larger breadth of things that we cover currently. The next one that we have on here is technology funding. That's why we're coming out to you in a levy, right? We're asking for money to help support the technology that we provide to our students, as well as our staff. And if we were able to get that paid for by the state, it would mean less that we have to ask of our communities here, and it would be a far more equitable system. The next one that we have here is the climate impact mitigation assistance. That's another priority that we have. You know, we all know that it's hotter here today, right? Being that I grew up in the area, when I was a kid, I don't remember seeing over 100 ever. I never even heard of it. I didn't know that it could get that hot when I was a kid. And to have something like 116 degrees in Covington, where I currently live, happen a few years ago, I mean, it's eye-opening. And it's something that we really do need to address, and it's way past due. And lastly, we have the 2-year budget to OSPI. This is a little bit more procedural. It allows us to help get OSPI to a state where we can bridge that gap. So we're not trying to do things each year and plan for the next. We can plan for 2 years and plan for the 2 years going forward. And that gives us a little bit more time so we can set our priorities and have bigger plans. So hopefully me providing this information is a little bit beneficial to you. I know a lot of times we provide this stuff and maybe you don't get a chance to read it. But I think it's really important that we know what our legislature is doing and how we can put pressure on our elected officials to pass the things that we think are important. And if you think it's important, if you think that we've come up with a wrong order in how we have listed these, let us know so that we can do what you want. You know, we are your employees. You hired us to run this district, and we want to see that you have whatever you find to be important. We want that information so that we can make better choices. That's all I have to say on the subject. Thank you.
Any other comments? Seeing none, we'll move to a vote. There's been a motion and it's been seconded for approval of item 6.01, Kent School Board 2024-25 Legislative Priorities for Washington State School Directors Association General Assembly. All those in favor, please raise your hand and say aye.
Aye. Aye.
The motion passes 5-0. Is there a motion on the floor?
I'd move approval of 602, the superintendent's contract.
Second.
A motion has been made and seconded, and we are now open for discussion on item 6.02, superintendent's contract.
Are we doing comments?
I do not see any students, so we will move into non-students. Our first comment is from Rose McAvoy.
Good evening, members of the board. My name is Rose McAvoy, and I have lived in Kent, been proud to say that I lived in Kent for the last 5 years. And 5 years ago, when my kids started school, I had a little bit of a bumpy start to the introduction because I barreled into the building on the first day and demanded to know why we had to spend $150 on school supplies to start our kids according to the list that went out. And over the next 4.5 years, I worked alongside, as a member of the PTA and as a member of the school community, I worked with all different people to create a closet of supplies that would be available to the teachers and for classroom use at the elementary school, which I'm very proud to say meant that this year, when students got their lists, they had significantly shorter lists. We worked together. We brought in what we needed to do. We had tremendous support from our community, and it was hopefully the first of many years going forward for a school that is not Title IX, is considered to be a more affluent school, but still has a significant number of families for whom it is a burden to purchase school supplies. All this to say, the teachers and the office administrators and the school administrators are amazing. We have had the most incredible experience so far. My oldest, this is my oldest baby. I brought my craft. He just started high school, he's a freshman. My baby just started middle school as a 6th grader. And talking to the staff at the beginning of the year and hearing them cheerfully say how hard they've been working to implement a new software system at the time of the year where they are the absolute busiest, I commend them. It's amazing. If you haven't sent them all donuts, you probably should. And the reason why I'm here and I'm speaking on this issue is as proud as I am to have my kids spend their days in these schools with these teachers and these staffs, I am not proud of the work that the district is doing at the administrative level. I am disappointed, at times disgusted. I'm a big fan of colorful language. I will not use it here, but I use it significantly in other places when talking about the district administration. I implore you to either delay or vote no on a contract approval tonight. I do not believe that our current superintendent is the right person to continue to lead this district. I absolutely believe that you will continue to have no votes from people who never in a million years thought they would vote no on a levy or a bond, who do it with bile in their mouth. But they do it because it seems to be the only way that we as a community can communicate to all of you our frustration and our disgust.
I do remind the audience that I know it was hard last one,
Megan, you need
to
to
not
be,
have a comment.
Megan, you need to make sure to be even keeled on that. There was a student that made a comment, there was a lot of clapping, and saying it for one person and not the other is not really fair.
I do, and I would say if I do have a bias towards supporting our students, I could up here and speak. Yes, I do encourage though for our adults, the expectation is that we keep comments or applause or boos, whatever that it may be, out of the room, please. Greta Nelson.
Good evening, board members and superintendent. I am Greta Nelson. I am here tonight to speak on this contract addendum to highlight that this seeks to inhibit or prevent individual board members from petitioning the government for the redress of grievances. It removes power from the board regarding its one employee. It transfers that power to the superintendent. A board cannot contract around the First Amendment rights of individual board members and the legal rights of individuals regarding actions taken or made by the superintendent or by a majority of its board that could be in dispute in the future. The addendum doesn't clarify calendar days versus business days. If the addendum is approved and there is a future dispute in which the superintendent would invoke the dispute resolution clause, the board and superintendent would have 5 days to agree to a mediator and 1 week after that to schedule 1 full business day of mediation. If the notice is provided on a Friday, there would only be 3 business days of the following week to jointly agree on a preferred mediator and/or to follow a strike list process. I work in the legal industry, and there is no way that a preferred mediator agreed to between the parties would be available for a full day of mediation within 1 week from a joint decision on a mediator. In litigation, preferred mediators or agreed mediators are typically booked out several months in advance. Having a precondition for mediation that doesn't occur for several months means that individual board members would have to waive any time-barred claims to meet that precondition. If this addendum is approved tonight, this is notice to those board members that would approve it that your individual vote and your inaction regarding a number of changes that need to be made to this addendum will be added as a charge in a petition for recall that is currently being drafted and will be filed with King County Elections in the coming weeks. This community objects to anything that would diminish the power of the board or cede that power to the superintendent by this contract addendum.
If my instructions were unclear, I'd be happy to have safety services reiterate them. Our next speaker is Erica Billiard.
Good evening. Good evening, KSD Board. My name is Erica Billiard. I'm a longtime volunteer and the mom to a 9th grader at KLA and a 2nd grader at Sue's Creek. Both are excellent schools with amazing staff who are extremely dedicated, and both are suffering from poor decisions by the superintendent and district level administrators. My 2nd grader, like many students in the district currently, is being shuffled around due to poor planning and understaffing. Both of my kids' schools are sharing one assistant principal, which is totally inappropriate and totally inadequate given the high needs at both of their schools, including the fact that KLA spans 3rd through 12th grade and has students who think differently and have a lot of social emotional needs. KSD has lost countless excellent administrators, teachers, and other staff due to a lack of support from the district. You guys just lost an excellent principal who was Sue's Creek's principal at Canyon Ridge. And that is a shame because he would have been an excellent superintendent one day. KSD leadership has set its schools up for failure instead of successfully preparing them for a great year ahead. And that is a shame because we could be a great district. I'd like to note that I'm here tonight on behalf of families, staff, and voters who can't make it or feel they can't speak out. In many cases, they feel speaking out is futile because the board has a long history of not listening and responding to their clearly voiced needs. We, as an enormous community, have told you time and time again that what the superintendent and his staff are doing isn't working for our students, staff, families, or community at large. It's pushed those of us who always vote yes on school funding to vote no and tell you we don't trust the KSD leadership or the board's oversight and guardianship of our taxpayer dollars. It is an awful position for all of us to be in. You have the ability to solve a lot of problems tonight with one simple vote by listening to the community and voting no on renewing the superintendent's contract. And I'm sure he'll be fine because you've already voted to have a great golden parachute for him. We are at a pivotal crossroads. You can keep doing the same thing that's not working over and over and send KSD into downward spiral, or you can start rebuilding trust with the community by voting no and find us a superintendent who will invest in KSD and effect real change. The community needs a no vote and a new superintendent as a show of good faith from you. Get us going in a new positive direction tonight and start KSD on the road to earning back trust and funding. Please do the right thing for all of your stakeholders by voting no on the contract renewal tonight. Thank you.
Our next speaker is Clara Lance.
Hello, board. My name is Carla Lance. I'm a community member, student parent, employee parent, and employee of the Kent School District. I would like to ask the board to not vote on extending the superintendent contract at this time. There is a levy ask on the November ballot. I believe the results of that vote should be considered prior to voting on a contract extension. My oldest daughter went through the Kent School District, and from the time she was in third grade, her goal was to be a teacher at the Kent School District. She started teaching in her first classroom at 19 years old. She has a master's degree, she's 23 years old. She is teaching at one of our schools in first grade, and she has 31 first graders in her classroom. Things need to change, and if we continue where we're going, this district can't sustain where we're at. Our teachers are burning out. We have young teachers that want to teach, but they don't want to teach in this environment. I implore that we at least table this until we see where the levy goes and then make a decision after we have more information. Thank you.
Thank you. Our next speaker is Valerie Hitch.
Hello, my name is Valerie Hitch. I am a KSD parent, PTA member, 16-year resident, taxpayer, and every election voter. In the last election, it sucked, but I voted no on funding the school levy. I'm here tonight to give you an opportunity to change my mind for the upcoming election. You can do that by voting no on the superintendent's contract amendment. When he was hired, this district needed dramatic improvement and change. Instead, we got a continuation of the administration's ways, lackluster performance, questionable financial decisions, combative and disrespectful communication in public forums, and ethical and legal code violations. Our unions have voted no confidence in him multiple times. In his report tonight, he chose to speak to how important it is to wash your hands to stay healthy, but he chose not to speak on the lockdown at Kent Ridge or the mental health impacts of lockdown events. He chose not to address the issue of classroom capacity, which has been brought up multiple times, or how that negatively impacts learning effectiveness. The lack of willingness to attack these tough issues is just one of the many reasons we cannot afford to continue with this administration. I'd also like to express specific concern over this dispute resolution wording in the amendment. The tone and necessity of this dispute resolution amendment is combative, not collaborative. It reduces your ability as a board to do your jobs. You should absolutely not be okay with this. He is your one employee, and you are our representatives. He works for us. We should not be beholden to new restrictions on how the board is allowed to dispute issues with their one employee. We can, and we must, do better for our kids, our staff, our community. So this is your chance to take a risk on change for the better, because the risks of staying the course are massive, including the taxpayers' willingness to fund this administration through levies and bonds, as you saw last time, and the time before that. Your decision tonight will make or break many people's decision on the November ballot. I strongly recommend you vote no.
Our next speaker is Steve Goliff.
Good evening. My name is Steve Golliff. I teach 5th grade at Jenkins Creek. This is my 6th year in the district. My kids both went through school all the way through Kent Ridge, graduated a few years ago. I want to take a little different angle on the contract situation this evening. I kind of frame it as a PR issue. And I want to go back to the last time we passed a levy, or did not pass a levy, I should say. The last time I spoke here was in February. We passed 1669. I told you we are probably going to get even fewer votes the next time around. And sure enough, we got 5% fewer yes votes the next time around. We had 1669. We had an additional $800,000 requested for the green building, which was denied. We have a green building, I think that's sitting empty, collecting dust. We have a lawsuit now. We have people trying to evade getting served. We've had KSD and KEA advocated for passing the levy, but then we also had 11 unions issue a vote of no confidence and ask people to resign. But then we had a guest speaker advocating for the spring levy by recommending that we cut back spending at Starbucks and Applebee's, and then we ended up with 43% voting yes. After that, we had a climate survey. We asked people, KSD asked people for emails to be part of a focus group. I don't know if anything's happened with that or not. I put my name in. I know other people that put their name in. I don't know if that's happening or not. And then at one of the last board meetings last year, we heard about listening sessions. Again, there was no plan presented at the time, but eventually some listening sessions got scheduled, even though there was virtually zero advertising for them. There was exactly one person that showed up to the first listening session. I'm gonna out myself now. At no time did any of the KSD reps suggest that they might change anything in the proposed levy, even though I tried to explain, here are some reasons people are voting no, but we got the same answers over and over that we've heard for the past year. So there doesn't seem to be any, it's hard to tell where the listening is. We keep hearing that we need flexibility in the levy dollars. Well, that's part of the problem, right? When we keep emphasizing we might spend the money a different way, that's half of the problem. At that listening session, I asked about the fields, how they were going to be paid for. I heard multiple different answers, and I'm still not sure how that works. The meeting was recorded, that listening session was recorded, and then it's nowhere to be found. You have to go out and search for it. It's not in the KSD website or anything. And that brings us to today, more PR with a contract that's neutering the board and taking away the board's job, basically. We had a 1669 that created a new board, and now we're having another contract that's going to apparently make it so we kind of don't have a board.
Okay, thank you. That's
So,
our time.
Thank you.
Brendan, crossover McGoy? McGay. Thank you.
Hey, President Margell, how many more comments do we have?
This is the last comment that I have on this item specifically. We do, I believe, have some online comments. There's 3 online comments.
Okay, thank you.
Hi.
Did you need a break after?
No,
Okay.
I was just curious.
Hi.
Yes.
My name's Brendan Crosser McGay. I'm here to speak about the contract extension of Superintendent Vela. I've listened to some good and kind of bad things being said. And I don't know him personally, so I would say that he probably has good qualities. I heard some people saying some good things about him, and so I would say that despite a lot of that stuff, I don't think that the qualities of him personally actually matter as much as what the community says. Like, if the community is saying they're struggling with, trusting and transparency and some of these other kind of issues that we've heard spoke today, and I've been in many of these meetings. We talk about it a lot. I hear it spoken about a lot, and I don't see any kind of hey, let's push back on what's happening there. I feel it's more like, let's just keep doing that. Let's just keep letting these issues kind of lie there and not address them. Let's not address the transparency issues, and I'm not going to go into the specifics of them, but and I don't think that stuff matters. I mean, the only thing that matters here is that we get the funding for the schools so that the kids have resources to have school, and I think that we're struggling with that, and our schools are going to struggle with that a lot more if we can't do everything we can to try and fix that. And I think that if Superintendent Vela's leadership has led us to the point where we are right now, hey, you know what? Why don't we try somebody else? See if somebody else out there that can, maybe help us bridge the gap between the community and, the school district, because it's been frayed, and I don't know why. I don't know why it's been frayed. I have my own ideas, but I mean, they're my own, and I don't want to disparage anybody, but I'm just saying that why don't we give somebody else a shot to see, hey, maybe they know something that he doesn't. Maybe there's some information or some ideas out there that we haven't tried. So I urge the board to not extend his contract and to consider that there are other avenues to maybe getting the funding for the district and getting the funds for our kids that we really need, because that's really all that matters. Does it matter if he's a great guy and is awesome to talk to and maybe does some really cool stuff for the school district? I mean, it's important, it's great, but if the community doesn't like that, you know, if they don't believe in his transparency, then none of the rest of this stuff matters. We don't have any funding, no school for kids. So
Thank you. I do believe that we have 3 online comments.
Ms. Santello?
President Margell, members of the board, Superintendent Vela, and Ms. Curry. There are 3 videos that were submitted for this topic. I'll play the first 2. The last one is in Spanish, and so I'll play it, and then I'll read the translation for you following.
After you start playing it, can you pause for just a second just to make sure that Vice President Farah can also hear it?
Vice President Farah, can you hear us?
I can hear you loud and clear.
Thank you.
Okay.
Can I make a point of privilege? I just know Director Song stepped away for a moment, and I was wondering, I also need to use the restroom, and so I was going to go as well, and it seems like I would really want to listen to what our community has to say. Is it right if we take a 5-minute break?
That'll be fine. Let's go ahead and break until 7:52.
Thank you.
My apologies for ending that robust conversation. We had a board meeting where a party came out in the middle of it. Okay, 7:52, and so we are resuming. We have 3 online comments. Director Farah, please let us know if you don't hear once we start them.
I will.
Good evening, board members. My name is Allison Riley, and I am here to comment on agenda item 6.02. There is an ever-growing disconnect between decisions made from the dais and public concern. The proposed superintendent contract and list of perks highlight that. We hear statements about the board's fiduciary responsibility and how decisions made currently are also made for future leadership. Where are we seeing those sentiments in this proposed contract extension and list of perks? Some questions that have arisen from the contract. Who is paying for the arbitration outlined in Exhibit 1? It is controlled by the superintendent, yet the board is financially responsible. Are board members individually financially responsible for that, or is taxpayer dollars being used? Why is there an additional $5,000 for travel? And why are receipts not required for that additional $5,000? Why are additional flex days needed? Why was there a 250% increase in professional development coupled with cash out language written into this contract extension? Much of the proposed contract empowers the superintendent, weakens board oversight, and takes away voter voice of elected officials to hold their single employee accountable. What evidence was used to justify this extension, the perks, and the loss of oversight written into the proposed contract? At the end of the day, the superintendent's job is a public one paid for by taxpayer dollars. Public concern is valid. I hope each concern is fully explored and addressed. Table this vote in order to have time to do both of those things. Thank you.
Good evening, board members. Tonight, I'll be discussing my opposition to agenda item 6.02, Superintendent's Contract. At a high level, it's important to call out that this contract represents not just an extension, but a raise in the form of increased perks as well. Some of these perks come in the form of direct cash, like the $5,000 travel stipend or the additional $6,000 available for professional development. Others come in the form of cash out options, like an additional $13,000 worth of vacation days. And others appear to come in the form of future revenue, like $23,000 contributed annually to the superintendent's 403B plan. But I'm not here to talk about the contract itself. Instead, I'm going to talk about the data used to justify the contract. In the 22-23 evaluation cycle, the board rated the superintendent a total of 11.25 points out of a possible 16. In the 23-24 evaluation cycle, the next year, the board rated the superintendent a total of 11 points out of a possible 16. A quarter-point drop from the previous year. The superintendent's lowest score in 22-23 was 2.5, while his lowest score in 23-24 was a flat 2. How is the board justifying an extension and a raise when your own rating seems to indicate that his performance has gotten worse? In addition, the district's strategic plan lists out 39 different measures for evaluating the 4 goals. The evaluation rubric you used that I received via public records request also lists out those measures, however does not include any values for the 23-24 school year. I have submitted a subsequent records request for the 23-24 measures, and I emailed the board about them on Monday, but as of now, have yet to hear back. The strategic plan does include a timeline of when those measures should be available, and all but 3 show as being available by August or earlier. I don't know what those measures will show, but you do. You know which measures have been provided and whether they support or oppose this contract, and eventually the public will as well. The district has stated in the past that the primary reason for the bond and levy failures has been the tax amount. However, the district's own survey responses indicate that, at least within those surveys, the primary reason deals with a lack of trust. You are asking the community to approve a levy in November, and the district has specifically stated that they want to build trust with the community, but making decisions like this without providing the supporting data is not how you build trust. If you do not have the data necessary to justify this contract, then you need to wait. Wait for the data to become available, and evaluate this first year of the strategic plan, because extending the superintendent's contract with either missing or opposing data is not doing your job.
Hola, mi nombre es Lucinda. Tengo un hijo en el distrito de Kent. Los programas ampliados por el superintendente y el liderazgo han impactado mucho en mi familia. Mi hijo posteriormente asiste a los programas del Centro Random y lo ha ayudado a enfocarse y especialmente a seguir más con entusiasmo sus estudios. Igualmente es importante contar con un liderazgo que sea una persona que entiende nuestras necesidades como latinos. Como madre latina me siento escuchada y apoyada. Agradezco al superintendente por su apoyo y por escuchar nuestras necesidades. Gracias.
Hello, my name is Lucinda. I have a son in the Kent School District. The programs expanded by the superintendent and the leadership have greatly impacted my family. My son subsequently attended the programs at the Centro Rendu and has decided to focus and especially to continue his studies with more enthusiasm. It is also important to have a leadership that is a person who understands our needs as Latinos. As a Latina mother, I feel heard and supported. I thank the superintendent for his support and for listening to our needs. Thank you.
That concludes our comments. We are still in open discussion. Any board comments?
Do you have anything? We're in discussion.
Yeah.
Oh, yeah. I mean, I guess I had some curiosities and just a few hesitations because I do want to make sure that I'm making a well-informed decision and vote. And just hearing from some of the comments today did strike some additional questions that I have. And one of them in particular, I'm wondering if we can have some additional clarification from our council.
Mr. Leonard.
So one of the topics that was brought to our attention tonight was the lack of clarity and some vague language around this, the piece about mediation. Could you provide us with your feedback and thoughts on, I guess the first question is the liability piece. There's nothing in there that clarifies the fees associated to the board. And so I too would like to know, is it the entire board collectively that's paid by the district? Is it each individual member that will split the costs of the mediation? How is that laid out?
All right, so President Margell, members of the board, good evening. I come to you being brought into this conversation after the superintendent's original contract was negotiated. The section, paragraph 4 on administrative section, it actually exists currently in Superintendent Vella's contract. What that contract doesn't have is any sort of dispute resolution or process in which, if there is a dispute under the section, what is to occur. And so what is before you in the addendum is not new language related to the actual underlying reason of that section, which predates my existence in the district. It was pre-existing in Superintendent Vella's contract. It's more a clarification as to what to do if there is a dispute under that process. So that was the intent of the additional language. In regards to like the funding of the section of the mediator, that is not borne individually by individual board members, nor by the superintendent individually. That would be expense incurred by the district.
And how would that be enforceable if that language isn't discretely and operationally defined in the addendum?
What was the question, Director Song? How would that be enforced?
Yes, because if there's this looseness and subjectivity to the way that the fees associated are sent to the board is currently written in his contract in that addendum. Under whose discretion is it that they make the determination to enforce that the district will in fact pay for those fees and not redirect those fees to individual board members? Because the language doesn't explicitly state that. And so could somebody challenge that?
So the purpose behind this section is really to have the parties engage in alternative dispute resolution prior to any lawsuit or challenge legally, was the intent of the section that was brought by in negotiation. And so if throughout the process the parties are unable to, it doesn't require that a resolution be reached, right? It only requires that in good faith the parties attempt to engage in some sort of alternative dispute resolution. If through the conversation we can't even agree on the fee and there's challenges related to that, you know, I would imagine that we would enter into those conversations in good faith to try to find resolution. But make no mistake, the contract nor the addendum does not require that the parties actually reach a resolution, only that they attempt to agree or attempt to engage in alternative dispute resolution prior to initiating a lawsuit under the contract.
I am familiar with the intent. Again,
Sure.
my question goes back to how will this be enforced? And under that hypothetical situation, if mediation and the associated costs can't be fairly in good faith agreed upon that the district would pay for them, under what RCW or WAC would we be able to refer to if there was any contest to say the administration wanting to redirect those costs to individual board members? Because right now it doesn't seem like there's any clarity around protections. And so at this point, all of it is truly just laid out to the council and the district's interpretation on how they'd like to proceed.
Yeah, I'm not aware of any theory that would attribute this to individual board members having to pay for it. I'm not aware of any theory, and so in the absence of a theory, you know, costs incurred are incurred by the district. They're not incurred by individual board members. And so in order for there to be, I would say in order for there to be that situation, it'll have to be clear in the contract that states that the individual board member's responsibility. Otherwise, it would be the district, and much like all costs incurred are paid for by the district.
So we would have to enter into this risk in faith and hope of a theory.
No, I would say that, not a theory, I would say that the alternative, if this was the individual responsibility of each individual board member, it would have to be construed as such in the contract, is my position.
Thank you, you answered my question. I guess that's the comment that I have for the board is due to the lack of clarity and the vagueness of that does terrify me. I think there's been a lot of precedents already and experiences on my short term on this board where a lot of these theoretical and hypothetical situations have come to fruition. My, I guess, confidence in the actions of working in good faith hasn't really been reinforced. And so for that reason, I would just like to hear from the other board members on their comments on the looseness of the language of this addendum.
Director Cook.
Yeah, I agree with Director Song. I think it's far-reaching and does not protect the public, which is, of course, what we should be doing here. We are a body of directors that are charged with the education of our students here, not to get into disagreements on our employee and what he's doing. The idea that I would be able to go and sue my boss because he said something that I didn't like seems patently ridiculous, in my opinion. But I mean, as far as that goes, though, I mean, I haven't heard any argument from the yes side, I guess, of our board, assuming there is one, of why we should be tying our hands in this way. What is the benefit that you see for us passing this?
The language already exists within the contract. It also predates me, that right now it just goes straight to litigation. And so we know that that doesn't change. That is part of the contract. That will not change. So what this does is this puts a measure in place that we can try to go through arbitration first. So we have a first step. So if anything, that this is protecting costs and protecting us a little bit more than what there is before, is what I see. I think it was a good negotiation to have that. And also very common within other lines of business, not necessarily contracts that I've seen for employment, to be honest, but when you have, the language already exists that it can go to litigation, to be able to have arbitration first makes sense.
To rephrase and provide clarity on my initial question, I wasn't challenging the existing language of litigation.
Yeah.
I was asking for clarity on this addendum of the arbitration, because in the language of the arbitration also says that the costs and liabilities will be on the board, and that's the piece that I'm looking for. So if anything, that would be an additional cost, because if we can't come to a resolution, and it does happen to go to litigation, now there's that additional piece that we just spent money on. And the area that I'd like the clarity on is who's paying for that, because according to our council, it says in good faith, but as a taxpayer, as a member of the board, that's not good enough for me. I can't consciously vote on the assumption and within good faith that the administration would uphold that language, that the district would cover it. So that's one, which the district shouldn't be liable for that. But then if there's ever a situation where the language was challenged, we have nothing written within our policies that would protect individual board members from incurring those costs. And another question that I have, again for council, I apologize for making it come up and down, was another question that was asked that I also would like clarity on. When it comes to the mediation, we do have the language in there that it says, or for the arbitration, the 5 business days. Can you provide clarity on the accuracy of, is this even possible? With the comments about the mediation timeline, and I would just like your thoughts on that piece first. Is it possible to even get a mediation within those 5 days? And what happens if we try to source that mediation or arbiter and the next availability is beyond the 5 days? What happens in that case?
Thank you for the question, Director Song. Certainly, I understand that it can be difficult to get a mediator. I would say my experience, there's a range and spectrum of ability to get mediators. There are services that provide this, and there are ability to get mediators same day. I mean, there is a range and a spectrum in terms of getting a mediator. What I would say in the event that the parties can't secure a mediator within the timeline, my viewpoint on what this does is it still allows the parties to engage in conversations, to extend deadlines, as long as the parties are working together in order to engage in this process. Meaning, if they needed more time, and having worked in this space for many years, it is very common when we are asking for mediation and there's timelines, whether it's by board policy, whether it's by contract, whether it's by statute, that the parties can agree to extend deadlines and timelines in a way, and that really fits within the spirit of this agreement, which is alternative dispute resolution and mediation, given that sometimes schedules are such that it might not be within 5 business days. Or 5 days. That is a guideline in the agreement, but certainly it would not constrict the parties from agreeing to extend it if necessary. If in the event that one side says, no, we're not going to agree to that, and we're not going to extend it, what does that do? I would still say you would likely satisfy the obligation of engaging in that process. Like I said, you could show up to mediation in day 1 and leave after 5 minutes. There's no obligation to continue forward in a process that's not going to be fruitful. What it does do is it allows the parties to engage in this process prior to litigation. That was the intent of the section.
Okay, and I would like something beyond in the spirit of. So looking at the language of this, again, a lot of this is open to interpretation and subjective decision-making based off of the district council and administration. So going back to my question, if we can't secure a arbiter within the 5 days as outlined in the addendum, what is the next step? because you say that we can still have the meetings. I am well aware of that. But if this is a part of his contract where it says that any disputes need to be resolved with an arbiter, and we're not going to have one retained within the 5 days, then what?
I'm going to scroll back up to the original addendum. Hold on just one second. It's a great question. My response is I believe that if the parties engage this process and don't get to the finish line, so to speak, I would believe that you have satisfied your obligation, and that would, and then if the parties are unable to proceed forward, then the superintendent could engage in litigation without proceeding forward through the process.
And this would be in good faith?
I mean, whether it's in good faith, that's subjective. I mean, but I would say that in terms of what the language says, I think it would check that box off.
Yeah, and I think your thoughts on this are well intended, but when it comes to the contractual agreement that this is the process that we are agreeing to follow, and we are not able to follow that, and there's no concrete language that outlines what is the procedural code or policy that as a board we are implementing on how to navigate this, that's where my hesitations come in, because I've sat through multiple situations where the subjective nature of the course of a conflict has gone in diverse set of ways. There are a myriad of accounts that we have on record where things just don't go the way that we were advised, and for that reason, that's where my hesitations lie. And I would truly like to hear the devil's advocate for this, or the opposing side. I'm not challenging it. I'm simply asking for clarity of what do we do in these situations, and how would we navigate them, going beyond this is the right thing to do, because that's not how contracts really work, because there's a lot of right things that we could do. But if we're not able to uphold that part of the contract, I don't know how we can consciously enter this.
I don't necessarily believe it puts you in any worse position. That if the addendum did not have the alternative dispute resolution process, then the alternative is the existing contract.
So in the existing contract, it says that if we breach the contract, then the superintendent has the right to, I think it was like, to leave the district and then get paid out for the remainder. So technically, if we do go through the arbitration, we can't secure the arbitration, is that putting us in a breach of contract where those other additional clauses will then become enacted?
Those are still there. It just provides an interim step.
Right, but we're still violating that part of the contract.
Potentially. You would under either scenario, which is the existing contract or the contract with the addendum.
Okay, that is my fear. If we're going to sign a contract, I want to make sure that with high fidelity, we are able to uphold that contract. I don't think it's fair to Superintendent Vela to be put in a position where his own contract has underlying contradictions or gaps in language where it can be left for interpretation and cause us to enter stages of litigation if that can be prevented from the beginning.
But the litigation doesn't change.
No. I'm not saying that. I'm saying he could litigate because we are now violating the contract if we can't retain the arbiter.
It would fall back onto the contract that exists today, which would then put it through litigation.
I understand that, but, so, I'm trying to think of how I can simplify this. So in the contract, it says that if we violate a portion of his contract, he has escape routes, right? The litigation on whether or not somebody wants to pursue litigation against the superintendent is not what's being called into question or being challenged. What's being called into question is if this addendum is added to his contract, that if there's a dispute, we have to go through this dispute resolution. If we cannot go through that dispute resolution, that is a violation of his contract, which means we violated it, and now Superintendent Vela can make the determination if he feels like we have now impeded his ability to do his role. That is what I'm referring to.
My guidance on that is that additional section, if the alternative dispute resolution process does not happen in the same way and we can't get a resolution, that is not, in my assessment, an additional material breach that would cause and trigger that section in Section 4. I think it's just a hurdle that has to be cleared, that if the parties are unable to clear, whether it be because they can't select a mediator, or they show up and they can't mediate it, or they can't get an agreement, you're in no different scenario. Now, I would stipulate and agree that additional provisions of a contract can be challenged. You're adding other sections that can be challenged. And so in a general sense, adding language into a contract produces additional challenges potentially from the superintendent if there's a dispute. But I don't believe that this section removes or changes any of the liability originally agreed upon by the parties in the original contract in that section, which I believe, and then to answer your last question, and I just want to refer to this because you stated that this might be a subjective opinion under paragraph 6 of the new addendum, which is the board shall be responsible for mediators' costs and fees, and whether or not it was my subjective opinion as to whether this applied to individual board members. There is a whole body of law that protects board members in your collective decision-making in which you're not individually responsible for your individual decisions being made. As a board member, you have protections by our insurance company. You have protections that protect you from as long as you're within the scope of your assignment and job. And I would, when this was drafted as the board shall be solely responsible, it is in its collective capacity and not individual capacity. And that is not a subjective opinion of mine. That is what a whole body of law stands for. And so I understand anything could be challenged, Director Song. It's possible that something like that could be challenged. My degree of worry related to that is very small, and you would have the whole force of district legal counsel arguing that the intent here is not to collect individually from board members, that the intent here is to act in a board collectively in the normal and way we normally understand the board to be, which is collectively and not individually. And that's my position on that.
To clarify your response, my comment about subjectivity was to your comment about if we can't secure arbitration, then we should just still go through the process to try to navigate this.
Fair.
That's the piece that's subjective to me, because sure, we could do that, and I think that would be absolutely fine, because that's how it's done now without an arbiter. However, that still doesn't address my question about if we breach his contract of saying that we will have an arbiter and we're not able to secure one within those 5 days. And I think the looseness and lack of clarity around this language is quite concerning. And at this moment, I'm not highly encouraged to want to pursue that unless I can get the clarity that I'm looking for in terms of, is there going to be concrete language that would put those protections into place and to clarify what are the next set of steps that would happen, and to operationalize that, as opposed to, well, if this doesn't happen, I guess we'll just talk about it when we get there. That's the piece that I'm hung up on.
I believe that the question's been asked and answered. That
It wasn't. That's why I clarified it.
Let me clarify it again then. That a breach of that section does not materially breach the remainder of the contract of which we're speaking about for it. That portion of it is not invoke the breach of contract for the remainder of the duties of the superintendent, if I may.
That is correct.
Can you clarify? Because I guess maybe I don't have the right understanding of what is a breach of contract, because my understanding now is that if in the contract it's included that we have an arbitration and we can't do an arbitration, that is a breach. Is that not correct?
So there are remedies that you referred to in an existing contract in that section that were remedies that are specific to that section. The addendum, and if there was an inability of the parties to comply with the obligations in that section, that's not a breach that's referred to in that administrative interference section in paragraph 4. So that would not invoke those provisions in that section.
So what would then? Is there something in here? Is there a point in here that does?
Yeah, a lot of this is the existing contract, and I'd have to pull out and look at and go line by line, but there is an existing section that deals with that language. And we'd have to compare and contrast with the existing language in paragraph 4, section 4, the administrative interference has remedies there for that specific scenario.
Are you able to?
I can if you just give me a second.
Yes.
Thank you. Yeah, that's the piece that's unclear, because I guess my understanding still, and I'm sorry I'm so so dull at trying to comprehend what's happening. But again, my interpretation is we're adding this addendum into the contract. If we're not able to uphold it, is that not a breach?
So really, again, I do look at section 4 of the existing contract because it's really about administrative interference, that the board's responsibilities for policymaking and non-administration. Board members will refrain from taking any unethical, inappropriate, unlawful action regarding the administration of board policies and day-to-day operations. So it's really around specifically board administrative interference, and that's what that section is about.
Okay, because this wouldn't be the first time that we've had misleading or unclear guidance and instructions, and so for me, still, this is still lying within room for interpretation.
Again, I go back to section 4 in the existing contract that already exists there, and so it really is the remedy for this currently is the judicial remedy. And so what this does is get an intermediary step that is more collaborative and really in the spirit of what we want that relationship to be is, and being able to have that arbitration there. Without it, that judicial remedy still exists.
I would answer it this way. The additional language in the addendum about alternative dispute resolution, if the parties were unable to secure the mediator in a certain amount of time, and technically it's not in compliance with the agreement, would in no way be any different breach than, say, if the district all of a sudden decided to cut the superintendent's pay by half. That would be a breach, but it would not be a breach that triggers administrative interference in section 4. It would potentially be it would be no different than any other material term in the contract, but it would not. I'm going to be very clear. This is not subjective. It would not violate the plain language drafting of Article 4, Section 4, that says and defines administrative interference. So I want to be clear on that. I don't want there to be any sort of misunderstanding about what my position or the district's position is on that. That section would not failure to follow or even if Superintendent Vela says we want to engage in alternative dispute resolution and the board says we don't want to, no. In no way would that trigger Section 4.
So this is maybe just procedural, but we keep referring to Section 4, but Section 4 is completely superseded within this addendum. So the first line here says Section 4 of the agreement entitled Administrative Interference, Communications, and Relationship shall be amended and replaced in its entirety as follows. So there's no point in going back to Section 4. It's all right in the addendum, correct?
Correct.
Because I keep going, the reason I ask is because I keep going back over to the other contract, and that is superseded by this, and I don't need to pay attention to that, correct?
That is correct. It is predominantly the same language with the exception of the alternative dispute resolution section.
But it has no force or effect once this is adopted, correct?
That is correct. It would replace that section.
So Section 4, we don't need to look at Section 4 in the first one because if we pass this, this supersedes that entirely.
Well, the reason I referred to Section 4 is that's what's currently in place for the superintendent, what was negotiated, and a lot of times, it's the starting point of the relationship between the parties of the existing contract. That's what's currently in place. When we negotiate a superintendent contract extension, we don't start from zero and strike everything and just start all over. There is an addendum which has the existing language codified already. And so the only difference that which was brought was the alternative dispute resolution, whereas the other sections. But you are correct that technically it replaces it all.
So I guess my concern there is I've always lived my life by two wrongs don't make a right. And it seems to me the first contract was bad. The second contract is bad. Why do we can write out the contract theoretically and say, okay, well, we're stuck with what we have, but why are we using that as our baseline instead of saying, what are the other districts around us? Because you've said in the past that this is not something that anyone else does. When I, as far as I can tell, I couldn't find any other district that had any kind of language like this whatsoever. Have you adjusted your thoughts on that, or have you found other districts that have similar language?
So I will say, Director Cook, that portions of our conversation have been stated in executive session. I have not spoken publicly about this contract at all.
Okay, can you speak to my question now then?
Again, we've advised in executive session, and
Okay.
we've talked about negotiation and privileged information. And, you know, at this point, I would defer to those conversations that we had in executive session that are attorney-client privileged conversations. And at this point, I'm going to defer to that.
Okay, so I will ask it in public since that's apparently a problem. Have you ever come across something like this ever before in your time being a lawyer for school districts?
I have not negotiated similar language.
Have you ever heard of any language from another district of any sort from any lawyer that you've ever known or worked with?
I cannot speak to that expansive language. I work in about 30 school districts, and I have not used and seen this language.
Okay, so earlier today, you said you worked in 50 districts, but now you're saying 30, and previously you've had other
Superintendent
numbers.
contracts is probably 30,
Okay.
50 school districts in other capacities, so I'll give about 20 difference margin for error.
Okay, I'm just curious because that's a pretty big margin there between those two.
It's an approximation.
Yeah, I understand. I guess my other concern here is I look at that last section within the addendum, and I mean, this is not us protecting the district here, but I wonder, how are we able to forego someone's right to legal resolution? Are you able to do, I didn't know you could give up your right to sue within the courts. I've never, outside of, contracts with, entities like God, they all have those arbitration agreements, but is this similar to an arbitration agreement?
What section are you referring to?
It's section 7 of the addendum. It's the very last paragraph, or sentence, I suppose.
Travel?
No, it says limitation on legal action.
Section 7?
Of
Yeah.
the addendum.
Travel?
Of the addendum.
It's of the alternative dispute exhibit 1, President
Yeah.
Mario.
Oh, sorry, yeah, it's part of that.
To the extent that the parties negotiate this agreement, they can, the parties are free to negotiate the rules of the game, so to speak, including when and how they initiate legal action under the contract. Because the contract is what gives the basis for legal action, and so the parties can appropriately negotiate that and how they want that to occur. So courts would defer to the parties that they intend what they intend, and if that is a provision that both parties want, to limit the ability to engage in legal action until they engage in some sort of process, that is routinely found to be enforceable by courts.
Okay.
Yeah, I mean, I would still like to, again, I'm still trying to make an informed decision, but I would like to hear from other board members just their take on this addendum. Is there something that I'm missing? Is there, did I overlook some details of this? What are some of the benefits of having this? Because from existing knowledge, this would be kind of the first of its kind in a superintendent contract from what many within our advisors have shared with us. And so from that, I guess I'm curious to know what some of the pros are for this.
The board recognizes Director Clark.
All right, so first of all, as a locally elected official, the school board is unique. Unlike the city council, where you in fact act as an independent individual, school boards are by law only permitted to act as a group, and it's whatever the group decides. So when you, for instance, go through the process of looking at would there be a problem because we can't get arbitration in 5 days, you'll recall it specifically stated that in fact you can expand that time simply by agreement. So it doesn't have to be just 5 days. And the question is, would the group collectively want to come to a logical conclusion with an outside source? And you would obviously want to permit that to move forward, not get stuck where you're at.
So am I understanding your argument here that our legislature provided school boards as oversight entities, but they did so in a way that if there were to be, and I'm not saying anything as far as this board here, but if we had a board in another district that had a majority of 3 people and maybe even 4 people, and there was a single board member that was not part of that group, and they agreed to whatever it is that they were agreeing to, that other board member in their oversight capacity is still responsible because each of us swear an oath that we are going to do the public's work in the best interest of the public, and that is a determination of ourselves. And yet you're saying that like any board director across the entire state of Washington, our legislature wanted them to only act upon a majority vote of anything. So there's no oversight provided unless you have a majority. So if 3 board members were to be nefarious, not this board, of course, but any board, and they had no good faith, and they were to come into a contract like this, and there's a good faith participation, they could then punish those other board members by saying they are going against it because they've now voted something in as those 3 board members, even though the board member in question, whoever that might be, is trying to provide their best understanding of oversight and protection of both the fiscal responsibility, the safety of our students, and many other things. And we are charged with that individually. And in this contract, we are also specifically individually targeted, so to say, in a way that would bring stuff against us individually, even though your argument is that you can't do anything as a board member, you can only do things as a board whole body. Am I understanding that correct?
It's about how you arrive at decisions and create policy. And yes, that is a correct statement. So the question has, what happens when it becomes dysfunctional? And I think the attorney can probably verify for me that the state does have a process to actually take control of a school district that is in conflict with state law.
I mean, yeah, we know that that's happened multiple times recently in situations where the superintendent and or the board were doing things out of their out of interests that were not aligned with the public's interest. And if that were to be the case in this district or any district, those other board members providing the oversight that they believe the public has wanted and the public is outcrying for are now going to be beholden to that, and what kind of remedies are there? So if that were to be the case, and this may be a question for our legal counsel, if something were to be done as an individual board member, how would I, as an individual board member, be held accountable for things when I'm hamstrung in my ability to provide the services that I was elected to provide, and I can only rely on the majority of the board? So individually, how am I held responsible for things that I cannot have any control over? So you're saying I would have to remove myself, and now that oversight I'm no longer providing. The public could theoretically sue me because I'm not doing my due diligence and not doing my duty as an elected member of this board. How is that able to be gotten away with a contract? You know, we're talking about oversight provided by RCW within Washington state law compared to a contract that 3 board members theoretically could just put into place. And that has, I don't see how those two can work together. Maybe you can explain that to me.
Well, obviously you're demonstrating it because the question is a disagreement among the board. And the point is you do have the right to explain your position, why you feel that way, and then if you can, persuade others to join you. But the reality is, as a single board member, you can't bring the system to a halt simply because you don't agree.
Would you argue that, say, if I wanted to go and visit schools, or if I wanted to go talk to principals in a capacity that was not going to impact them, that would be enough to be this sort of thing could be brought against me, or no?
No, this is about protocol in terms of how we operate as a board, and that's an agreement among us.
Well, I mean, this is a contract with the superintendent. It's not a contract with the board. We have our duties already explained to us by going and swearing in. Yeah, I mean, I don't know how many other times you've sworn into things. My own experience is swearing into the military. And when I swear into the military, I say, my body and mind is yours to do with as you please, but you're going to take care of me on the other end. And that is how you end up with someone like myself as a disabled combat vet who the VA is taking care of financially because of the things that happened while I was in that I otherwise wouldn't have had. And so they are taking care of me in that sense. Here, I feel like it's a similar duty. We swear to provide the services of oversight and financial responsibility of our district in the way that we believe it's being done. And that can't be done by saying, oh, well, you don't understand it. Our public said they wanted you there, but they don't understand it. We get to decide what the board members do. And this is not talking about going in and giving directives to anyone. So I understand that if I were to go into, say, anyone's office in this building or in any building in our district and said, I don't like what you're doing now, I want you to do this, that is improper because that is me interfering with that. But the idea that me providing my oversight by asking for information or going and talking to different people that work within the district, by reaching out to my community as an elected official, how are those things? Because that's what I see in the past so far. Those are the types of things that have been charged against me for the things that I've done. I have never directed a single person in this entire district, other than maybe my wife, to do anything. And honestly, if I tried that with her, it would also be told no. So, like, I don't understand how are you to provide? So say you were in the same position as this fictional board where you're in the minority, you are expected, mind you, that you are responsible for anything and everything that happens within that district. And it is written in law, it is not a question. You are responsible. So if anything goes wrong, if you do anything where you choose to put the wrong people in power, you could have lawsuits brought against you. You could also have recall brought against you. There are all kinds of different things that could be brought against you. And especially a situation where if you do something illegal, that could get you individually in trouble. You aren't protected by doing illegal things. If you do anything illegal, you still can go to jail. Even though you're elected, even though you thought it was part of your duty. You'd have to have a fight with a lawyer, I suppose, and argue that case. But that's my concern, is that how do you decide what it is that is part of your oversight and what is not? Because as an elected official, that is independent. That is the reason that you are meant to make decisions on your own, with your own individual understanding of everything that's going on, and by getting as much experience as you possibly can, and then making educated decisions for the public who have elected you, who have put you in that place. And taking you out of that place seems like a very far reach to me.
Well, just for illustration's sake, as a board director, you are explicitly prevented, as you've already pointed out, from interfering in the operations of the district. And if you will look at the construction of how they directed school boards to operate, it is supposed to be in compliance with the superintendent, not in opposition.
There is no compliance. If you can point to the
I'm
RCW.
going to interrupt. This is becoming very argumentative, and I honestly, I just wanted to make an informed decision. So could we go back to the topic of what
what are the pros and cons of this addendum? I think we've started to veer a little bit far off into other discussion topics. But that's my opinion. Like, would you guys engage with me in this conversation and help me understand better of what's the other perspective that I'm missing about the addendum and the addition of this arbitration?
I would just go back to what I've already answered with before, is where the contract stands now. The one remedy that there is a judicial one, and this gives at least the opportunity for a collaborative process that is more cost effective and can come out with different results that a judicial one might not be able to, and that is better for the district, speedier. Unfortunately, our court systems are also underfunded and backed up, and trying to get in is hard. And so this gives an opportunity to be able to hear the information in a speedier manner, in a more collaborative environment. So for me, compared to what we have today, this puts us in a better position. And I think it's a good negotiation for both the superintendent and for the board, because it benefits on both sides that way. So,
thank you. I guess my question to elaborate more on this then is, I have a lack of clarity around another piece of this. Is, yes, Director Clark was correct in that it says we would try to do this within a week, but then we do have the option of extending this if there's a mutual agreement to do so. If we're trying to pass a policy, a resolution, make a decision, and the arbitration was brought forth by superintendent, and the mediator can't be scheduled for weeks to months out, is there anything within our clauses or policies that say that we would pause any additional movements on that topic until this arbitration process is completed? Or can the superintendent at any point waive that decision and retract the arbitration so that we can reconvene and have a meeting about it if the board and superintendent mutually feel like the timeline might be too extensive?
I can tell you, kind of give two parts of that. Is one, I think that having legal counsel weighing in on that was great. What is compelling to me in this is, if you look under, and to the point earlier, what has been replaced, the section 4 with section 2 of the addendum, which is under the administrative interference section, and it talks about that, and it replaces that and updates that, where it talks about the superintendent and the board and its members shall collaborate regularly to promote consistent, transparent, open, honest communication. And if they're continuing to do this, it talks about the collaboration of it.
Yeah.
And so that is where the idea of, if you're both in collaboration, and that, yes, we get it, this week didn't happen, it's going to take 2 weeks, it's going to take 2 months, but you're in the process together, then that's where it can continue to be. You're in process, you're doing it together. So the process has started.
Yeah.
So that's where I see.
And I agree with everything that you said. That's my understanding as well. It's just more so, if we're at this point because there's such a huge conflict that a mediator needs to be involved, is there anything within our policies that's currently existing that says that any further discussions about that topic should be paused and no action should be taken? Because I guess where I'm coming from is, say we want to pass a policy, and the superintendent says, no, I don't agree with this, we're going back and forth, superintendent then initiates his dispute resolution, okay? And we find out that the mediation is going to take 3 months, just throwing out a random number. That's extensive. At that point, do we just not move forward? Because in the language, it says that there has to be a mandatory mediation administered. And I don't see any other remedy around that where there's language in this addendum that says that this requirement can be retracted by the superintendent, since they're the ones that's initiating the dispute resolution.
And please correct me if I'm wrong on this, Mr. Leonard, is that this has to be with board action of interference. And so unless something has passed or we have done something, the idea of just talking about something isn't doing, right? It actually has to pass. So let's say that somebody wants to do something, we all talk about it and then vote it down. That wouldn't be administrative interference, is because it didn't pass, right? The policy. It would take the action it had to have passed before we're
that's not what I'm asking.
interfering. And so, but pausing on it, that's my question on this. I don't know if you can pause on that.
Let me give a ridiculous hypothetical. The board wants elephants in every school.
Perfect.
Superintendent's like, that's absurd. No, now we're in conflict. He invokes his dispute resolution. We go through the mediation process. They're like, hey, we got you. Let's do this 1 day thing, but we can't schedule you for a month. Does this discussion now go on pause until that mediation happens? Because in the contract, it says a mandatory mediation needs to occur, meaning we're just not going to move forward on making any decisions until this happens.
And so that was my point, is that the decision had to have been made. Just that it was brought up to the board, because I could want the elephants, and everybody else could say the elephants are crazy. The idea that I want the elephants, that's not a board action. And so until the board votes in a majority and it becomes passing, then it has to be enacted before interference would be enacted, I would say.
I agree, President Margell. I will state, though, that I don't believe there's anything in the contract that would have there be a pause, that would stop. You would have a dispute under the contract. We don't know who's right, and we're going to go to mediation to figure out if we can bridge the gap. And if we can't figure out who's right, eventually it'll be decided by a judge.
Okay, so maybe I'm understanding this.
But it wouldn't be paused.
Differently then.
There's nothing in the contract that says that alleged administrative interference, because it might not be. It might be within the board's authority, but it wouldn't be paused. There's nothing that says it's paused.
So what is a situation then where this dispute resolution would be invoked?
So I'm not, Director Song, I'm going to apologize a little bit. I'm not ready to fully litigate this section right now at the dais. We did discuss this in 3 executive sessions. I wasn't totally prepared today to go through the intricacies of this section. We talked in executive session about this section 3 times, and these questions didn't come up. So I might be ill-prepared to go into great detail about this section. I want to be very mindful of your question. It's a good one. It's to the meat of what's in this existing contract, but that contract existed prior to, and so I do want to state that I might not be well able to answer really specific questions about that initial section right now, but it does speak to administrator interference, and so those duties in which are solely up within the superintendent's ability and discretion.
Yeah, and I think it's fair to avoid this, because you're right, I didn't bring this up sooner, because this thought just popped up. But I guess, could we then have Superintendent Vela give us an example, since he's the one that initiated this addendum into his contract, of what were some of the thoughts or concerns of situations where this addendum was a priority for him to include into the contract? If our council can't, I think the person who wants this might be able to provide that clarity today.
Can I want to make a motion to table this, given the fact that our lawyer, who is our trusted advisor to this board, is not able to provide the advice requested of him, and that's not on you at all. But as he's stated, he's not able to. I would like to table this until our next public meeting, our next regular public meeting, which I believe is in 2 weeks. Is that correct?
We can't make a motion in a discussion, right?
Yeah, we can.
You can make a motion.
Oh, we can? Oh, gosh.
So I'm going to turn this
And then
to,
it needs a 3/4.
I'm going to turn this over to Mr. Leonard for that question.
So you have options. We've explained this before. There can be a motion to table. It takes precedent. You have to vote on it now, okay? And it has the same result. Or you can vote on the motion and up and down on the motion as well. You have two options. If a motion to table is made, it would have to be seconded and voted upon first. It doesn't require two-thirds, it's a majority vote on the tabling of a motion. And so, but you have two options.
Okay. Well,
as to my inability to answer the question, what I want to state is this. I was not here when this was negotiated, meaning I did not negotiate this provision. That's not a cop-out, it's just a reality. So I wasn't here during the conversations about why this provision was advocated for or agreed upon between the parties because I wasn't here representing the school district.
Do you know who was?
Other counsel was. I do not know Director Cook. I do not know who it was. So my ability to answer a question that was posed to me right now, I don't have an answer to you as to what exactly was the genesis of this section. And so in fairness, I wouldn't be able to tell you.
Yeah.
That's the limit to my ability to respond to your question at hand. It's not that I'm not prepared on this, it's that I wasn't here when this was negotiated.
And that is valid. And I'm going to apologize to Director Cook, but I want to go back to me first since I asked my question first. Could we have Superintendent Vela give us a situation in which this dispute resolution might be invoked?
So I'm going to ask that first from President Margell, and please don't take this as a negative, that I'm going to refrain from commenting on that because of, as Mr. Leonard, you mentioned earlier, this is part of executive session. In terms of the negotiations that were taking place, I'm going to refrain from that. Secondly, I'm going to ask the board to consider not using the name. You can use superintendent. Please refrain from using the name because that's exactly what we're talking about. So I'm just going to share that for the board to consider.
I apologize, Superintendent. That is a valid request.
Well, given the current situation of not having a response from our secretary of the board here or from our legal counsel, I still would prefer that I move to table this until our next regular board meeting. Do I have a second?
Second?
I'm sorry.
Oh.
The board would be asking for the second. Thank you. Is there a second for the motion?
I second this motion.
We have a motion on the floor for tabling this item, 6.01 Kent School Board 2024-2025 legislative priorities. Oh, I'm sorry, 6.02 Superintendent's contract has been made and seconded. We are now open for discussion on tabling the item.
I guess I would like to hear the argument for why we shouldn't table it, if there is one.
I feel like we have had 3 meetings, months of open dialogue available to anybody to ask any questions, and I feel fully prepared with the information that I've gotten over the last several months to be able to answer all of this and be able to have ability, as all of our board members have, to be able to be part of the negotiations of what the contract looks like, and we got it here after having that ability to ask those questions, to have input. And so at this point, I feel prepared to be able to make a decision tonight.
Can you reiterate why we have an open public meeting? You read it every time we come in here. I can read it for you if you prefer.
I'm sorry, is this a specific question about the superintendent contract?
No, I just wanted to reiterate why we do the things that we do and how we do the things that we do. I'll read it, it's fine.
I think it's a great question, but it's also off topic of the topic that we're on hand, but you can definitely read it during your director's report at the end of the day.
This speaks directly to your last comment, because your last comment said that we've had plenty of discussion, that we've had plenty of time to discuss things. This statement here goes to why we're here. It goes to what we do. It goes to why we were elected and why everyone that's here, as well as all the rest of our community members, are the ones that are in charge, not us. And that's why I want to read this. And I think it speaks specifically to the fact that we did discuss this in private without our public involved, and this is our time to speak to it with our public involved. I'm going to read it. I know you don't
Actually,
like
I'll
that.
read it for you. This is a meeting of the Kent School District Board. This is a meeting of the board. It is done in public. It is a meeting of the board, though. And so I will reiterate that. This is a meeting of the board, and so
Could you
that's...
finish the statement, please?
Yeah, this is this is a meeting of the Kent School District Board, which is held in public.
So in addition to the contract, though,
Thank you.
Just
Director
one
Song.
second. I would like to have you read the full statement, if that's possible.
It's been read.
Then I'll read it. Welcome. This is a meeting of the Kent School District Board, which is held in public to comply with the Open Public Meetings Act. We welcome the public's participation in this board meeting and thank those of you who have come to this meeting and those who are viewing via our live stream. Does that not specifically state the reason that we're here? It's the purpose of the Open Public Meetings Act that we are required to follow. The only reason we discuss anything in private is to provide that ability to talk of those things in private. The discussion part, that part is not useful to our public. They don't know that we're discussing it. They didn't even know that we were discussing it. Honestly, I didn't even know that anyone was going and negotiating with anyone. I was never asked for my input on what our starting point should be, because this is a contract negotiation, yet I was not asked. I don't know if anyone else was on this board, but none of, as far as I understand, unless there was another meeting that I missed or something, but there was never an ask of me before the negotiations started, at the very beginning of them, what the directive was, what our guidance was for those that were going into that negotiation. We had no voice as a board. It was a single person, as far as I understand.
Again, to also reiterate the point that we do have executive session and executive privilege, to put out there again, every single board member was given ample opportunity to be able to voice opinions, make changes, make directives, and I don't know what to say other than that. Like, we've had 3 meetings on this. We have had open dialogue. We have had the ability to email and have specific interactions with the attorney one-on-one. And so all of that has been made.
With our attorney or with the superintendent's?
With Mr. Leonard.
Okay, so, but I haven't even met the other attorney.
No, you wouldn't engage directly with counsel for the superintendent. That's not how that works. I have engaged with the attorney for the superintendent directly. We have met 3 times. Director Cook, we have had great discussions. You've had great questions. I've tried my best to answer your questions. You provided questions in writing. We met for a long period of time last week. I thought I was on the right track in getting you answers. Certainly you have more questions, but certainly I've tried to get you what you wanted in advance of this meeting, and that was my intent.
I appreciate that, but this meeting, along with everything else that we do, is for the public. It is not for us. It's not, we don't go into private because we are the people in charge of everything, and that's the whole purpose of that, is to keep it private for the person we're discussing. It's the same reason that we go into executive session if there's a complaint brought. It's to give that person the option to provide that like private space to discuss things. The reason that we can't just end it there is because outside of exempt session, we don't get to make decisions back there. We can only make decisions out here, which means our public should know without a shadow of doubt that this is why we're doing it, and here are the reasons, and these are the discussions we had. It's, you know, if you're not able to speak to those things, how does the public know that you're doing your due diligence? And I understand there's a portion of this that is held in private for executive session. The discussions that you had, I would assume, fall under attorney-client privilege as far as discussions about the contract, because that was not during executive session.
Correct.
And so outside of that, though, the basics of who went, I don't believe that falls under the purview of that. Like, is that, is it so secretive that we can't even talk about who did the negotiation for us? Like that party, even that in and of itself, we can't discuss?
No, I wouldn't state that. I would agree that negotiations occurred through superintendent council and through myself negotiating
You
back and
alone?
forth.
It was you and the superintendent?
With direction of the board, with direction of the board.
From which board? I wasn't part of that.
Okay, so over the course of the last couple of months, including additional executive sessions, negotiations were ongoing.
I'm
Okay.
talking prior to the executive sessions.
Prior to the executive session, I will only state that the parties met very quickly, and Superintendent Vella's attorney forwarded information, which was considered and then brought.
Okay. Are you able to speak to who knew about it? Because it wasn't me.
I'm going to defer at this point. I mean, there is negotiations that happened in executive session and attorney-client privilege, and at this point, I'm going to defer at this point of
I
sharing additional
acknowledge
information.
that we've had many meetings about this. We have had our questions asked, and Curtis, I think you did a great job answering those, at least mine. But while we're in this discussion in public, to dive a little bit deeper into this so that we can make informed decisions, I guess my rationale for wanting to table this is this was our opportunity to get input from the public, and I think a lot of additional questions did come to light that I did not think of, and for that reason, I think we should re-deliberate on this with the new information that we had. I still believe there is a lack of clarity around some of the existing language in this addendum, and I think with this newly procured information, we should be able to talk about that since there are new elements and variables that were just introduced today.
Can I ask another kind of procedural question? I'm looking at our policy 1310. It says policy review, adoption manuals, and administrative procedures. Would this discussion be applicable to that section?
What policy 1310 is what policy?
It's policy review, adoption manuals, and administrative procedures. The first sentence on it says, a board policy is a formal expression of the judgment of the board providing guidance or regulation for administrative action. Legislation of new policies and the periodic review of existing policies are primary functions of the board. I'm just curious, because in that specific one, which I feel like the superintendent's contract is at least as high on the list as a policy that we are discussing, and in that it states that we have a first reading and discuss it, and then bring it back again in the next meeting. And I guess I would like to hear what is the emergency that says we need to get it done today instead of pushing it out for 2 weeks. If we don't do it for 2 weeks, what happens?
So to answer your question in regards to policy, there is nothing that requires additional reading of any agreement or additional 2 sessions to approve any agreement, both for any contract, be it the superintendent's contract, the teacher's contract, or any other contract. Board policy is different because we make modifications to that, and that is specially called out in policy following WAS's recommendation. So, that doesn't apply to your greater point as to should this require, should we have 2 readings? Is it important enough that we come back and consider? A lot of this, in fact, the majority of this happens in executive session because there is a balance between what we do in public and what applies to a private individual, yes, in a public position, but in employment, and they have liberty and other rights associated to that. And so the majority of what we do there, 95%, the negotiation, the back and forth, happens in executive session. The performance evaluation, a lot of that, most of it happens in executive session. Yes, the culmination of that, the approval of the contract, happens in open session. Generally, it's a formality because of the work that's been done in executive session prior. We did a lot of work on this. Hard questions were asked in executive session. We came back. In fact, we scheduled another executive session in order to get this done. In fact, it wasn't brought 2 weeks ago for that very reason, because I wanted to make sure that the board felt comfortable. I spent individual time with all board members to make sure that we were all on the same page. And so I personally don't feel like it's rushed, but certainly it's at the board's direction. It's at the board's direction, not mine.
Yeah, I think it would be in the best interest to table this because, I mean, I want to praise the superintendent for wanting to put in measures due to a skill deficit of leadership. And if this is something that's going to be requested and is a benefit to support the roles, responsibilities, and duties of the superintendent, we should make sure that the language is clearly laid out so that he receives that support that he's requesting. And looking at this language, your inability to answer some of these new questions because they were just brought up to you, I think would constitute logical and rational reasons to want to table this so that we have further discussions. Again, I only brought up the questions that initially arose for me, but after hearing from the public, I would like some clarity on that. Some of the language does seem vague. You also used a lot of verbs such as in good faith, the spirit of. And for me, that doesn't seem fair to put in a contract for our superintendent.
I understand your perspective. I will tell you, there is no contract I can draft that anyone can draft that does not have some ambiguity in it. And that at some point we have to decide that this is the decision we want to make. And because there's no way we can draft something that will not have some sort of ambiguity. Any contract can be challenged. Any provision can have some ambiguity in it. So I just want to recognize that that is a possibility. And then at some point, the bigger question is, we have a superintendent contract, and there is a decision that does need to be made in that your superintendent contract expires at the end of this year. And decisions need to be made on a superintendent contract one way or the other. Although not prescribed in your superintendent contract, my role as board chair or board council is to verify that we have leadership in a district and that there is a plan for continuity. And part of the advice is related to that in that, I'll be honest, in coming to the district in May and seeing that we don't currently have a plan in place, that had questions for me. And so that's part of this process of making sure that we have a plan in place so we have a superintendent next year.
So I guess my question on that is, you're saying you came in May, it's now September, right? I mean, that's 4 months later. And granted, I know there's a lot going on towards the end of school. We've got all kinds of stuff, graduations and getting prepared for the end of school and getting all the schools shut down and all of those things. And then we've got the summer and everyone's got vacations and stuff. This feels like it was done on purpose. I've asked numerous times why everything we do has to be voted on the same day. Every time I'm told, well, this is a one-off situation. We need to get it done today. And yet, here we are again. And I guess maybe the fellow board members don't care about how I feel when I have to make a decision without having heard from my constituents and the voters of our public here. But I'm going to keep bringing that up. It's going to be brought up every single meeting as long as we keep doing these things. Like, give our public some time. Like, if someone was on vacation this week and they were gone, now they have no knowledge. If they left on Thursday last week and they're out of country, and this is a very real possibility, that within a week, less than 7 days, we are telling them, you should have just stayed home. Because if you had known that this was going on, you would have been here. Because it's that important. Because the things we do here are that important. But we're not giving them anything. We're not giving them any leeway. We're not saying, hey, come and talk to us. We're charged with that in RCW. It's told our director's responsibilities. It says, C, provide information to the local community and its electorate describing the school district's policies concerning hiring, assigning, terminating, and evaluating staff, including the criteria for evaluating teachers and principals. I'm fairly certain that falls under this same responsibilities as board directors, and you're telling me that we're not even going to give them a week? Like, we're going to give them from Friday to Wednesday? I don't know. It doesn't make me happy. I don't understand it.
So here's what I'll state to that. And again, I work in a variety of other school districts, And so my experience can only be based on what I've done and seen in other school districts. Generally, the turnaround of a discussion and a finalization of the contract where the board feels comfortable with the contract and then approval is a relatively short turnaround time. Once the board's ready to go, it is my experience that that goes for approval at the next board meeting. Same thing when we hired the superintendent, we negotiate, that approval is usually a very short turnaround time. That negotiation doesn't happen in public. The public doesn't negotiate the contract, okay? Now, you raise a very good point, Director Cook, in that the public should have feedback into the superintendent and the superintendent's performance. That's not necessarily during the negotiation of the superintendent's contract. That's part of the process that should be occurring throughout the entirety of the process, through the evaluation process, through ongoing conversations with the board and the superintendent governance team. That should happen. So the approval of the contract should be a culmination of that work.
But we haven't even provided the review, right? I mean, have we?
I think it'd be respectful
to
to still table this conversation. I think out of respect for the community voices, the addition of new information, we're already 4 months behind schedule. I don't see any harm in an additional week. I think given the situation that we're in terms of public perception, this would be a nudge towards the right direction in terms of reclaiming some of the public's faith in the board's willingness to accept their thoughts and opinions by giving another opportunity for us to discuss this a little bit further. It's wild to me to think that after a vote of no confidence and threats of recall that we still continue to engage in behaviors where we're neglecting or rejecting the public's opinion by delaying a conversation for additional weeks so that we can have a more formal and private discussion with the new information that was shared. That wasn't directed to you. I apologize. I was looking in that direction.
Director Farah, any comments on the tabling?
I'm gonna refrain from what I have to say because it seems that some board members that have been on this board almost a year now keep claiming they don't know. And to me, that sounds that you are neglecting the job that you were elected for. We've had ample time to ask all questions. We've asked very tough questions. We've had 3 executive sessions. We gave more time than we can imagine. Yet here we are tonight, wanting to ask for more time. If they don't want to do the job, then they should resign. That's all I have to say.
And I'm willing to accept another version of that statement because it really did sound pretty direct, even though the passive aggressiveness wasn't as subtle. However, I don't think either one of us had made the claim that we don't know. I fully was aware of my decision coming into this. The new information was shared. And I think out of respect and my duty to the public, I want to have an opportunity to show the public that we truly did consider their thoughts and opinions as opposed to having a 30-minute dialogue about who's right and who's wrong. So, Director Farah, do you want to give another version of that statement?
No, I want to also talk about the public. The public really sometimes have to be very cognizant of the words that has been used multiple times tonight and even when Superintendent Israel was being hired, which was the word we don't trust. In the United States, there's a racial aspect to that. In the United States is a country that people get persecuted because of the color of their skin. As a person of color, when I hear those things, I am my alarm goes up because we know the language that's behind that. So when I hear things like that, it is very hard for me as a person of color to understand that it's coming from sincere place. When I hear a person of color being accused of not being trustworthy, there's an undertone directness to that. So when we talk about public, the public also have to be cognizant of that and be very sensitive of the words that they use. So therefore, I just want to make sure that we as a board who have been here and have been elected to do this job has to be those that are guarding the district and how it functions, not because we are here, but because our kids depend on it. Our community depends on it. So therefore, it is very important that when words are being spoken, we really have to be very cognizant of what language we use, because even our kids are listening to this. And that is all I have to say about that.
Absolutely. I want to announce to the public and everybody here today that I wholeheartedly agree, because as a gay person of color myself, speaking from the minority voice and also wanting to speak from the inclusion efforts of how do we equitably approach situations when we have leaders of color or any individual of color, that the rhetoric that's used should be used wisely, and that there are microaggressions and implications that could make different inferences. On the other side of that, I also really want to highlight that just because of some of my minority statuses, I think that there is justice and equity and fairness in being upheld to the same standard as my majority counterparts. And what I'm seeing from our experiences is that sometimes these shortcuts might be made in addition or in response to some of our leaders because of public perception of their minority status and their identity. And if we wanted to go down deeper into that dialogue, which we can at a separate time, that in of itself is not equity. And so I do want to highlight that, and I also want to, again, agree with him that these microaggressions are real and they exist, but we should also focus on how do we equitably treat and uphold our minority leaders to the same standard as our majority peers.
And I agree, there should not be any less, but we do know there's a historical aspect of this. So when those words are used, therefore, there's an undertone that is being used.
Yes, I've
And that
received a
should
lot
be
of that
said.
here.
Director Clark? My first problem is I need to correct, I misspoke the last time because I was cut off in mid-thought. The relationship between the superintendent and the school board is a cooperative one. So, and it's set that way because it recognizes that the public needs to have a place of input. The board of directors needs to be able to examine things, make decisions based on information from administration, and try and come at the best possible solution. But there are very few perfect solutions, and I am not in favor of tabling this.
Are there any additional new information comments to be made on the tabling of item number 6.02?
No.
Seeing as
I just would like to say one last thing. If you choose to go against the public, it is going to come back. And I really feel that it is fiscally irresponsible for us to play these games with a levy that needs to be passed. It needs to be passed. I'm sorry, but it does. And I want to give the public every single chance they can to meet us where we are, wherever that is, and try to reach out our hand to them and say, please come with us, help us, because they are the ones that are going to be voting. It isn't us. We don't get to determine whether or not this passes. It is the public that does. They are also the ones that provide us the authority to do everything we do here. And if we ignore them, it is at our own our own peril.
First, I would advise Director Cook not to use the dais for supporting or going against the levy. While we encourage all of our constituents to please find out more information about the levy and please register to vote, encouraging or discouraging the levy while on the dais is inappropriate. The next thing I'd like to say on that one is when we listen to our community, we've heard from many different sides of our community today, in my opinion, and we've heard many different opinions. There's not just one voice of the community.
So I guess, to me, that family that's on vacation right now, I apologize that I wasn't able to make the case good enough to sway my fellow board directors, and I apologize for that.
One thing I'll just add, on the tabling of the motion. Independent of what you do here, you're going to vote on whether to table it. Independent of what you do here, it does not change the nature of this decision, and that any discussion that happens in the interim will need to happen in executive session. A decision made by the board, yes, in consultation, and you have input from the public, which you shouldn't have to only get at this meeting. You have the ability to get information from the public at any time.
But you can't share that information, though, no?
I would imagine in your role as a board director, you can get information about the performance of the superintendent and performance about the board generally and the district throughout your entire time in your position. It's not artificially just this time in between now and the approval of the agreement. What I do want to state is this, because obviously this would not change the process. If you table this motion, we would still go back to executive session. We would still have the same conversations that we've had 3 times. It wouldn't change it. We would still have the ability and the requirement to do this in executive session, ultimately to take a vote in public session. But it is not the public's decision. It is your decision solely. And I want to be clear that all you're doing is tabling the motion gives you more time. That's true. But ultimately, the process in which we engaged in up until this point would not change. We would go back to engage in that same process.
But even if we didn't change it at all, and we just kept it static as it is, and we didn't change a single thing about what we're voting on, it would allow those that either couldn't get the time off of work tonight, didn't have the time or the ability to get involved and have their voice heard, it would give them additional time. Like, what if you work 5 days a week and you happen to work those 5 days that we've given you? I mean, I don't know. We haven't even given someone a weekend to contemplate it. And that's where I feel like we do this all the time. And our public keeps telling us, do better. And we keep not doing better. And I don't know how else to put it. I'm at a loss. I don't know how else to make people understand that it is the public that provides us our authority, our duty, and yet we ignore them over and over and over. It's the reason I ran. It's the reason I'm sitting here is because of these things. That's exactly how you ended up with someone like me, which everyone apparently doesn't like. That's why I'm here. You don't get people like me to sign up for this sort of stuff when you're doing things well. I'm sorry you don't. I don't sign up to do this because things are going good. I'm not interested in politics. I have no interest in continuing if I am able to make the difference that I think I can. I'm done. That's it.
Yeah, and I think that comment was a little damaging, and then I do invite you to maybe reiterate or provide clarity because the way that I took that was, regardless if we table this, everybody's mind's made up, and regardless of the public comments, that's not gonna be taken into consideration. So I know PR is not the strong suit of this district, and I think I'm presenting remedies into how we can reverse course and be in alignment with how do we shape that, how do we restructure and help rebuild and regain the trust of the public. This is not the way to do it.
I will rephrase Director Song. My intent is not to engage in any PR conversation. My intent was solely to give you legal advice. I have no value judgment whether you table or not. Whether you table right now makes no legal difference in terms of what your obligations are. I make no value judgment. My position and my opinion on that is silent. I don't have a position on it. My comment was solely based on what the expectations of the process would be if you do table, which would be what would I do next, which would convene an executive session, have a conversation, and that it doesn't change the process in which we undertake. So I will clarify that is what my intent was in that conversation and that point that I made, and that we would still need to engage in this in executive session, in private, with questions posed with the board and myself present in order to answer them, much like we did previously. So
Thank
I
you.
will revise my statement, and yes, I'm not a PR expert, so I will take your comments with criticism and agree.
And again, my gaze is directed in that direction.
understand.
That was a general comment. I'm sorry, I wasn't saying you specifically. But yeah, that would be just my final comment to the board is, do we want to show the public that everything that they just shared tonight meant nothing? And if in conscious, in your values and your philosophy, that is what you want to uphold, you are within your rights to display that to the community. For myself, I can't without providing the community another opportunity to show that we have considered their comments in more detail, because a lot of these statements were given to us, and sometimes it's really challenging to come up with a response on the spot. I think some of us have experienced that and displayed that tonight. And so by doing this, we would be able to promote the role of inclusiveness and the role of collaboration that we spout all the time. So I am ready for the vote whenever the rest of the board members are.
I have no more. I have no further comments.
Seeing that there's no further comments, we have a motion on the floor to table item number 6.02, superintendent's contract, to the next public meeting. All those in
Can I ask for a roll call vote, please?
You may, and that is granted. Director Song?
Aye.
Director Cook?
Aye.
Director Clark?
No.
Director Farah?
Nay.
And nay, the motion fails 2-3. We are now in open discussion again for item number 6.02, superintendent's contract. Is there any comments? Director Cook, or Clark, I'm sorry.
I have a question for Superintendent Bella. Am I sorry?
You used his name.
You can use his name. The comment earlier was in light of the contract is with the superintendent. And so, but addressing him would still be appropriate to address him by his name, which is Superintendent Bella.
Okay, so if I'm not mistaken, you belong to a national association of school directors, and if I'm also not mistaken, you have a leadership role within that organization. Could you explain that to us?
I am a executive cabinet member of the WASA Association. So.
And the National Association?
The National Association is one that I'm automatically on, not a board member for that.
And I'm sorry, WASA is the Washington
Association of School Administrators.
Thank you.
And Hispanic leadership among educational leaders?
Yes, I belong to ALAS, which is also an association that's our Latino administrators.
And that requires your having to go to places and speak to people. And I would assume, simply from that experience, it gives you a broader contact in terms of innovations taking place throughout the schools of the nation, and whether in fact we are beneficiaries of that.
Absolutely.
Okay.
Director Song, any questions?
No, I mean, I have comments. I think his civic duty and engagements and community collaboration is going very well. I have to commend that, and I think that deserves praise from the community. I mean, it sounds like there's a lot that you're engaged in and involved in, lots of mentorship. I mean, we're paying for mentors. We're looking for a mediation into this contract to help bolster some of the skill deficits that are in existence. But even with all of that and with the time, I guess I
I would just like to hear some comments on our honestly laundry list of just failures and under-delivering of services to our KSD community. I think it's one thing to isolate a lot of the accomplishments associated with those organizations, some of which seems like they're just automatic. But with all of that support, with the years fulfilling this role, I'm still hesitating because there's so much in here in terms of lawsuits, misinformation, management questions about who are we putting into some of these leadership roles, and some of the guidances have led us into the litigations that we're currently facing. And so my hesitation right now is more on a lot of the deficits that have come into light within my year of being on this board. And I think it's fair to not only highlight a lot of the accomplishments, but we should also take into consideration and have some discussion on what are some of the remedies, what were the causes and reasons for these, and is a increase in some of the benefits and compensations, are they justified? We heard from one of the comments that the scores have gone down over the time. The ratings have gone down. The amount of fiscal, I guess, oversight that's occurred is something that terrifies me, seeing what's happening in other districts. And with the current trajectory of the poor guidance that we've had, it's hard for me to see what how some of the positives in community engagement outweighs the performance of our students, the fiscal nature of our current budgets, and then the decisions that are made by some of the leaders that are appointed by our superintendent. So I would like to hear just some feedback on that, because I want to make sure that I'm not voting based off of a bias of what I've collected. And so this is a time for us as a board to discuss. And I think this is a great opportunity for the other board members to help me see another side to this, help me rationalize and understand from your perspective of why we think extending this contract is a good idea.
So before you do, I'd like to ask Mr. Leonard to address whether this is a partially part of the negotiation process. I caution the board on that.
So, Superintendent Vela, I appreciate the question. Ultimately, the question as to whether to extend the contract is appropriate for discussion. I would ask the board to refrain from any conversations about specific negotiations, provisions, in part that were shared in the executive session. But to the ultimate question on the board, which is whether to renew, that conversation and discussion is appropriate for open session. But I would ask you and direct you to not have conversations about provisions that were in attorney-client privileged, that were in executive session, about negotiations that occurred, and those pieces should stay in executive session. Also, there are provisions related to the superintendent's performance that I get are part of the evaluation. I get that. Ultimately, we've heard positives and negatives, and the door to a certain extent has been opened in regards to that. So we can't just say, we're only going to hear one side of the story. So I get that we have, at this point, a bit of a forum to hear, what is happening now in the district. And so from that perspective, Superintendent Vela, there is, I think, an appropriate question in front of the board as long as the information that's attorney-client privilege stays in executive session.
May I ask a clarifying question on the rubric used in the evaluation? It has been brought up a couple different times about the scoring, and while I don't want to comment on the particular scores, but the methodology of just the number itself, can I speak to that?
That information related to the superintendent evaluation is done in executive session for a reason. And so those details shared about the superintendent's evaluation and the rubrics and that information should remain in executive session.
Okay.
Can I ask a follow-up question? So can you give a legal reason why we provided the evaluation from 22-23, but now you're telling us we shouldn't provide the evaluation for 23-24?
So
From a legal perspective, that is.
I don't know if I've advised that, Director Cook, and I would feel more comfortable having that conversation not in public
Are we
because
able
of
to go into-
attorney-client privilege and potential for litigation.
Are we able to go into executive session now so that we can discuss it?
We can certainly have that conversation. I have not advised related on this, and I'm not going to give legal advice in public related to this issue.
Okay, thank you. Are we able to go into executive session so that my questions could be answered?
I would like to say
Can
we have something on the table, and we should decide
Yeah.
the topic that's at hand. I believe that these questions have been asked and answered before today, and I don't think that those answers are going to change.
I know I haven't asked that question, and I'm not allowed to know the answer here. Executive session is the only way I could, is that correct?
We've had conversations about this. You've asked me that question before, and you and I have spoken about the superintendent evaluation on more than one occasion.
I didn't ever get a, law reason why it was okay for one but not the other, and if you didn't provide the guidance for them to release it before, I know I wasn't consulted to release it, so the board didn't release it as a board, so it was decided by someone. I don't know who released it the first time for the 22-23 review, but it was released to people that had litigated it.
As somebody who has been part of executive session, these questions have been asked and answered. These exact questions have been asked and answered.
Okay, well, I guess you have a different memory than I do. I apologize if your memory is different than mine.
Sometimes, even if we don't like the answer, they have been asked and answered.
I guess just going back to my question is I just want to hear another perspective because I have my lens. But again, I want to make sure this is a well-informed decision. And so I invite my fellow board members to share their thoughts on 6.02.
Director Clark?
Okay. I have to say, I'm a little unnerved when I hear a board director sounding like he is speaking on behalf of the community as if I was not speaking on behalf of the community. So I'll just illustrate that in two fashions. One, if I'm not mistaken, I am the only board member that's been to all 44 building sites while they're in session. So that means I'm observing the community at operation, I'm observing the instructors in the classroom, I'm talking to the administrators. But I make an effort to try and get out, particularly to see the various different things going on. So you guys have been very good about, for instance, going to plays and so forth. And Megan goes to every swim meet. But the fact is, I'm going to a wide spectrum of activities out there to observe. And so I have to believe that my conversations are valuable with the community too. So I'm telling you from my perspective, it's not perfect in terms of how the 5th largest school district in the state operates, and it certainly doesn't have all the supports that it needs given the population that it's serving. So it's not perfect. But what we have to try and do is create incremental change as we can come up with the resources to try and do that. Now, the reality is, what's the guidance for the district is the strategic plan. And the strategic plan is a long-term plan. It is aimed at improving efficiencies at all levels among all those that participate. And you're correct in terms of we need to work on the community relationship because that, well, we've had conversations about that, so you know that that is a priority for us. But the point I'm trying to drive home is the strategic plan has incremental guides to measure success
And the question is, if you are working towards making that plan work, you have to make adjustments. But it was the superintendent's leadership that made that plan possible and long-term leadership to make it successful. And that's exactly why I'm gonna go forward, because I believe the school district is working as hard as it can. The teachers are doing a great job. The point is, we have to continue to work in mitigating the factors that aren't working. But with that, I still want the superintendent.
So can I just recap that just for myself? You're in alignment with, we need the continuity, the consistency, and ensuring that we have a leader at the top who can kind of carry us further. And you're approaching this from a more long-term perspective.
Yep.
Okay.
I would say that my evaluation would be similar in that consistency is important. As a mom, I've always looked at, we have bedtimes at certain time, we have family dinner at certain times, and we have what our family norms are. And as a district, I've appreciated the strategic plan that we have had. I've appreciated the programs that we are starting to implement that go in support of that strategic plan, and the progress that we're making towards those. We are starting to see some of that come to fruition. I also believe that we have headwinds, and in no world would I say that we are perfect people, that we are a perfect district, that we are perfect in any which way. But what I do say is that there is a desire and a plan that I'm in support of for getting towards better and continuing that process of continuous improvement. And, you know, would somebody else do it differently? Would I do it differently? Maybe there's a couple things I would have a bigger focus on or a little less focus on. I mean, I can tell you, I would love to see more high cap. That's my thing. But we all have these different priorities. And it's a world of competing priorities and emphasis. And in the end, I like where we're going. And I feel like the partnership that has been offered with the superintendent and us collaboratively trying to do that together, I am happy with that process. I would also say, sorry, I lost my train of thought on this one. There was a couple words that I wanted to just make sure that there was correction in there. Professional development does not mean skills gap. Those are two very different things, and so I want to make sure that we put that out there. Professional development, if you're not growing, you're dying. And so we want to continue to invest in the people that continue to grow us. And so you have to put that investment. And so that is part of that. So please don't equate professional development. That's what I thought I heard. If that's different than what you intended, my apologies. But that's what I thought I heard a couple times.
Yes. So just to add clarity on that, when I mentioned the skill deficit, I was talking about as a superintendent and being in a leadership role to collaborate with your team. I feel like that's an area that is a deficit. And rather than working towards ways to remedy that, I think putting in a mediation clause into a contract is more of a scapegoat as opposed to addressing that skill deficit and incorporating professional development to learn how do you better interact and collaborate with your board, as opposed to how do I put something into my contract that's going to give me a little bit more protection. That's what I was referring to. Professional development, absolutely. We all go through it. I go through it in my field. And so hopefully that clarified.
Yeah, thank you. I do appreciate your clarification. I do disagree on, and this has come out tonight, that the mediation, again, I feel like is a concession that is appreciated from the superintendent, from the contract that exists. I feel like it puts us in a better position, and it gives us at least an additional opportunity before a judicial remedy to a conflict. And hopefully, one that we would never have to go towards, and we've been able to, in the last 2 years, since this was put in place, not have to. So that is mine. Director Farah?
I really have nothing to add.
Yeah, I thank you. I think all of that was very well said. Again, I don't want to make decisions from a place of bias and discrimination. I have my experiences, the lived experiences I've had so far that kind of help shape the way that I'm considering the contracts. And so I wanted to make sure that I at least allowed myself the opportunity to hear the other side to where I'm coming from. Because I think when we make a decision like this, we have to put our community first. And installing somebody into leadership is a really big decision, especially if there's 3 additional years that we're going to be committing to. I think our superintendent has done a lot of really great things. I think he's really pulled us gradually into a better direction from prior administrations, from my experience and from what I've heard. His willingness to engage with the community, I think, is beautiful. I hardly see that in a lot of other leadership roles, not just in school districts. But as an individual, I also acknowledge that I have my own capacities and limitations. And unfortunately, I continue to hold this belief that I think we've exhausted the capacities that our current administration is able to provide. And I think our district does deserve to have additional considerations for how do we advance our district and community forward. Not to say that somebody's not good enough. I think we all have our limitations, and I think we've reached that ceiling. And so I guess where I'm coming from is I'd like to see the option of additional administration that might be able to take us in another direction. I just haven't heard otherwise. I think a lot of the negative experiences and outcomes I've experienced and observed so far on this board doesn't outweigh the civic engagement. I think our superintendent has a beautiful heart and passion, but in terms of our growth in education as a district, as a community, I think we just need something different and innovative. And so that's where I'm currently at.
Can I, just one clarification, 3 additional years, it's technically 2.
Sorry.
Yes, I just wanted to
the
make sure that.
remainder of this one.
Yes,
yeah, yep.
correct.
It does reach back to the July timeframe though, right? So it's a 3-year contract.
It's a 3-year contract, but there's already an existing 1 year in place. So when the comment was made that 3 additional years,
Yes.
It's only 2 additional years, 3 years total from, including this year that's part of the existing contract. That's what I was just making sure. That
2 additional
I just want to
years.
make sure I understood it.
I misspoke.
Appropriately.
Yeah.
So one thing I was wondering, so I don't know if I would ask this in executive session if I could. We weren't provided all of the data. Has that data been gathered yet? Like the data that we weren't provided when we were doing the review because of timelines?
Anything that had been asked over the last 2.5 months, and Mr. Leonard, if you wanted to speak to that, I think the questions came to you directly. And so if you would like to.
I'm not asking if it's been provided like in the past. I never saw it. I'm just wondering, have we had time to get those data points? Because when we did the review, we didn't have all the data points. We had stuff with asterisks and stuff that said we'll have it at the end of the year. Or
The review of the
year.
contract?
No, the superintendent's review.
Oh.
There were just data points that we just didn't have at the time. And I was just wondering, do we have those now? Or?
And so that is one of the interesting things about superintendent contracts and any review, right? Is that there's always data that is, you're kind of chasing it, right? And that was acknowledged. And so when the review was done, it was done at a point in time based off of the prior year. And as every year has done, so then the next year would be part of that. I think that I'm not overstepping information on just talking about a review year.
So to answer that question, and again, refraining from executive session that was done for the evaluation process, What I will share is data that is summative in nature or formative is different. Example, the state continues to finalize current ESPA data, as an example. That data continues to be cleaned, et cetera, et cetera. That is what we're referring to in the process of assessment, and we look forward to coming back to the board as the board talked about work sessions. Recall the board asked for assessment. That's something that we'll further dive into. In addition, we do have progress monitoring data. You mentioned the iReady piece and those kinds of things, so I can say broadly that those are forms of data to answer your question.
Are any of the data points that we were missing when we did the review, are they available now after the past 4 months?
As I mentioned, the ESPA data is still getting clean, so
Well, that's
that will
one.
be part of that. That's forthcoming.
That's one piece, though. I'm just asking, is there literally no additional data that's come up in the past 4 months?
I can say we have data.
We're always in a process of getting different data from different points.
Wouldn't you
Because
want?
next month, we're going to have the back to school iReady scores, right? And those ones won't come out. And then we never just stop and wait for everything to come into us,
No,
right?
but I'm just
and
saying,
so there always
and-
will be more data. So that would be part of next year's evaluation, just as this year had the data from the previous 12
Oh,
months.
I'm not suggesting we change the review. The review is set as it is. I'm wanting information so that I can make an informed decision as to whether or not we should continue the contract of our superintendent. I'm asking if the data that we didn't have then is available now. I feel like it's a simple yes or no.
I think I answered the first part on the ESPA data. The other example I'll give you is, as you know, we had summer programming. That data is still being finalized and gathered so that we could come back to the board on a summer program that'll include credit retrieval. We also targeted students for literacy. So that data is forthcoming as well in a presentation that we have set for the board.
Okay, not to belabor the point, but I just need a yes or no. There was a data that we did not have. You had asterisks in there that said, this will be provided at a later date. I'm asking, is any of that data that we did not have when we did our review, because I have not been provided it, whether you think I did or not, that data, is there any of that data available today that we did not have during our sessions for review? That I just need a yes or no.
So again, I'll answer. You got the data.
You're using a
that
lot
you
of
had.
words. You're not saying yes or no. I'll say.
Please allow him to answer, though.
Yeah.
He's trying to answer your question.
Okay.
And I answered the first one. I gave you examples of what's forthcoming. You had the data that we had to date for that process. You will be getting additional data as it becomes available.
But you
So
don't have any more today.
It's a yes and.
So yes, you do
Correct.
have more data,
Yes.
but you're not giving it to me today.
That's correct.
And
Yes.
okay, and this board is okay with that we didn't get provided that, and you all, okay. I just wanna
Because
make
we
sure
did not
that-
have it. Yes.
I understand. So I feel like I'm still at a deficit, but that's fine. That seems to be a trend here. I don't understand the metrics that the, I guess, pro side of this are using to warrant the multiple tens of thousands of dollars in increased compensation. Now, granted, it's not salary, I understand that, but it's written in there in the contract that there's additional benefits, which is all just different words for what you get for working here, whether that's one type of benefit or another.
So again, I'm going to ask Mr. Leonard to speak to this, please.
So the process in which the parties engaged in negotiations, there was a back and forth in negotiations.
I'm not asking about anything that was discussed. I'm saying if they could point to what it is that they believe has been done in this district at all that points to why we should be increasing pay and increasing benefits of some sort. Well, it's not pay, but benefit package altogether. Because as I've understood it, I looked up some of the other districts' superintendents, and we're getting close on the top end of that as far as how much compensation is provided. And I mean, it's darn near the amount that the President of the United States makes, which I would imagine his job is a little bit tougher. And so I just wondered, like, what is it that you've seen, like the shining golden metric that you're seeing that says, this is why I think, and I'm not saying executive session, I'm just saying like what you've seen in your own reviews of how things are going, or even, you know, if you have community members that have brought things to you, either or, just information that you have that would maybe sway me towards that direction, and I'm open to it.
I hear your questions, and there was many in there, and so let me see if I can go through them. First, talking about the superintendent and increases within the contract. What I would say on that one is I feel like many of the answers I'd want to give, I can't give because they are part of executive session and part of the negotiation that went in there. As far as the superintendent's performance, I also would point towards we had a very collaborative sessions for the superintendent evaluation, and I feel like any of those questions, we've had very frank, very open discussion about that performance, and so I feel like that those questions have been asked and answered within that, and we came to a consensus on everything that we put into the evaluation, both in scores and in comments. And so, so that would be, so I would point towards that as far as the superintendent's performance. So the contract negotiation, again, I feel that there's, I would have in the last 2.5 months been very open to answering any of those questions about why specific travel this or that compared to the, yes, there is very good and thorough reasoning on all of that. This is not the place to have it.
Okay. As far as the consensus piece, you know, I agree we came to a consensus. I found out afterward, looking through some of our vouchers, which are public information, it wasn't shared in any private place, that our superintendent is paying $50,000 to the mentor for him, but also he was acting as mentor to us. And I didn't know that. I did not know that he had a conflict of interest in getting paid by the signed check that was signed by the superintendent, as opposed to a $50,000 check that was approved by the board, because I don't remember approving it, and maybe it was approved by a previous board. I don't know. It's possible. But I didn't even know that. Like I didn't know that he was getting paid in the first place, and if he was, how much it was, or who signed the check, or whether I approved it. I don't remember approving it. The voucher came out after, so I felt like to me that was very, it felt very like off to me. It didn't give me a good feeling after that. And so even though there was consensus, after that point, there's no way I would have had consensus. I would have never agreed with that, because I believe in having advisors that are completely separate and should not have any influence as far as like, he's also advising the superintendent. He's also getting paid by the superintendent, like these sorts of things. He's also only ever been a superintendent. We didn't have any other former board directors or board directors that are actively board directors in other districts come in and talk to us. Like, I don't think that's private information that we didn't have them. But to me, that's who I would want to talk to, is other people that have been on the board. And I know you know, Director Farah had mentioned my own, I guess, naivete, having only been here for a little less than a year now. But none of us have been here past one term. So, I mean, you've had other terms, but not consecutive, correct? Okay, and that's correct for everyone, right?
Director Clark, how long have you served on the Kent School District Board?
I'm in my 7th year.
Thank you.
Not consecutive though, correct?
Yeah, that is correct.
Okay, and when was the last time you were on the board?
2013 to 18, I guess.
5 years?
13, 14, 15, 16.
Okay.
Right.
And that's fine. I'm just saying that outside of you, all the rest of us are relatively new. I mean, even 4 years doesn't seem like a ton of time. And I mean, having between 16 and, I don't know, whenever you were elected, I think 2019, you know, that's some differences there. I don't know what led to your opponent ending up taking over for you. But like, I don't like to speak to those things, because to me, it doesn't make any sense. Like, whether you're new or you've been here a while, guess what? We all have the same vote. So it doesn't really matter if I've been here for 10 years or 100 years or 1 year. All of it's the same, because we need to get to the point where we feel comfortable making choices. And I mean, I guess I just have to continue saying that I don't feel comfortable making choices with the information I'm given. And then when I say that, it's ignored. And I mean, that's okay, I guess. It just feels off.
And President Margell, my biggest resistance right now to wanting to move forward is I did send you and council an email regarding a question, and it was publicly shared, and so that's how I came about it. When we talk about things like good faith, this is where I draw my hesitations and my boundaries, because if indeed that was true from the email that I sent you guys, which I still haven't received a response, I sent it, what was it, Friday, Monday, I bumped it yesterday, still no response.
I responded to it, and I directed you.
Yeah, you said to ask our council, and then I did, and I still haven't received a response. But they were informed on Monday and on Tuesday. And for me, that's the biggest sticking point on what's going to help guide my decision, because it's really
And
disheartening.
just to be clear, that question had nothing to do with superintendent contract.
That's where I'm trying to get the clarification. And that's why I'm tiptoeing around the details, because if indeed it's true from the allegations that I presented to you and council, that's where I feel disheartened about my continued ability to trust in the leadership. And that if in fact that was intentionally manufactured in order to be utilized at a later date in time for other reasons that's not listed, to me that seems very very manipulative. And if that's the type of leadership that we're going to be supporting, then I just want to make sure that, one, I'm making the right decision and not making a decision based off my assumption of what I received from the public. And I know this sounds very cryptic, but again, I don't want to violate our executive session. And so that was a long way of me asking, could I get an answer to that now, since I didn't get an answer to my emails that I sent around 6 in the morning, both times, to give ample time?
I think that I would be happy to stay after and have a conversation with you. Absolutely.
I would need that information before I vote, because that's what's holding me back. Because if indeed that's the question that I asked is true, that is horrifying for me. And I don't know if the other board directors have an opinion or thought on it, or if they even care if it's true. But for me, I'm very values-based, so I want to make sure that I'm also voting in conscious and in alignment with what I believe is right.
I hear you. Right now, we have an open item. I am happy to talk to you about it. I absolutely feel like the answer would alleviate any concerns. I have no doubt on that one.
Do you feel that the district or you or legal counsel has had enough time to make that, to answer his question? Or do you need more time?
Can we ask Mr. Leonard to answer the question if he's able to?
I think that the topic at hand is of ongoing litigation, and this would not be the appropriate venue to be able to speak to it. And so it would be a conversation that would be appropriate for executive session, and that's why we are.
Can we break into executive session now, so for 3 minutes, so I can get that answer?
I know this board's done that in the past. I know Director Farrar had I guess, a bit of a personal moment and needed to step away, and they excused themselves, or you excused yourselves to go to executive session. It seems like this is at least as important as his feelings.
I don't remember going into executive session at that time.
Well, I'm requesting, can we go into executive session for 5 minutes so I can get a response to this if you're unable to provide it at this time?
So I think in order to go into executive session, we would need to appropriately note the time to go into executive session. I don't think procedurally there's anything that prevents that. You don't have to go into executive session. You could have that conversation in the hallway as long as no one else is there. But here's what I'll say. There's nothing that would prevent you from entering into an executive session. You do have an issue pending on the table. So at some point that needs to be resolved.
Yes, and I think this would help if I had some clarification. So I'm requesting for us to go into a brief executive session so I can get my answer to this, since it wasn't provided prior to this. And I believe 2 days was ample time. Because when I request information, you guys told me it's ample time when you send me an email at 6 a.m. the day of.
And this is a decisioning factor. I mean, please take this from where it's coming from. This is the decisioning factor because I'm also thinking about if it's not going to make a difference, then we can answer at any time. But if this is a decisioning factor, I am absolutely willing to do what that helps to make that decision one way or another. And I'm confident in the answer, so.
Can I ask a question then on that? Why are you entertaining his request to go to executive session but not mine?
Your question for executive session, and I'm sorry, this was a while ago. What was it specifically regarding?
It was regarding the information that I didn't receive that I was going to ask a little bit more detail from our lawyer.
Oh, the reason for that is because it already was asked and answered.
Well, okay. I guess I don't feel that that's the case, but I guess that's okay if you don't care.
To answer your question, this would heavily influence my decision based off of the response that I receive.
It is 10:09. We are moving to executive session for approximately 3 minutes. At 10:12, we have decided that we need to have a few more minutes to be able to connect in Director Farah. So we are extending another 10 minutes to 10:25. 6:28, and we are resuming from executive session. We are currently in open discussion about item number 6.02, superintendent's contract. Are there any other board member comments or questions?
I assume that there was nothing that we can share from what the executive session was discussed. Is that right?
Correct.
Okay, I just wanted to make sure. So I still feel like I haven't heard the argument for why we are providing additional compensation beyond what's already there. And I still haven't received, that other data. I mean, I know we voted down the extension or whatever, so I just, what is it that makes you feel like, and not you individually, but the other board members that are planning to vote yes or feel in the pro side of this, what is indicated to you that we are better today than we were 2.5 years ago or whenever the contract was first signed?
I would just like to say, I don't believe that there is a pro side or there's not sides on this one. I really don't believe that, but that's also been said a couple times, so I would just like to make a clarification personally. Being grouped in as a pro or a anti does not feel right for me.
I apologize, I wasn't meaning anything by it.
No apology needed, just going forward. Director Clark, did you want to answer?
I believe I've already made my statement. This is about long-term stability in the district with a plan that has been agreed to and approved by the board to basically make us more efficient and successful.
What was agreed to by the board? Just curious.
Strategic plan.
Oh, but this board didn't do that, right?
We look at it
we
every
discussed
year.
it.
It was in place.
Before
Yes,
we came
before
on
you
board.
came, yes. But realistically, of course, it was formulated with leadership from the state. So in fact, all the I's were dotted and T's were crossed.
I also feel like the question's been asked and answered. I think I've articulated several times my feelings on this.
Here's what I would state just from the negotiation, knowing that I cannot share in open session the contents of the negotiation. But I will state this, that like any negotiation, there's a back and forth. And there's things that are requested, compromises made, and things that are said no to, and a back and forth. And what you see is the proceeds of that back and forth conversation, of concessions made, and those, some of that information or a lot of that information was shared in executive session and with you individually about that process.
So just one question about like your experience with other boards, and this may just be again like that I have only been here for a year, and obviously this is the first time that I've had to do this. What is the normal process for how you choose whichever board member is going to be the point person for this? Is it just always the president?
Generally, yes. In my experience, it is the president. Yeah, that's generally my experience. I don't have all 5 board members engaging in that conversation, to be honest. But I, like in this case, would want to bring all items for discussion in executive session at a future session. And that's what I believed what we did in this case.
I see. So like in the cases that, like you're saying, this was generally the case, in the cases that it wasn't the case, how did they determine, or I guess even the ones that were the case, how did they determine that the president was the right person to go into that space?
I'm going to state and take away the generally and state in all cases, my belief is that the board president is my contact with the board in these conversations. And not say generally.
Do you happen to know if there was ever like a vote in public to decide that person, or is that just like, because I don't think it's enumerated in the president's responsibilities, so it's not a position that's decided on its own by itself, written in policy or anything, as far as I understand. So to me, it seems like you would have to have the board decide, because we can't do anything by ourselves. So if it's not done by the board as a whole, then how is it decided?
Well, first of all, the way the system works right now, the board president is the spokesman for the board and is in fact responsible if there is something that needs to go back out to the board, responsible for that. Well, that's the same point in the leadership of trying to negotiate the contract. It's the same thing.
I agree with your fundamental point that it's a point well taken that certainly as negotiating on behalf of the board, I want to make sure there's a majority position. I don't want to take one person's position. And so in circumstances where if I felt like there wasn't a majority position, I would try to clarify to get that.
Can we take a 5-minute recess? I'm diabetic and I need to run to my car and take my medication. I'm not feeling well right now. So can I, or I mean, you guys can continue, but do you mind if I step out real quick and come back?
You can always
or-
step out, absolutely.
Okay.
Are you okay? Do you want someone to come with you?
Yeah, I just need it and then I'll be fine.
Okay.
Yeah, so just wanted to stop you.
Are you fine with us continuing?
Yes, if you guys
Okay.
wanted to continue,
Yes.
absolutely.
Thank you.
Just know if you guys go into the vote, if I'm not here.
Okay, thank you.
Can I say something?
Of course.
Can you guys
The
hear me?
board recognizes
Yeah, I just
Director
wanted to also add on what has been said about the decision making that has happened with the contract and all. The board president did not make any decision. The board president had spoken to our legal team and then brought those things to us, and then we made a decision on that. So there was no decision made before we decided that this was the contract that we wanted to bring forward. So I just wanted to add that to what has been said already.
And just to clarify, no decisions were made during executive session. It was a proposal that is brought and then brought here for final decision. We never had a vote, we never had,
But
We've discussed, we've had our questions answered, all of it. And then now here's the culmination of what is been going on for the past for I think 5 weeks, and the community has elected us to make this type of decisions. The community has tasked us to say that all of us can sit there. We decided you to be the one that represents and speaks on our voice, and that's what we are doing. Each one of us is sitting there because the community feels that we speak on their voice. Each one of us has been elected to do that. Not one single director, not one individual. No, we all have been elected.
Well, I understand that. I guess maybe I phrased it incorrectly. I'll ask a question instead. President Margell, when did you know that it was you that was going to go do this?
In a discussion with Mr. Leonard.
So
I guess I probably had an idea that it was going to happen because the board president last year was the one who brought it. And it was my assumption that every other year it has always been the board president that has done that. So last year was the board president brought up the discussion and worked with the attorney at the time to work that out. And so through process, I guess when I was elected by the board to be the board president this year, I guess at that time I knew I would be my full answer.
Okay, because I guess my point to that is some of us here up on the dais have had a vote of no confidence in them by all of our unions, essentially. And it wasn't myself. You were the only one, as far as I know, that they had come and voted no confidence in you. So it kind of, like, if it were me in that position, if I were in the same position as you were then, I would want to make sure that everyone on the board was in agreement on that, or at least that there was a discussion. I guess just to make sure that I was the right person to put in that place. And I know I wasn't ever like asked or any of that until it was already brought to us, after however long it took to get to the point where you brought it to us. And so that's where I just don't know, where did you feel that, other than anecdotally through another board president, how did you know that it was you that should do it?
Again, through the expertise of Mr. Leonard, who's worked with a variety of school districts, advised because he has always worked with the board president. I would also be happy to continue this conversation because I don't know if it is relevant today in the discussion of the item before us that is currently discussed 6.02, because again, while the beginning of information might start with one person, it was 100% available for comment by the entire board, and of course then is here today for voting on by all boards.
So when the previous board had gone into this same situation, and correct me if I'm wrong, but you weren't involved in hiring the superintendent, correct?
Correct.
So how did you know about that, if you're saying that, because you weren't here, so how did you know that?
We're going into the third year of a three-year contract, so last year would have been going into the second year.
But you didn't renegotiate a contract ever, right? And there was no contract that was negotiated during any time until now with you on the board. Is that right? Am I understanding that correct?
Don, if I may.
Yes, sir.
I'm in my 7th year. It's always been the board president.
But I'm not asking that. I'm asking because you said you knew because the previous board president. So did he break privilege and tell you this?
No, we were an executive. I mean, every year we have this discussion. Every year the contract is something that can be looked at.
It can be, but it wasn't, right?
I can't share that with you because that was part of an executive session that.
Well, there's no new contract. I mean, it's plain old, it just isn't there. So if it was there, then you could say, yes, I was part of that, but it wasn't, so you can't.
I'm not able to discuss what was discussed about the superintendent contract in executive session.
Well, you wouldn't have been in executive session when it was discussed. When the first contract was signed,
So Don, I'm
you were not
telling
on the
you,
board. And
it
you
was-
said that you were
we
there and
cannot
you knew
discuss
because
it.
the president had done it at that time, but you weren't on the board. So if you knew that, I'm like, how did you know that?
Question's been asked and answered.
You guys move at all. I'm like, wait a minute, what's going on here?
I'm glad we brought you back.
So could
Thank
you,
God.
Mr. Leonard, I apologize for interrupting you to get the reconnection back. If you could reiterate.
Yeah, so the comment I was making was related to the process in which not only do I normally, but my understanding of, and I won't speak of all districts, but that it would be extremely confusing and we wouldn't be able to meet all 5 board members in negotiating a superintendent contract. So we deal with a point person, and that point person, for all intents and purposes, has always been the board president. Now, I would agree that I would want there to be consensus. I would want to make sure that when I'm talking to the board president, that there is a shared understanding of what that consensus is. That is a fair point, Director Cook. And part of the reason why we then convened in executive session on separate occasions over the last period of time was to make sure that all board members, not just the board president, ultimately had input, feedback, and the ability to ask questions related to the superintendent's contract. And I will tell you that even those initial meetings of the negotiations, without going too much into specifics, the majority of that was we only brought you the things that we considered. There were things that were no's, that were not doable, that were just not brought to at the initial kind of view. And you have a question about that?
Yeah. How did you know that they weren't acceptable?
Based on our conversations with President Margell, based on our review of comparable districts and other Puget Sound ESD contracts, there's a lot of work that happens associated with this on the front end. That happens.
And the board, right, like as far as I understand this, and correct me if I'm wrong, none of us can do anything by ourselves. So we can only act as a board, right? And so the authority to do these negotiations is given by the board. Is that correct?
That certainly is correct.
And a single board member would not have that authority, regardless of whether they're the president or vice president, any number of different kinds of being on the board.
I would disagree. An individual board member would have the authority to negotiate. They wouldn't have the ability to approve the contract.
So if I decided to go and do that on my own, that would be okay? Or is it because they're the president?
I would say if you were the board president, I would have operated in this exactly same manner because you're board president.
So where does that authority come from, though? Because, you know, it's not written in policy, it's not written in law, it's not written anywhere. It just is, I guess, an unwritten rule? Is it?
I wouldn't say it's an unwritten rule. Not every rule of board governance is in writing.
Mm-hmm.
I would state that that the board, through its practice, through its norms, through the course of doing business over the course of decades in 295 districts, that has been established, even though it's not in writing anywhere saying board president has this. I'm sure, while not in your board packet, there are guidance that I've seen from WASA and WASDA and other places in which it recommends that that happen with the board president. It's based on recommendations from many organizations that do recommend that this be the board president.
Are any of those organizations or yourself, are they elected members of this board?
No.
Okay, I just wanted to clear that up. So this board didn't authorize it, just others did. And you wouldn't have authority to do that, nor would anyone else outside of the 5 members of this board. Is that correct?
So would I have authority to basically state that who has the authority to negotiate the contract?
Because you decided, you and our board president decided that amongst yourselves, because I wasn't consulted. Maybe one of the other board directors was?
So I've never seen a resolution in any board that authorizes that the board president have that authority. So, and I'm assuming that if we check the registry, there wasn't a board resolution done in 2021. There wasn't a board resolution done in 2018. There wasn't a resolution done in 2015, in 2014, or any other times the superintendent contract was up, because it was always the president.
So we're beating a new path here.
So, well, this would have been the same process in which was undertaken in the past. There was no change.
And, you know, just because they did it wrong for the last 100 years doesn't mean that they aren't wrong having done it the wrong for the last 100 years, correct?
I'm certainly not stating that anyone has done it wrong in this district or in the 294 other districts in the state of Washington that does it this way.
And so you can say for certain that 295 districts all don't talk about it and don't actually come to a consensus?
That's not your question. Your question is whether or not the president has authority to engage in negotiations with the superintendent. And that question, I can say definitively that the superintendent or the board president does have authority. As to whether or not how they reach consensus is a separate question.
So could she do that tomorrow after we vote?
Can she do what?
Start negotiations again.
Can she start negotiations again on a contract? No, because the contract can only be for 3 years. So no, she can't.
But it's a day, so you could do 3 years and 1 day. So you could change it, no? Theoretically.
I don't see that as a viable or logical conclusion. And if it extends, the contract cannot be beyond 3 years. I do know that. So I would not support anything that would extend beyond what we can contract for.
So in like 90 days?
Let's just say a year later. Okay.
So a year later, it could happen again, and the board doesn't have to be made aware at all.
Director Cook, at this point, I'm hearing you, and I would say that at this point, knowing your position on it, I'd probably sit down with you and have the conversation. Guess what, Director Cook? We're going to do what we've done in previous past, which was President Margell, and my prediction is we wouldn't do anything different.
And so my question on that point, what has this board shown you so far from my swearing in on December 13th up until the day that you met with President Margell led you to believe that I would agree with them on just honestly many things, but did it seem like we were in consensus in almost any way in any other capacity?
I have no idea.
So you base that on what then? Like because you're saying now you wouldn't do it. So now you have an experience that has shown you otherwise. So what was your experience that showed you that you should do it that way? It's just because of norms?
Because that's the way I normally operate.
Okay.
And I hadn't have a conversation like I've had right now.
Yeah.
And so in my role, knowing your position now, which wasn't available to me prior, I don't know if you even knew that, to be honest. We know that now. I can only operate on the information that I have now. Okay?
Yeah.
I had no reason to suggest in May that anything should be different than how we've always done it.
How long
And
does
so-
it normally take a negotiation to come to fruition and then go from that negotiation between the board president and the next section, which includes the rest of the board? Can you give me a timeline on what the norm is, since you're basing this decision on norms? Do you have like a guideline as to how long these things normally take?
This took longer than normal.
And if it took longer than normal, might that be because there are things that are a bit contentious, like that they had things that they wanted to bring that we weren't able to agree to? As you've said,
I would not characterize this as contentious in my perspective. No.
Okay.
And just for the record, I've been involved in contentious negotiations, non-renewals, and terminations of superintendents.
Yeah.
And I would not characterize this as such. I characterize this as fairly routine.
Okay. And so, but you did say it took a little longer.
It took a little longer.
And by a little, like what is it? Like in your case with the 30 versus 50, where you're adding an extra 66%, or is it like?
It took 2 more executive sessions than normal.
Okay. And so.
I just want to pause and say we lost Director Farah.
Oh, we did. Okay. Well, we'll pause again.
I'm sorry, am I allowed to do that?
Yeah, no, please.
That's a point of privilege, I think, or point of order. One of the two. Does that mean our internet is down? Or is it?
No, because we're still streaming.
Oh, okay.
Ms. Antello, we're also open to having him by phone if streaming is not working as an alternative.
While we do this, am I allowed to step into the hall and talk with Mr. Leonard?
I mean, I did the same, so.
We were in executive session at that
I know.
time.
I'm just saying, like, while we have this.
Well, no, I discussed
down
stuff
time.
after.
Yeah, I called us into executive session
Oh, okay.
during that.
Oh, okay, thank you.
It'd be highly irregular.
Okay. We just have the time. We're not doing anything. I'm gonna have a kind of unrelated question.
Oh.
And since we can't conduct it.
Could we save it till after the meeting?
Sure.
Okay.
Yeah.
I just, as soon as we get on the phone, I can like to move forward.
Okay. Start doing some calisthenics.
Hmm.
12 hours?
12 or 13 ahead.
Yeah.
Oh, I see.
It doesn't really matter ahead or.
I'm jealous.
I saw sun.
Yeah, it's definitely not nice
Something
there.
that we have not
Where
seen
is
for
he?
a while.
Holland.
He's in Holland? What's he doing in Holland?
Flight delay.
Oh, was he supposed to be here tonight then?
Yes.
Oh, I see.
Yeah, it was a layover.
I will
Those
take the
darn
opportunity, if we do connect by phone, It's hard to hear if there's a lot of other conversations going around. So if we could just make sure that we have one person talking at a time on the dais.
Okay. Wally, can you hear?
Yes, yes.
Okay, can you hear us, Director Farah?
Yes.
Okay, thank you very much. We will try our best to just have one speaker at a time.
Okay, I'm barely able to hear, but I can make what you just said. You're gonna put me on speaker.
Thank you. Is,
Oh, can we pause and take a picture with the students? They're here for an assignment and they needed a picture with us. And so I just don't want them to leave without getting that for their assignments. Is that?
I think that's it.
Come up and take a selfie.
Okay. Sorry, I want you guys to get your credit, especially for sitting here this entire time. I mean, we took one. You guys can just use that. But
His computer. So I'm gonna.
are we standing in there?
Get in there. 1, 2, 3. There you go.
Timestamp that one.
Thank you so much.
Sorry, President Margell. They just mentioned they needed one.
Is this Kentwood?
Kentwood.
Yeah. Thank you.
Sorry, lots of irregularities tonight.
Okay.
President Margell.
Yes.
Director Farah couldn't hear because he wasn't connected through Zoom. It was just phone on speaker. So I'm going to get him the phone dial-in, and we'll bring him in on Zoom via phone here shortly.
Okay. We'll go ahead and pause for a moment. Okay. Director Farrer, can you hear us?
Yes, loud and clear.
Awesome. Thank you for working through the technology with us. We're glad that you were able to
problem.
rejoin. I believe that we
Glad-
were
me
left
too.
off with Mr. Leonard.
Okay.
So I think we pretty much covered that point. One of the things that I'm not entirely sure of is what is it that would indicate that it was administrative interference versus providing oversight?
Under the existing contract?
Either or.
So what would be an example of it, of something that would be administrative interference?
Mm-hmm.
So the duties that are the superintendent duties.
Okay.
And those are somewhat aligned, and let me get his contract to see if that's defined. Hold on.
Okay, thank you.
So Director Cook, I have not litigated this section.
Okay.
I've not litigated it. I've not gone to court, and I was not here when it was negotiated. But I do read here, I can read it from the original contract, which is the same in the addendum.
Okay.
And it is agreed that the parties at the board's responsibilities for policymaking and not administration. Accordingly, the board agrees that the individual board members shall refrain from taking any unethical, inappropriate, or unlawful action regarding the administration of board policies or the district day-to-day operations, or both, except through the collective board action authorized by the Open Public Meetings Act of Washington State. And so basically, what is stated here is those day-to-day operations, as understood, are vested in the superintendent. And that is my understanding as well. That doesn't change anything. This here does not change my understanding of what the role of your superintendent is for those day-to-day operations.
Mm-hmm.
Now, if you're asking for examples,
Yeah.
in which hypothetically I would believe that could violate this, I don't know if I can give you an answer or a bullet list of things that would violate this, Director Cook. I've not been provided with any concerns from Superintendent Vela related to this.
Okay.
I don't have a list. But I can tell you from reading the plain language of the understanding is that if the board was then engaging in attempting to usurp the superintendent's authority, engaging in the day-to-day operations of the school district, trying to run the school district, so to speak, there would be an argument under this contract.
Okay. Can you give me
Of the examples could be varied.
Can you give me one example?
If you were showing up and firing people on the spot.
Would I even have the authority to fire anyone by myself?
I don't know. I would say no.
Okay.
But you ultimately make decisions on a consent agenda,
Mm-hmm.
but you would not have the authority to walk into a building and fire somebody on the spot.
Is it typically, or is it normal to have this kind of contract where it specifies that board members can't do unlawful action? Isn't that kind of self-explanatory?
I will tell you, Director Cook, it is not normal,
Okay.
but nothing in Kent is normal.
Okay, fair point. I agree with that. Where would you say if I were to try to go to the furthest point that would be close to being administrative interference but is not? Do you have an example of that?
I'm not prepared to litigate this, Director Cook. I've not prepared to litigate this section and deal with hypotheticals. And I'm not even convinced that even with appropriate preparation on this, other than a judge weighing on it,
Mm-hmm.
that we would have definitive answers to a lot of those questions that are hypothetical.
And is there any reciprocal nature here where, say, the superintendent tries to exert influence or something unlawful or inappropriate or unethical given the board? So if he were to, or he or she, if it were a female superintendent, were to do something that is the board's job, is there any sort of reciprocal nature to that?
Not the way that this is drafted, no.
Wouldn't the remedy on that one be to terminate the contract as a board with the superintendent?
That could potentially be a remedy.
Would it be acceptable for me to ask if I've already done anything that would fall under this? Can I ask that?
Not to my understanding, Director.
I mean, not you.
I'm stating that I have not advised that you've done anything to violate this.
Okay. Is there, like, I guess I'm wondering what's the concern? Like, what is it that I've done, or that the concern is that I will do? Because that's my concern, is that it definitely like hinders a board director possibly, but possibly not. If it's just talking about unlawful action, I'm already not going to do unlawful action. So to me, I mean, sure, let's pass it. Why not?
My understanding is this section was agreed upon prior to your existing on the board.
Mm-hmm.
And I cannot speak, as I stated prior, about the reasons or the genesis related to that, because I was not the board counsel that negotiated this provision and cannot speak to that.
But this provision was expanded. It wasn't reduced, correct?
The section that you do see in front of you, the actual definition of administrative interference, all of those sections remain the same. The only difference is related to the alternative dispute resolution process prior to engaging in litigation. All the other substantive changes remain the same as negotiated in the prior contract.
I guess, well, I had asked for a red line of these different things, and I was never provided specifically red line, so I can't determine that.
There wasn't a red line because it was an addendum. So we didn't make modifications because there is no red line, and I told you that.
Well, I know, but it says Section 4 was replaced in its entirety, and in that case, there would have to be you could do a red line because they're...
We could, we didn't. There is no red line.
But I asked for it, and I didn't receive it, correct?
That is correct. We did not redline a document because we didn't make changes to the document. It was an addendum. There was no redline document.
Well, but it's replacing it in its entirety. It's not an addendum. It's saying that this old one is no longer good. This one is the one that you have to pay attention to, and there are changes, but we're not going to redline it for you to indicate what the changes are.
And this was explained to you in executive session.
Oh, I understand, but I still, that's where I have difficulty, though, is that even if it were the old contract, none of that has been brought against me. So nothing I've done so far has risen to this level. My concern is that by extending this, by
keeping it.
Yeah, by not just keeping it, by expanding it, by adding other things to it, like even just having this dispute resolution. How does that work if I say no? If I say, you know what, I don't believe in that, I don't think that the dispute is warranted, is that going to need to go before a judge to decide whether it is in fact something that meets the standard here?
I don't believe so, no.
Who would decide that then?
So under the contract, if the superintendent does not engage in, if there's no alternative dispute resolution, he cannot sue under the contract.
I understand that, but as far as like if he decides to try to start that and the board goes along with it, and I just say, I'm not going to be part of that, I'm just going to go and do my thing.
If you individually as a board member?
Yeah.
On like a 4-1 or something like that, or,
Yeah.
It would be the majority position that would prevail.
And what would that mean for me? Like if I ignore
in terms
it,
of your position of being in the minority position,
so like,
absolutely nothing.
So it really just would be like an admonishment? Like I'd be like, bad, don't do that again? Is that the extent of their authority? Like they
No.
can't put me in jail for it. They're not going to call the cops, right?
Certainly, the question as to whether or not the superintendent has a remedy under an individual board member, there is a question there. And certainly, because the section does talk about the board collectively and individually, so there could be a potential there as well.
So I'm forced by law to be responsible for everything in this district. It states that in RCW. There's no question there, correct?
Everything, responsible for everything by law. That's very overbroad and a very generalized statement, and I'm going to hesitate to state
that that's true.
Would you like me to read the thing so everyone is aware, or do you know?
I agree with Mr. Leonard. You're responsible for the budgetary oversight and other delineated tasks, the operations. In fact, that's what the whole point of this is to define the difference between the operations of the district, which you are not in charge of.
Okay, let me read this. It is RCW 28A 150230, School District School Director's Responsibilities. 1. It is the intent and purpose of this section to guarantee that each common school district board of directors, whether or not acting through its respective administrative staff, be held accountable for the proper operation of their district to the local community and its electorate, not to this district, not to the state, to our wonderful community that is still here. And after that, it states, in accordance with the provisions of this title, as now or hereafter amended, each common school district board of directors shall be vested with the final responsibility for the setting of policies ensuring quality in the content and extent of its educational program, and that such program provide students with the opportunity to achieve those skills which are generally recognized as requisite to learning. So what part of operation in this law, because this is RCW, it is not a policy, it is not even a WAC, a Washington Administrative Code. This is RCW. So if we were to break this, it would be going against the law, correct?
I don't see the connection. And in fact, the last section you wrote was about policymaking.
Yeah, and that's a separate sentence.
Policy making and program. So,
but it talks about intent in the beginning part. And the reason I bring this up is because when I see the intent, anytime I've ever understood law, maybe I don't understand law well enough, but when a legislature decides to tell you why they're doing it, that part is pretty important. Would you agree?
Is that a question for me?
Yeah.
I'm not a legislator, but we sometimes look at legislative intent to try to determine what
they
is.
meant.
Sure.
And that being the first line of the first paragraph of the school director's responsibilities, do you think they put thought into having that being the very first thing, given that it does say intent? And down below, it says that I am accountable for the proper operation. And so even though you're saying I can't go and operate, which I'm not disagreeing with, I'm not saying I'm going to go in and direct people to do anything. I might go in and watch something. I might listen to what people are saying. I am still held accountable, even if you say through policy or resolution or any other way that I am not to do that. I still am required by law to do that, no?
So here's what I would say, Director Cook. I've been working in the district since May. This section of the contract is not new.
Yeah.
It's from 2021. We've had 3 executive sessions in which I've answered a broad variety of questions posed. We could have this conversation at any point related to this existing portion of the superintendent's contract to answer your questions related to how this impacts you currently, not about the extension of the superintendent's contract.
Well, these were questions that were brought to me from the public. So how would I know to ask these questions before someone brings it to me? Like, I didn't know this until someone pointed out, hey, by the way, you are held accountable for the operations of the district, yet you're being told that you can't do that. And so but it also says in the contract that's written that it can't supersede law. So how can you have two things that seem to be at odds with each other? And so what, it just ignores that part? So why leave it in there if it doesn't match?
But again, we also are a board of 5, and we have a policy and procedures that are there for us to be able to define what our operating procedures are. One person cannot define what that looks like. So we have certain policies and procedures for what that looks like. That one board member can say that I'm going to, as the example was before, go fire the people I don't want. That's not acceptable within the policies and procedures that exist for the board in how we conduct business.
Yeah, the superintendent's the only one that can fire people. I mean, that's pretty clear. I've never claimed otherwise. What I'm concerned about is the follow-on, right? Is, am I going to be stopped from going and talking to principals? Like going and asking them how they think their superintendent is doing?
From my perspective, no.
Okay.
During time and place as by the policy and procedure, because my student is learning and they're working, and so we need to be respectful of the the students first, right?
Mm-hmm.
And so we want to make sure that we're following the time for that. And then we also would be following the policies and procedures that we have in the district for safety of who we have on our campuses at certain times and not. And then also following the policies and procedures for making sure that we give proper notice so our principals can make sure that they're not leaving another meeting that they need to be part of or anything like that. So yes, having conversations is one thing, but there are policies and procedures that you need to follow as a board director that are outlined to make sure that we still have the safety of children first and the contracts of our labor partners always considered. I mean, there's a number of other things that come into play, so not just the whim of one director.
Okay, so let's say someone in the district, principal or not, contacts me and says, hey, I have some information for you. Can you come and meet me? It wouldn't be appropriate for me to go and meet them outside of their contractual hours because that would be them working off the clock. And my job is to provide that oversight. If I go there to do that, would that be going against our contract here? Even though maybe they don't trust the other board members, they don't trust the district administration for whatever reason. It could be, completely unfounded, but they've chosen me for whatever reason that they want to talk to. If I go and do that, I'm not going along with the policies and procedures, but I'm going because I'm providing my duty as is stated in the RCW, which I'm required, because if I ignore them and they end up getting hurt because they were going to bring something to me because I was the only one they trusted, now I am still accountable because RCW says I am. Even though I may be following policy and say, hey, sorry, I can't go and talk to you. And now something happens, that person gets fired for whatever reason, brings that against the district and says, I was fired wrongly. And now I'm responsible because I didn't answer correctly in that, because I should have been following RCW, but instead I'm following policy and procedure. Does that make sense?
No.
So you're saying if someone contacted
I just think that
you.
it sounds like a very elaborate.
So here's what I'll say.
So I'm going to say
Director
one
Cook.
thing about that before we continue on that, because I have had no less than 5 people in this district. I'm not going to name names, and I don't have any records of it because I don't want them retaliated against, who have brought information to me that I did not share with anyone else because I was worried for their well-being. So this situation has already happened. So to me, that says we've got a problem here, where we have people within the district that do not feel comfortable bringing things up the way that they're supposed to through policy and procedure. They're finding ways to go around it to contact either myself or another board director or another person on the district staff. But if it's the superintendent that they're concerned about, what do? Should they continue working through the policies and procedures because those are the people? Should they go and seek legal counsel at their own cost? Because that seems like a pretty high bar for them to reach. Should they go and just talk to their neighbor, their friend? To me, it seems the board directors in our role are special in that because we are not their manager. We're their manager's manager, don't get me wrong, but I have no control over what happens in the district. I expect our superintendent to handle that. The fact that I've had multiple people reach out to me shows that he's not. And that worries me. So when that sort of situation happens, what would you do? Would you ignore them? Would you say, sorry, that's not policy and procedure, I need to run it by my superintendent first, when the action that they're talking about is coming from their superintendent?
What I can tell you is I would not try to board a bus with students without having not made the district aware that they were there. What I would not do is go to 3 different elementary schools on a day without even checking into the office to let them know, and interrupting classes and jumping into classes while children are starting to learn.
Can I
There
ask
are
a question
many
real
different
quick on
things
that?
I would not do.
Because you're currently bringing things up that are things that I did. Would we be able to bring up the deputy superintendent, please?
Did you have a question for the deputy superintendent?
Would I be asking for him to come up here if I didn't?
We have had many, many hypotheticals tonight, so I'm
It
not sure if I'm asking you.
It speaks to what you brought up.
Is there a question for the deputy superintendent?
Of course there is. What am I going to do? Say, hey, I just wanted to bring you up here. Of course there's a question.
So the answer would be yes.
Yes.
Deputy superintendent, sounds like that there's a question. for
Director
you.
Cook, could you ask the question, please, and then I'll decide that?
You're going to decide whether your boss
Whether I
gets
need
to
to
ask a
have someone
question?
answer I might be able to answer that question.
Okay. Did I message anyone when I went out the first day that I went out to do temperature checks around our district?
Deputy Superintendent?
Okay, then. Thank you for joining us. I apologize if you're not feeling well. I see you wearing a mask, and I'm sorry for keeping you here so late.
That's all right. President Margell, members of the board, Superintendent Bella, Ms. Curry. Your question was, did you message anyone when you went out to schools?
Yes.
Initially, no, you did not. You posted on social media that you were going to be going out and checking temperatures.
Mhm.
It was brought to my attention. I reached out to you. You called me.
Mhm.
I asked you if you could give me the names of the schools so I could let the schools know that you'd be coming there, not knowing what order that was going to be. You gave me the names of the schools. I then reached out to the schools, just letting them know that you would be coming to your school to check temperatures. So, yes, that's what happened.
Did I tell you each time from one place to the next, did I message you both with the picture of what I found while I was there and also where I was heading next?
Yes, you did.
And the next day when I went out, I did not do that. And the 3 instances that President Margell was speaking to were during that day, I assume. And what was my explanation for why I didn't do that?
You left your work phone at home.
That is correct.
Did you check
And
into the offices?
Of course I did. Or when I was there, I spoke with the principal or vice principal, one of the administrators, at each of the buildings. I always did. When I went into the building for, I'm not going to name names because I don't want to get anyone in trouble. I happened to come across one of the administrators while I was outside. I asked, can I use the restroom? And so no, I didn't check into the office as the school was already being let out. So students were already outside at that point. So I didn't think it necessary to go read myself in for that purpose when the administrator that was outside, who had a walkie-talkie and could pass that information on if they so choose, I felt that was enough. That may have been a mistake on my part, and I apologize for that. I did not intentionally not tell you about it. I feel like I did a pretty good job on Thursday letting you know what I was doing, where I was going. Granted, I didn't tell you ahead of time that I was going to do that, but again, when I have people reaching out to me that are concerned about things going on in this district, I tend to wonder if I tell you, what's going to change? And another question that I have for you, Deputy Superintendent Behringer, is when I contacted you after everything was all done, what was my question about? Because I had a concern that I brought up to you, and I was concerned about this. What was it that I brought up?
Yeah, you were concerned because you were in a teacher's classroom and they had mentioned to you.
Did I say teacher?
You were in someone's classroom.
No. Still, I said room. It was not a classroom.
Okay, you were
Thank
in a
you.
room.
I
I'm
just
sorry,
want to make
don't
sure
have
we're
the-
clear
I
on
don't-
this.
I don't have the text in front of me. I'm sorry.
I understand.
That you were in a room, and the person in that room had mentioned that the temperature or the setbacks had been set back in that room, and they'd never had experience like that in that room in the years they'd been in that room. And so I said that I would check on that, which I did check on that. And as I didn't respond to you because you went into a whole different legal response, and I figured I'm not going to respond if you're talking about legal things.
I didn't say, by the way, I did not say legal. I said that I wanted to discuss it with our board.
And legal counsel.
Well, with our board, yes.
So the answer is, we'd set out on Wednesday of last week before the heat, that we did all the setbacks the mornings before, so we could get all the cool air in the buildings. So there were no intentional setbacks that were done in the middle of the day in specific classrooms and specific buildings. We follow a normal process, which is all on computers. Everything you can be run anytime you want and check all that stuff. So, and not knowing where you were going and what rooms you were going to be in, there's no way that we'd be able to do any of that kind of stuff.
I understand. But did I indicate that I thought that was happening, or it was just a concern that I brought? I didn't accuse anyone, correct? I didn't say this person did that, or facilities is screwing up over here.
No.
I said, I'm concerned about this. I just wanted to check in, make sure that wasn't happening and that I was worried about it. And if
you were
it
alluding
was,
to the fact that you hope it wasn't happening.
yes,
Yes.
because if it were happening, then I couldn't provide you that
In the
notice
future,
ahead of time.
yes,
And
that's
that
correct.
was my concern
And I
there.
assured you that it wasn't happening, and I would
And-
check on it.
Yes, and did I follow up and ask you anything beyond that after that conversation?
No.
So I took you at your word and left it at that.
Mm-hmm.
That's how I addressed that situation. So when you say that I'm going around and doing things without anyone knowing, that's why. It's because of safety of our students. And granted, maybe I'm not following the procedure that we have, but when we're sending kids out and it's 96 degrees on a school bus, I don't know what the rules are on that. I don't know what the temperature rating is that we can say, once you get above this limit, that's too much. I don't know what those numbers are, but I do know that our public deserves to know what their kids are experiencing on these buses. And it was not my intention, which I believe I told Dr. Behringer, that I would go on the bus that day. What was my reason for going on the bus that day?
Yeah, you had a friend that dropped you off, or you needed a car. It was a situation with your vehicle or whatever, and you needed to get a ride back to the bus barn or something like that.
Exactly. And so my plan was that I would go on the bus, ride back to the bus barn, my friend would pick me up and take me home. And for me to be able to do that, I would have
Sorry,
had...
that's odd. That's
Yeah.
odd. Get an Uber. No, you don't ride a school bus with kids unannounced.
Okay.
Like, if you're in the audience, you should be horrified right now. An adult should not just be able to go onto your child's school bus unannounced. Sorry, no.
Dr. Behringer, are you
That's
allowed to go on
weird.
a school bus if you choose to? Would there be anyone that would stop you?
Oh, yeah, I go through a process. I have to check in with the director of transportation. They have to schedule it with the bus driver.
Is
Yes.
there anyone in this district that could just go on the bus without having to go through that process? Maybe the manager of said bus driver?
Yeah, the transportation director, I believe, and probably the assistant director would have access to doing that without doing any formal process. That'd be it.
And me doing that, was there any concern brought by anyone whatsoever? Because there were parents that saw me on the bus. I posted it, so everyone saw that I did it.
Where
Have
did
you
you
had,
post that?
excuse me, just 1 second, let me finish. Have you had any concerns brought outside of our president here at this moment? Because she was apparently aware of this situation happening. Did she also
I
email
found out
you?
today.
Okay. When you found out, you've obviously, right now, you're very agitated about it, it seems. You don't like that it happened. You think that it was unsafe for some reason. I'm not entirely sure why. But you didn't think it was important enough to send an email or to call or to text or any other communication with anyone in our district about your concerns for the safety of our students.
I found out today at 4:45 approximately.
It is currently, for the time, 11:37, so it has been 7 hours, and you have, if you were so concerned, why have you waited until now?
The conversation has been had with the appropriate people.
And your meaning behind that?
I talked to Deputy Superintendent Behringer about it. It is odd. I'm sorry. It is odd to have
Oversight?
a board director get on a bus unannounced with students and go for a ride-about.
A ride about. You think I went on the school bus for fun? You think I was doing it to enjoy
I
myself?
did not.
You think I enjoyed a 96-degree school bus that I had to ride beyond all of the students that were on that bus, that I rode all the way through their route, continued on past all of the students, and continued back to the bus barn? And that was something I did for fun. It's something I would do, say, just to have a good time. Is that?
I think that you're the one who used the word fun, and I think for getting a temperature in a bus, if you really wanted to, you probably could have just gone to the bus barn and walked inside one and walked back out without having to ride with students.
When's
But
the last time you rode a school bus when it was 90 degrees outside? Have you ever? Do you know what it's like to sit on a school bus that's 96 degrees for roughly 45 minutes?
Yes, I have been on buses as a product of Kent School District and public schools, and also Metro, if you really want to know, because I ride Metro a lot, so yes.
Were you ever in charge of any of those agencies
Point
and
of
had a
order,
chance to
Madam
tell?
I'm not sure what this has anything to do with the
You
superintendent's
are bringing up the fact, you brought this up, not me, first off.
No,
You
this
did.
all was an answer of your questioning. This
But
was all
it doesn't
an answer
matter.
of your
You
questioning.
brought this particular issue up, and you're trying to besmirch my reputation
No, you're
amongst
doing
my
that
community.
yourself. I have no need to do it.
Point of
What
order.
was your word? You said weird?
Point of order.
Thank you.
I think
Before-
we're long beyond anything dealing with this particular motion on the floor.
Thank you, Director Clark, Director,
Excuse me,
President Morgill.
Superintendent Bella. I would like to speak to this for a second.
Just a minute.
No, it's okay. I
Thank you.
understand.
I
You
wanted
are our
to-
The board does
secretary.
not recognize, the board is recognizing Superintendent Bella.
I
Why didn't
wanted
you do
to
that
thank,
before?
Dr. Berger, thank you for answering questions.
Now
do
the board
appreciate that.
recognizes Director Cook.
Thank you. And I understand that many here do not like my methods. They do not enjoy the way that I choose to do what I do here at the district. Again, the reason that these things are done is not with malice. It is not with any, whatever you mean by weird. None of that. I do that because I think it's important for me to both see and feel what it's like to be those kids on that school bus, and more importantly, what it's like to be that staff member that's on that bus all day. You have no idea what they go through, yet you sit here up at this dais and claim that you do. I know Director Clark had mentioned earlier that he had been to 44 schools, yet he's never once toured the IT department. I talked to people there that have been for 20 years, have been here working at the Kent School District. Not once have they had any school board director ever show up. Do I expect people to? No. I've worked in IT my whole life. No one ever shows up to IT because no one cares about IT until it's broken, and then everyone cares about IT. But no one had done that. And so your argument that I had done that, I'm not done, sir. Did you not say something as you came up to the mic?
I have been there. I don't know where you're getting this.
Okay, well, apparently they weren't there when you were there. And I've heard that more than once. It is not just this one time. Yes, Director Farrell.
I was there. I have a computer science degree, worked in the industry for 25 years. I do understand IT inside out. I design systems. I write code. I know exactly how they work. I've spoken and I have visited multiple times in their data center and saw the server farm, the UPS. So I'm sorry where the information you're getting is not correct.
Okay. I can only base off of what people tell me. And so when I see these incongruencies with the things that I'm told about supermarket meetings of community members or people going places that others say they haven't, I don't know what to think. But I do think that it is my job to go and try to help wherever I can. And when there's a community that is sitting here begging for transparency, constantly asking for it, and I go out and tried to provide, on my own time, mind you, this is my time. I am only paid $50 a day, just like the rest of us. So I'm not getting money by doing this. I'm going out there and doing these things because I think it's important that I understand what all of our staff are going through. I plan throughout the rest of this school year to be in every single department and every single school. That is a goal of mine. I think it's important that I see what everything is as it's happening in our schools. And if I show up only when I'm using the policies and procedures, how do I know that that's what the day-to-day looks like? I don't know if you've ever been on a military base when a 4-star general shows up. Everything changes. That entire base looks nothing like it did before he showed up. That is very similar to the experiences I've had in coming to different schools with the administration. It's not a fault of theirs, but I don't provide that same level of scrutiny because I'm not running the district. That is the job of our superintendent and his staff, and I leave them to do that. But my job is to provide oversight. And if I don't go and visit these places, who is? You say you've been. When was the last time you actually went somewhere without checking first? How do you know that when you check first that they aren't just making it look the way you want it to be? Heck, you know what? If I were a really bad guy and I was running things, I could just have an entire different staff show up there that day. Theoretically, it could happen. Is it likely? You wouldn't even have to, because they only visit 1 or 2 classrooms. So you'd change out those 2 and you'd be good. And they'd go in there and they'd show you the exact things you want to see. I'm not saying that's what's happening. What I'm saying is that I need to know that that's not what's happening. And how do I know that? Without actually doing the oversight that I'm elected to do.
Is there any other comments pertaining to the superintendent's contract 6.02?
I have another brief one. Mr. Leonard, when it says the board and superintendent, if there's a disagreement, is that the majority? Like if we're, let's use my elephant example. If majority of the board is in disagreement with the superintendent, is that the only time this can be invoked, or is it if the superintendent feels like there's just one board member?
Mr. Leonard?
It is both the board and individual board members as well.
As far as that goes, if I were, sorry, Mr. Leonard, this was going to be a question for you. If I feel that this contract goes against the laws of the state of Washington, how should I proceed? Do I need to vote no, or should I be abstaining? Because, and the reason I ask is because when I am looking at voting on my wife's contract, I am abstaining so that I am not voting yes or no, because it is something that would be against the law for me to do so. And so my concern is that I don't want to be tied to this in any way, because I do not believe that it matches state law. And because of that, I want to make sure that I am absolved as much as possible. And in your legal advice, how would I do so?
You can vote your conscience. I don't believe that there's any legal difference between you voting no or abstaining.
So, okay, given that, what would be the difference? Why would you choose to do that in other contexts?
So I'm not sure if it's a legal determination as to why a board member votes no versus abstain. I think that's up to the individual board member to choose.
I would say, would you agree with, if you feel like there's a conflict of interest, you're more likely to abstain and not vote no or yes, you would abstain. So I would believe that in that situation, maybe a conflict of interest would be an example of when an abstention would be most appropriate.
It could be.
And what do you think the legislature's purpose was in making that the norm? Like, because obviously they created that.
I can't speak to that.
So in my opinion, the reason they choose to do that is because having that conflict of interest is illegal. And so you need to remove yourself from from the conversation altogether so that you are not going to press one way or the other. And that's how I feel right now. So I guess in my conscience, I will vote against. I'm not going to vote against it. I'm going to abstain. And the reason I'm choosing to do so is because I believe that this contract is illegal. I believe that this contract goes against what state law says. And I'm hoping that my other board members will give us additional time to get more legal advice. As you said, you haven't had time to go through all of everything, to give us solid advice from earlier.
That's not what I said. What I said was that this contract predated my involvement, is what I said. And so I did not advise the board initially related to the adoption of those provisions.
But Director Song asked you a question, and you said that you had not written it and that you would need to do more research, and then we could talk to you about it.
I don't recall stating I would do more research. I stated that I was not prepared because I hadn't asked the question as to what were the reasons behind that provision, because I wasn't there.
So maybe this is a bit of semantics. What would be the difference between that and you not being prepared because of you not having information?
I wasn't there when it was negotiated.
So you are able to answer Director Song's questions on that?
Director Cook, there's been a lot of questions, so I'm not sure what question you're referring to.
I'm sure our IT people could probably rewind and find it for you.
Honestly, I'm not sure how that would help the conversation. My intent here was to answer what I knew related to the superintendent's contract, and I have provided the information that I have.
I understand, but when Director Song asked you that question, I'm sorry, I'm also failing to remember exactly what it was, but when he asked you that question, you didn't say, this is my best understanding. You said, I can't answer that.
No,
So
what I recall stating was, again, and I'll repeat it, we had 3 executive sessions. I've been around since May of this year. I had exactly 0 questions about the existing provision in Article 4 related to the current superintendent's contract. Not a question from you or from anyone on the board in 3 executive sessions. And so I tend to try to prepare for questions that I think I'm going to get. And I have literally spent hours talking about this contract, and never once did that question come up until I was at the dais now about 4.5 hours ago.
Well, I
That's
believe
the first time I had that question asked of me.
Well, and I
and
believe
so,
direct-
and in fairness, and let me finish. In fairness, I wanted to communicate to you that this is the only time that that's been asked of me, despite many opportunities to have the question. I would have been more than willing to be prepared to answer that question for you. But that question was not posed to me. And what I said to Director Song was quite simply, I was prepared on the items that, and I can talk, if we want to talk contract, I can certainly do it. I just wish we could have had the conversation in a time with enough notice that I could have given you the answer that you're hoping for.
And see, I totally agree with you there, because the public is who brought the question to Director Song, if I remember correctly. And the public has not been provided all of the information that we have. They've only been provided the information that they were given on Friday, last week, 5 days ago from today. And actually, it might be almost tomorrow, but they were provided that then. And I don't know exactly when Director Song was provided it, but he asked the question, and I mean, granted you weren't prepared, but our board has decided to not wait on this, and we are just going to continue pushing forward.
We also lost Director Farrer again.
I'm not sure if there was a question there, but I will.
Well, I guess it either.
Well, can we continue if Director Farrer is not on?
We should wait.
Take a moment to get Director
My apologies. I need to use the restroom. Okay, I am at this point, I think that we should ask if everybody has information that they're available, that they are ready to vote. Director Song, do you have the information you need to make a decision and move forward with a vote?
Sure.
Director Cook, you've already said that
I
you're
do
going
not.
to abstain?
Sorry, I think I just got soap in my eye. I can't. Sorry. I didn't mean to do that. I'm sorry. No, I have additional questions. Thank you.
That is going to change an abstention?
Yes.
Okay. Director?
I'm good.
Director Farah? Director Farah, do you have the appropriate information that you need to be able to make a decision on this? He's on the call. Are you unmuted, Director Farah?
Can you hear me?
Now we can hear you. Thank you. Director Farah, do you have enough
Yeah.
information to be able to make a decision on item number 6.02?
I'm sorry, say that one more time.
Do you have the information enough to be able to make a decision on item number 6.02?
Yes, I do.
Thank you. Audience, I'm sorry, I know it is late, but please, if we could keep it quiet. Thank you. Director Cook, sounds like you have the question still.
Yeah, I do, yes. I had asked a few questions of our legal counsel, and like he said, he responded. My concern was that it didn't go far enough. And so part of it is just a matter of, trying to wrap my head around what it is that is providing benefits to us for doing this the way that we're doing it. Why are we choosing to continue here now in this moment instead of putting it off and allowing our public some time to digest this? Is there no interest in hearing from them, or do you think that there's no chance that something that someone sees here could bring up that might sway you, or you're so steadfast in this there's no possibility of that?
I'm sorry, you said legal counsel, then you asked me, I wasn't sure where you're going with that.
Yeah, I meant that as an aside. It wasn't, sorry, I didn't mean any questions for you. But my concern is, I'm looking at things like the different amounts. I also asked how much this was going to change. So how much more is the district expending to provide these changes? I haven't been provided that. Have you?
It was part of the negotiation and discussed within executive session.
Well, I understand it was discussed, but do you have a dollar amount of how much more this is going to cost us per year?
Again, discussed within executive session.
It can't be told to us? Like our public can't know how much it's going to cost them?
Mr. Leonard, would you like to answer that?
I appreciate you bringing your laptop. Other lawyers that we've had in the past were not quite so accommodating.
Just 1 second. So what I can say is this. The superintendent, the changes to the superintendent contract are various. There's no change to the superintendent's salary. The biggest change that you see in front of you is related to the TSA contribution. Mm-hmm. And that represents the biggest contribution and change in the overall contribution in the financial package, not the salary, the TSA contribution. I'd have to take a second to look at the change from the existing to the new, but it goes from a percentage, a set amount to a percentage of the contract of 6.5%. So it's quite a little bit of math, which was shared previously, but, and again, I'm a lawyer, not necessarily the math guy, but I could get that for you. But what I will state is this: it was the product of negotiation. And I can't go into specifics. We talked about this in executive session. There were other items that were agreed to, other items that were not agreed to. And that was part of the negotiation. There are other pieces in which the superintendent contract allows for him to get provisions of items that were already provided to other administrators. A lot of that was an alignment of those policies of what other administrators got. And so some of that was a realignment, including the vacation days, which actually isn't technically more vacation days because he was already getting those increased vacation days that we're already entitled to. The allocation of the amount or the receipts for in-district reimbursement. It's a set amount as opposed to having to turn in receipts. And so he doesn't have to turn in receipts in in-district travel. That's fairly common. In fact, I don't view that as an increased cost to the district because in reality, it'll probably hold serve. He still has to turn in receipts for out-of-district travel. So that doesn't really represent any difference in cost. So the predominant driver around that increased cost would be the 403, the TSA contribution is the majority of what was negotiated in addition to those other pieces that I identified.
Okay, that sounded like a whole lot of words to say no. You don't know what the cost is.
If you give me a little bit of time.
I would love that.
Okay.
Thank you. And for the record, I had already asked for this. I'm not bringing it up today as a new thing. I brought it up, asked it, and was never provided it.
So I also just want to put out to the board, these discussions can continue, right? I guess, like, is there a time limit or?
Nope.
What is, okay. It is midnight.
Yep.
I know people still have questions. Could we table this for?
No,
a couple
we've already
days?
voted that.
Okay.
Again, that's why I ask if, as long as our questions continue to be productive and make a difference in what somebody decides one way or another, especially after somebody's already said what they're going to vote. I would just caution the board to be respectful of the employees that have been here since 6 o'clock this morning and will be here again tomorrow or today at 6 o'clock this morning and have had most of the summer to be able to ask all of these questions and have chosen not to. So as long as they're productive.
I did ask, President Margell, I did ask this question and I was never provided it. And yet you admonish me for asking a question and not getting an answer. And you admonish me if I don't ask a question and don't get an answer when I ask it later. When should I ask the question?
We've, again, had 3 executive sessions.
But I mean, this particular one I already asked during one of our
it.
executive sessions. I did. I mean, I can ask Mr. Leonard to come back up and verify that I did in fact ask him that question. And just so we're putting all our cards on the table, the reason that we're still here is because we did not table it, and there is no suggestion that we table it even to tomorrow. The only time that we're going to do this is right now because it's such an emergency that it must be done. And I apologize to our employees that are having to stick around, but apparently it's an emergency that we do this today. If we could push it off, then we would. But since we can't, I'm going to continue asking questions until I feel that I have the ability to make my decision with all of the information at my fingertips. And right now, that's not the case.
Okay. Well, again, your own words were that you were going to abstain.
I did not say I was going to abstain. If I choose to not vote yes on this, I will abstain.
And we're just waiting for Mr. Leonard to collect his thoughts, correct?
He's doing some math, I guess.
Okay.
Coming up with whatever the total number is that we could possibly end up increasing our expenditures for this superintendent.
So the amount,
No, this is the total amount that it would cost in addition to what we
the
currently have.
deferred compensation under the new agreement would be 6.5% of his salary.
That's one
In
section.
deferred comp, correct.
But there are other amounts.
Of what I took you through,
Yeah.
the compensation does not change. The in-district travel is a wash. The professional development, if he uses it, goes up.
How is it a wash, though?
Because previously, he would have to submit receipts, so he doesn't have to submit receipts now for in-district travel.
Did he always end up taking the full amount?
All right.
Well, he should have.
I'm not saying
He was
didn't.
entitled to it.
I'm just saying if there is a difference, then it does materially change, does it not? If he didn't do it all every single year, then that would be a material difference. I
Well,
want to know what.
You would account for what would be acceptable and given.
Okay, so what it does is previously, he would submit receipts. And in looking at comparable districts within Puget Sound ESD, and again, this is part of the negotiation, part of the conversation we had in executive session, is that the provision would allow for there to be a reimbursement without submitting receipts in in-district travel, up to that amount.
Yes. And before, what was the total amount that he could get? The same amount?
Unlimited.
Unlimited. So before.
Based on the receipts.
And what was the receipt total before in his 2 previous years? It's not, I don't feel like that's a huge ask, because what I asked for when I asked for the total amount is everything. I don't feel like that's too much to ask. I don't feel like me saying, I want to know how much more are we going to pay for this superintendent than we did in our previous contract. That, to me, that seems like a basic piece of information I should have at my disposal right off the bat. Yet I've asked for it and I wasn't provided it before. You claim that I should have asked before for other things. I did this time and I still didn't receive it. And I don't know if you thought that it wasn't important or that my questions weren't important because maybe it's because of me. Because I'm combative. I know I am. I apologize for that.
Is that how I've treated you? Is there any suggestion, and that was my response?
You have treated me with nothing but respect
No.
so far.
So let me just say, Director Cook.
Yes.
Okay. I'm not trying to hide the ball. I don't recall when you made this request. It was in passing. You reminded me today in executive session about this request. I don't recall when you made the request initially, to be honest, because, to be honest, I've had a lot of conversations with you about this.
Yeah.
The request was not made in writing. It was an offhanded comment that I didn't even remember until you reminded me today, okay? There was no concerns expressed to you about the value of the superintendent's contract in 3 executive sessions. And so I will tell you that I would have been prepared more if I had some suggestion from you of your concern that was not shared with me. What I can tell you is to the substance of your question, let me just finish
Well, but you
what I'm
just said
stating.
if you had any, what was your words? Like if you had any indication that I wanted to know it, me asking you verbally wasn't enough? I need to do it in writing every time?
That you would potentially not support increase to a superintendent's contract overall. There was no questions about the superintendent's salary increase or any of the other pieces in which we discussed in executive session. But let me just state this, that the value of the superintendent's contract, the big difference is found in the TSA contribution, which is 6.5%. Based on the salary, 6.5% is $23,000 in deferred compensation. That is the majority of what the change is represented. And to state why we came up to that and why we got to that point is the topic of executive session. There are lots of negotiations that
I'm
went
not
back and
asking
forth.
why, sir. I'm not asking why at
Okay.
all.
Then fair enough. Then I will defer the remainder of my comments.
Okay, so my guess is that it's more than what you stated, so it's more than the 23,000 or what have you, but it's less than 100,000, I guess. And so what amount is it that you think is okay for us to not know about this contract? You think that $5,000 is okay, $10,000 is okay? At what point should our public say, that's not enough, I need to know what that dollar amount is? To me, it should be, like, this doesn't even seem like something I should even have to ask for. It should have just been, hey, these are the differences, here's a statement of this is what it's costing us now, this is what it's going to cost us tomorrow. We don't have that. And over and over and over, we make decisions without all the information. I wasn't provided the information regarding his review as far as this information goes from the stuff that's been adjusted. He wouldn't answer the question as to what information we've gained in the last 4 months. It's just, there is some, maybe, and I'm not okay with that. So I also want to go through this contract more, and it's because I want our public to know that we did our due diligence, that we went through every single piece that we possibly could and made sure that for the next 2.5 years, that this is the right choice. Because it isn't a choice like we're going to take it back tomorrow. If we find out tomorrow that he's been embezzling millions, we can send him to jail maybe if we can find it. But I'm saying, like, and I'm not suggesting that by any means. All I'm suggesting is that there are things that we don't know, and we don't have the curiosity or even the patience to say, let's put this off until another day. Like, I feel like I come to you with all of these reasons. You have no answer to me. You have no reason why it needs to be done tonight other than an esoteric, well, in March, his contract is up. And we don't want to start a search for a superintendent super late. Why did we not have any sort of, push to get this done earlier? It's not like this started in, I don't know, like last month. It's been 4 months. I mean, we weren't discussing this ourselves over that 4 months. So it was brought today, but we could have brought it out ages ago, possibly. But I don't know if it was a lack of understanding of how you should be doing things so you can make sure that our public is aware of everything that you're doing. But to me, I would want that stuff done as quickly as possible and then make sure that whatever my drop dead date is, which if it is today, well, it can't be because it's the next day. So it obviously it didn't matter that it didn't happen yesterday. So now we're gonna do it today instead. But what is it that's keeping us from doing it next week or the week after? I'm not saying that we're gonna push it out for 8 months. I'm not saying we're gonna even push it out past a week or even 2 days. We could do this on Friday, could we not? We can have a meeting as long as we notice 24 hours in advance.
So
No?
I will answer that question in this way.
Yes, sir.
That question has been posed to the board, and it was voted down.
Well, not exactly. I had suggested that we wait 2 weeks, and 2 weeks is not the same as 2 days. And I assumed that we could, not myself, I wouldn't bring it up again, but someone else could bring that, no?
The question about tabling the motion has gone for a vote and has been voted down.
So has there never been a time where you would have someone change the tabling and say, oh, you know what, 2 weeks is too far, let's bring it in by a week? To me, that seems like we could do that. Is that not something we have the power to do? Am I understanding that correctly, Mr. Leonard?
The question about tabling the motion has been answered. And your question was not specific to an amount of time. We could read back the record. It was to table the motion.
That's not true.
That was it.
Let's read back it then. Go ahead.
What I would like to say is there were a lot of assumptions made during that last comment that were false. First, during the negotiation process, a lot of things were looked at. 2-year historical averages were asked for and obtained. I looked at total compensation.
Are you able to share this information? Because this is part of your negotiations now.
If I would have been asked about this at a different date and earlier, yes, I probably could have provided that. But since I was never asked over several months, and so we are here now today, and I can tell you that, so since they have been looked at, have been evaluated against the total increase in compensation, looked at over the time period of the total contract, looking at other districts of similar size, looking at any variables that go into it, looking at The other increases that have gone into other administration within this district, yes, many factors went into this, and I feel very confident with information that was given, then such negotiated, and brought to the board many times for comment, questions, asked, answered, and now we are here today.
I still have not had my question answered. And granted, I didn't do it in writing, I guess, so maybe that negates me asking the question. But I asked for the amount, I still haven't received it. And apparently this board is okay with that. To me, that seems like a non-starter. It seems like we should wait until we actually know what the dollar amount is. It doesn't have to be down to the penny.
$23,000 in the TSA contribution, and an increase from $4,000 to $10,000 in the professional development if used.
Which is not cashed out. It is a amount that is only to be used for investing in our superintendent and the head of our administration for our district.
And that information was shared in executive session with you.
And did we also take into account the amount that we're spending for mentorship for our superintendent that needs mentorship? Because that was $50,000 this past May, correct? I assume we are going to continue that contract, or no? Is that not part of paying things out to be able to provide the superintendent with what he needs to be able to run our district? Or is that not part of his compensation package?
To be honest, have no idea of what you're talking about.
Okay, we paid Nyland, sorry, I don't remember his first name, Dr. Nyland, we paid him $50,000 in a voucher back in May for services rendered. It was asked for as a public document from someone outside of this board. It was a community member that reached out and asked for it. And I didn't even know that he had a contract, what that contract cost. I didn't even know, like, my review would have been grossly different if I knew that the person that's giving me advice is also being paid by the person I'm supposed to be rating. Does that not seem like a bit of a conflict of interest? I mean, to me, that seems like if I got paid $50,000, might influence me a little bit, especially when the board members don't even know that it's there. They have no idea. And that doesn't bother you, apparently.
Again, since this is the first that I know of it, I'm not sure of what additional contracts have predated this board.
Well, it was just paid in May. And do we not have a policy that requires anything over $25,000 to come to our board?
I'm sure we also have a contract with Comcast that we send out payments to.
Nope.
That,
We still have to go through our processes and pay it that way.
and so it was on the vouchers.
It was not ever discussed. Anything over $25,000 has to be approved separately. That's how we've done it. At least that's what it says in our policy. I guess we don't follow policy, or we follow it when we want to. If that were the case, let's say I am correct in this, does that bother you at all?
Well,
Again.
first of all, Dr. Nyland has been with the district in previous contracts. I was present for that. So he is used throughout the state in terms of advising people on how to handle the approaches, not the numbers.
Yes, I mean, he was never in our negotiations of the superintendent evaluation.
Are you discussing things we discussed in executive session? 'Cause
No, I'm telling you who was in executive session, and Dr. Nyland would not have been in that.
Okay, well, I remember him telling us how we would go about rating our superintendent, how we should do the process. That seems important to me, but I guess it's not important to you. And to me, if someone is getting paid to do something like that, it should be disclosed ahead of time so that we know that, hey, this guy is getting paid, and that's fine. But it gives me pause, the fact that one of our board members had more information than I did. And if that ever happened and I was the president, that would be the end of the conversation. I would say, you know what, you're right. We need to go address that. We're gonna talk about it, and then we'll come back and give the public some time to mull it over, come back to us, tell us more information how they feel about it. Because we are, again, just representatives of the public that elected us. And that's where the problem comes from. It's because of us just ignoring them. And I understand that I'm keeping everyone here. I am so sorry about that. But it is imperative that we are doing the things we need to be able to get the things we need to get so that we can provide the services we need to provide. And I believe that continuing to do these sorts of things are what are driving what's happened in the past. We're just reliving it. And I don't see how it's going to change. How do we find a way out of the mess that we're in? And not to mention the superintendent we have now that we are talking about giving additional compensation to, that we're giving additional benefits to, that we are extending the contract of, led us here. They talked about how they knew that we were going to be dropping ESSER funds for 3 years. Do you know what else happened in those 3 years? We had a 27% increase in the superintendent's pay. Does that seem weird? That you knew that this money was going away and is going to cause a problem, and you're telling me that you knew this for 3 years, yet you decided that 27% was an appropriate amount. I can't make a decision for what the board decided to do and behind closed doors. The previous board member who had my seat stated that she couldn't talk about it because it was discussed in executive session. Do you see a pattern here? We continue to have all these discussions in executive session that we don't provide the information because it needs to be hidden away. I understand the process needs to be separated, but I should be able to ask, how much is it going to cost? And just get a number. I should be able to do those sorts of things and just have an answer, especially when I've asked for it before. And when I don't have it, and this board says, I knew that it was there. Okay, cool, you had some more information than I did, that's great, which granted you're going to. I've even asked for emails to be provided to me from the previous board members. And there has been nothing but pushback on that, saying that there's some sort of, I guess, some sort of privilege for the board member with their email, which is a public email address, for a board member that's in charge of the district that's supposed to be providing oversight, and yet I'm not provided those emails that have been discussing maybe even this, may have been discussing any number of things. And the claim is that it is attorney-client privilege. How is, that's a good question for you, Mr. Leonard, sorry, lost my spot there. If I ask for something, can it be claimed that there is attorney-client privilege held by someone other than the existing board? Is the board not the entity, regardless of who the people are, that holds that attorney-client privilege?
I'm not sure what this has to do with the superintendent's contract.
It goes to the trend that I have here of asking for things and not receiving them. You are one piece of it, but it is not just you. I ask for these things so that I can look back and say, what was the discussion the last time they did this? Some of us might have that. Say, my board director to my left here, as he stated, he had other information that I didn't have and he didn't share it, which I don't expect him to share everything all the time. But if I was going into this, I would have went and looked it up. I would have looked at the board members' information from the previous discussions that happened from District 3, my own district where I live. I would have looked at that information and said, what were they discussing? What was it that were the sticking points before? What did they have to say about it? And he has all that information. He was here then. I don't. I asked for it and I'm not provided it because of attorney-client privilege. And that's why I ask you, is the attorney-client privilege with the board or with the board members?
So, Director Cook, we've had this conversation once before. First of all, your request for documents, I'm not going to respond in totality here right now. The district has a process in which documents are exchanged from one party to another and they're not just readily available for anyone to search through. I do not recall indicating that it's because of attorney-client privileged information. What I recall stating to you was related to potentially private information or other information that was contained that might need to be redacted prior to release. That just because a board member shared information in an email does not necessarily mean that it's relevant, nor should it be discoverable, and that would still need to have a process in which that would take some time and even potential redaction. I didn't say attorney-client privilege. I said non-discoverable. And it's not so simple just to say that you would have access to every email, because I believe your request is for every email sent, received.
It's been changed. I
Okay.
haven't had a response as far as I know regarding that, because they denied my request multiple times. So I've tried to readjust and change it to whatever the right way of doing it is. No one's providing me the right way to do it, so I just have to kind of come up with it on my own, I guess.
But to answer your question about attorney-client privilege.
You were not the one that said that, by the way. I'm not
Okay.
claiming that you did.
All right. The attorney-client privileged relationship does not belong to me, okay? It belongs to the institution, right? But it is possible that attorney-client privileged information that exists before your involvement in the board does not belong to you necessarily. And so I would at least have some questions, and it would depend upon the issue related to it, particularly because you're engaged in litigation against the district right now. And so I would need to make sure that any information shared is not germane to your litigation. Now, I understand that that litigation is more recent, but it is at least a question.
It's not even just more recent. The information that, or the litigation that's happening is due to board action that happened after I was on the board. I don't see how there would be any discussion. If there is discussion before I came on the board, that is something explosive. And I mean, if there's a claim of that, I don't even know what to say, because that's beyond the pale. If they were discussing getting rid of me through 1669 back in October of 2023, before I had even been elected, I can't fathom the situation where that would be allowed.
That was not my implication. It's more that when discovery happens, and your attorneys engage in discovery, they request information.
I mean, you brought it up, sir. I did not.
Okay. Well, my point is.
And you are advising the district on that litigation, are you not?
We have outside counsel on that.
And the outside counsel, just curious, they're
So
also the ones that wrote this.
So I am
Okay.
going to, at
Thank you.
this point, not continue in any more conversation in regards to pending litigation.
Yeah, I hadn't brought it up.
Okay. So to redirect the conversation, I am not sure how this is germane to the renewal of the superintendent's contract. And I'm going to direct the board to only ask questions related to the renewal of the superintendent's contract.
So who would I ask if I wanted to know how this discussion went previously? And I don't trust those that I'm here with, because I don't, for the most part. If that's the case, how do I get that information? Because I can't ask another board. I can't go and talk to Tacoma or Renton or Auburn and ask them how they did it, because that's not here. That's not this particular contract that we are discussing now. So to me, it seems like that would be pertinent information, because we are actively talking about extending the contract that we have currently. And if the discussions about that contract aren't pertinent to this conversation, I don't know what would be.
I guess it's a question of what was asked for. I've not been aware that that's what you were asking for, and that's the first time I've heard that. What I heard you ask for was every email sent and received at any point from the board in any topic for the last 10 years. That's what I understood. I did not realize that it was...
It was actually categorized in like smaller amounts until bigger amounts, and I wanted them done in the smaller amounts first so that it would be easier for everyone. And eventually, if we ever
lost Director Ferrer again.
And I will tell you what my advice was at the time.
I think we should probably wait until Director Ferrer is back.
Again, I asked the board, do we have questions that pertain to item 6.02?
I think we need to wait for Director Ferrer if we don't.
I can ask him.
Okay, well, yes, I have more questions. I can't ask them now because he's not on.
What question do you have about item 6.02?
Is he able to hear us?
I am here.
Okay.
Thank you.
So I guess I still am just concerned with much of what's talked about on here. There hasn't been any answer to me regarding how we are able to do something similar to what we've done before in saying that I am responsible. I don't feel like I've gotten an answer to that. Like, and if this passes and I abstain, if I vote no, whichever direction, it still is the force of like policy here at the district, correct? Whether I vote no or abstain, either way.
Correct.
It'll be the same if you don't vote on the contract at all. Meaning, if the contract is not approved today, your legal standing related to this section does not change because this section already exists.
Yes.
It's existing contract language. It's no different than the day you first took your oath of office in the district, and it's no different today, and it'll be no different depending on how you vote on this. Voting in favor, abstaining, or voting no. Your legal standing does not change because that existing contract, that existing language is the same. The only thing that changed is the alternative dispute resolution section. That's the only thing that changed. Any other question you have for that is, there's no other change. There is no other change. So any question you have for that could have been addressed at any point. The day you took office up until today, it was not asked.
So can I ask another procedural question, I guess? When is discussion about passing something supposed to happen? Is it supposed to happen in executive session?
Voting about passing something?
Not voting. When we are discussing an item to pass, that we are going to have, it's packaged up like this is, or a policy, or a procedure, or whatever we might be voting on. During that discussion, are we allowed to discuss what we are about to vote on in executive session?
Yes.
We can discuss the intricacies of what we're going to be doing. What's the purpose of the Open Public Meetings Act at that point
You
then?
can discuss it. You can only vote on it in open session.
So how do you know that what makes it no longer part of executive session? Because you've said I can't bring stuff out just whenever I want, but at some point we have to decide this is when we're discussing things, and that means we need to be in public. What is the trigger for that? At what
There's a
point?
statute, RCW 4256, talks about what is an open public meeting and what is an executive session. We talked about this at the work session at 5 o'clock. I gave you slides on it.
Yeah.
What it talks about is there's grounds for executive session. One of them is performance of a public employee. That's commonly where we talk about evaluations, also extension of the superintendent's contract. Those conversations are held in confidence because of the protections of individual employees. They're recognized by statute, not by theory, not by whim, by statute, codified in legislation. That's the reason. And we believe that and we follow it. Do you understand?
I do.
Okay. That's the reason why we take action the way we do. That's the reason why we don't discuss the superintendent's contract in open session or allow it to be negotiated in public. Do you understand that?
Of course.
Okay. Do you have any other follow-up questions about that obligation under RCW?
I do.
What is your question?
So my question on that is, you've said during that meeting that we had earlier that
Please be precise.
Even-
Which meeting are you referring to? We've had now 4 today. Which is it?
the meeting that you discussed, Open Public Meetings Act.
The work session at 5
Yes.
o'clock, correct.
Yes. And during that, you said that we could take no action without being out on this dais.
That is correct, and I stand by that. That is a true statement.
Okay. And what is deliberation about this information that we're talking about right now? How does it change? Like, what is it that's out here now, the discussion that we're having here? Why is it that we have to have this discussion? Because this discussion right here could not be done in an executive session, correct?
That is not correct. We could have this conversation in executive session. In fact, most of it probably should happen in an executive session, to be honest.
Okay, I guess I disagree with that, and I'm not sure how to equate that, because you've said that the discussion itself is open public meetings, so it has to be done
Okay,
out
you're
in open?
conflating a couple of items
Sure.
from the conversation earlier. Discussions and deliberations are a meeting, okay? So discussions and deliberations are a meeting, but they're also an exempt or an executive session meeting, meaning we can have that in executive session. So discussions are a meeting, just like action is a meeting, where you take final action. That has to happen in executive session. So I don't disagree that discussions, in fact, it's the only logical conclusion, is that discussions related to items designated by statute should and must happen in executive session. There is a resolution. We have discussion. You can have discussion, but I've told you and I've cautioned you numerous times that the conversation should not include portions of what was discussed in executive session. I said that to you individually. I've said that at the beginning of every executive session, and I remind you of that obligation time and time again, and I'll repeat it again today. The final action, the vote,
Yes.
is done in open session.
So what is the
Honestly, in
other
most
then?
districts, Director Cook,
Yes.
we have the conversation in executive session, and we call for the vote, and there's no discussion, and we vote, and it's approved. That's how it happens.
I'm sorry to hear that.
Okay, well, I'm just telling you that when you're doing the work, that's what it looks like.
So at what point with
Director
that?
Clark has had his hand raised for a very long time.
Call for the question.
Is there a second?
Second.
A call for the question has been made and seconded, so we move to voting on this.
So wait, we do need to vote to end discussion. Is that correct, Mr. Leonard?
That's correct.
And so I would like us to vote on that first, please.
Let me make sure I understand this. I thought the call for the question is voting to end the discussion immediately, and then we go to the question of,
Director Cook is correct. In order to end debate, there needs to be a motion to end debate, and then you can go to the question. So I
This was
would-
the mistake you made the first time back with 1669.
I would ask that there be a separate motion to end debate, and then go from that point.
okay. And I would have to say in my review of Robert's Rules of Orders, the calling for the question is to end the debate, and then you go to the vote of the motion that is out there. But I am fine either which one.
I would prefer that we do this in an abundance of caution to have it on the record and we get a vote on it.
Okay.
Thank you.
Is there a motion on the floor then?
Move to approve.
Is there a motion to end debate?
Oh. Yeah, I move to end debate. How's that?
Is there a second? Ending debate, we're going to have a vote. If that is
Okay.
not voted in, then the debate continues. If it is voted, then do we still have to vote for a motion and for the question? But that doesn't seem correct because the motion's already on the floor.
Just one second, I'm reviewing Robert's rules.
Thank you. Wally, just to let you know what's going on, there's a procedural question that I have right now. It is my understanding that when somebody has asked for calling the question and it's seconded, then the chair moves to vote without allowing debate on that. If there is a 2/3 majority of the members in favor, the motion passes, and then we move to the previous question, which is the motion for 6.02 superintendent's contract in this case, then that one would go to immediate vote with a normal majority rules voting.
That is correct. That
Okay.
is well stated, President Margale.
Thank you. So there's been, just to make sure that we have it procedurally correct, could I have the motion again of calling for the question?
Move to close debate.
Calling for the question. Can we? Sorry.
Call for the question.
Is there a second for calling for the question?
Is not calling for the question ending debate? Or is that the?
That was
call?
his original, and
Okay.
that is ending debate.
Okay, thank you.
Naomi.
Oh, you're back in.
Director Farah?
Yes.
Okay, so a motion is on the floor, and I'm seeing if there's a second for calling for the question.
I second.
Okay, so
Can we do a roll call vote?
yes, Director Song?
Sorry, what are we doing right now?
To end debate, so then we go to voting on 6.02 superintendent's contract. So this is a vote to end the debate.
Okay.
And so a nay vote would be we continue with debate. A yay vote would be to end debate.
Nay.
Director Cook?
Nay.
Director Clark?
Yes.
Director Farah?
Yeah.
And then I vote yes. It does not pass. Debate continues.
Thank you. So I still am having difficulty understanding how this benefits our district. I still feel that we are not
I think we have completed debate, so can we
No.
move on to the vote?
No, we have to
I'm
have
getting-
a
I'm
two-thirds
losing-
vote for that. Director Farah, it is a two-thirds vote on calling for the question.
Mr. Leonard, may I ask a procedural question from Robert's Rules? If we had just moved on and passed this as it was and ignored the two-thirds rule, what would happen in that case?
Can we discuss Robert's rules at another time and keep questions around 6.02, please?
That's not what happened though, right?
It has happened in the past, and that was my question.
Oh, I can't provide you a response to that right now.
Okay.
I
can-
don't know.
can
I
you-
don't know what the response would be. I don't know what
Would
the
you mind
response would be.
finding that response for
I
me and
certainly
getting
can.
back to me?
It probably won't be tonight.
Okay, I mean, that's fine. So the next thing that we're discussing here is the travel. So we've got an annual stipend of $5,000. I still haven't had a total amount provided. I do appreciate Mr. Leonard providing the $23,000 number, but I haven't seen an actual dollar amount that's full. But that's okay. We'll move on through each of them independently then, I guess, and we can discuss them as we go. So when we're giving a $5,000 in-district travel, what is the difference between that and what he had before? Because it seems like we're giving him more, otherwise it wouldn't be provided in here, correct?
No, it's less paperwork.
It's just less paperwork?
Yes.
And so before, do we have any number whatsoever as to what it's been done before? I assume that's a public record, no?
It would be.
The
And-
superintendent has not claimed all of the miles that he does between all of our different schools.
Mhm.
I sympathize. It's not worth the time usually, but it is
That is
wear
correct.
and tear on your vehicle, gas.
So
and
it's worth,
So
but
to
it would
answer
be
that
worth the
question-
time to go through it here, because we're now giving it to him without asking him to do any of that.
In
It's a-
theory,
it's an
it's
appropriate.
$5,000. In theory, it's $5,000. If he did not submit any receipts previously,
Okay, so
it
that
would
that
not
would be an
exceed-
additional $5,000.
it could be, depending,
be.
minus whatever he had done previously.
Okay,
But
considering we don't know what that number is, we'll say
I would
It
it's
has
assume
been
he's
zero
done-
for the last 2 years.
oh, it has been zero. So this is an increase by $5,000, which seems substantial given the fact that it was more than 20% of what you were claiming before, correct?
I would tell you that it doesn't represent an increase in my mind because the superintendent did not submit his receipts. He would have been entitled to. So under any year in the contract, if he had submitted his receipts, he would have been entitled to. The fact that he didn't should not be used as evidence against the superintendent.
But it can be used for the superintendent?
No, I'm only stating that through the value of the contract, the value of hypothetically whether it increased or not, he didn't submit any receipts. He could have, though. And I'm assuming, just let me finish, I'm assuming he did do inter-district travel and does inter-district travel. It's a reflection of the work that the superintendent probably has already done and did for free.
I mean, that's his choice. If he wants to work for free, I'm not going to stop him. I mean, no one's going to force him to file anything, right? I mean, but it is an additional amount than it was previous. So like, so far, it's been $0, and now it's $5,000, and he doesn't have to do anything for it, other than just driving. We assume that he's going to drive enough to make up $5,000. Do we know how much driving that would equate to?
Well, what's your concern with this?
Well, my concern is, so they claim that he does enough driving to equate to $5,000. What is the mileage pay for that? It's like 40 cents a mile or something.
67 cents would be the
67.
All right.
IRS right
Point,
now.
Director Cook, I'm going to read to you what other contracts in the state of
I
Washington.
need to ask a question. Point of privilege. How long is this going to go on? Because there have been people who came this morning, 7 a.m. to work. This is inhumane.
I mean, you could have voted
and
for.
Don knows what he's doing. He's doing this thing on purpose. He's not doing this for anything other than just to make sure that he punishes the people that work for this district every day, day in and day out. And they're sitting there waiting for him to complete this. He has asked all these questions that he asked are already been answered multiple times.
Please. We are not to be disparaging other board directors. I have not done that.
This
to
is not
Director Ferraro.
disparaging. I'm being honest. I'm just telling exactly how it is. This is what you're doing.
When did I tell you that?
You
sir?
are not. You are not. You know,
Director Farah,
trying to be
point has
cute
been
or
made.
anything. This
Director
is, yeah,
Farah.
this is ridiculous.
Director Farah, a point has been made that these questions have been asked and answered, but we will continue on.
So to your question, Director Cook,
Yes,
this
sir.
would have been a great question to ask in executive session. I had data to share with you. You did not ask the question, but here's what I would have said if you did ask the question. $5,000 is vastly under what neighboring districts have. Seattle, the in-district reimbursement is $8,400. In Lake Washington, $10,800. In Tacoma, $9,600. In North Shore, $9,600. In Puyallup, $7,200. In Federal Way, $9,600. In Bethel, $4,800. In Issaquah, $10,800. In Bellevue, $9,000. In Auburn, $8,400. In Highline, $6,600. In Renton, $9,000. In Clover Park, $8,400. In Sumner Bonnie Lake, $7,200. In Shoreline, $6,000. In Tahoma, $14,000. In Peninsula, $15,000. And onward and onward. As you can see, I would have had a response for you, but this was not a question that was posed to me previous. It's only been posed in open public session. This was the product of negotiation with council, and a recommendation has been made, and I stand by that recommendation.
I understand, and like I've said before, we could have postponed this and allowed our public to have this information provided to us. These questions came due to others bringing them to me. If I had thought to bring them before that, I would have. But it wasn't provided to our public until Friday of last week, so they've had 5 days. And I apologize that our public wasn't on the ball enough to have it to you by Saturday. I would have done so had they provided that to me at that time, but they did not. And so those conversations didn't happen until a few days later. And because of that, we had no executive session or any time for me to be able to ask those questions and then get a response. So maybe you can see why it's important that we do a first reading and a second reading like we do with our policies, as this, I believe, is just as important as for 3 years, we are talking roughly $1.2 million going out of all the pockets of our people here and into our superintendent's pocket. And
I
to
find it
me, that's
interesting that you have 3 months and have no questions, yet the public has it for 5 days and they have so many.
I apologize, they're smarter than me. That's why I love our community. Are you saying our community is dumb?
I'm saying that as an elected official, I would have expected better from you.
I often think that of you, so thank you.
I don't think we're on the topic of the contract.
Thank you.
Okay, next topic, we talked about reimbursement. Would you like to continue on with the other districts and how much they're paid, or are you on to the next subject?
I wasn't finished with that yet, thank you.
Okay.
So I did some quick math, and it looks like that works out to be about $3,350, or 3,350 miles would equate to $5,000. How many miles? You said he didn't file for any, so I feel like that would be an infinite number more, right? I mean, it's
The IRS reimbursement rate is $67 in this year. Divide that into 5,000.
67 cents per mile.
67 cents per mile.
That's what I did.
Okay,
It's
you did that?
3,350 miles. And so I don't have anything to compare it to. You can claim that these other districts are doing things differently than us. Last I checked, I'm not in charge of any other districts. I have no control over what they do or how they pay their superintendent or what kind of base pay. Did you look up how much their base pay is? Is it different than the superintendent that we have here?
I have all that information.
Okay,
I
please-
have all that information.
please provide
But
it.
again, this was part of the negotiation that we had in executive session. I do not feel comfortable going into the negotiation strategies that we had in executive session of information that was
I am not
protected.
asking you to go over any negotiation strategies.
Okay.
I am asking you to provide the amounts for those that you just provided of their base pay. That seems like it's not too much to ask. And again, I could have asked these questions over this evening and gotten them when we voted on it in 2 weeks from now. But instead, this is what this board has chosen to do. So this is such an emergency that we're going to get it done tonight. I'm going to have all of my questions answered. Does that seem inappropriate somehow?
So for a 260-day work year on average, 12-month contract, right? And a 72 square mile district, it's about 13 miles per day. I'm actually thinking that we are way underpaying him.
And how many miles did he drive then?
I'm sorry, what was the question?
Well, you're saying that it's 13 miles a day. How many days did he drive 13 miles? Do you have that information? Because it seems like we don't. So my point stands. We do not have any information as to how much he actually drives. So he could be driving literally 500. And that means that we're overpaying by however much that is. Because we have no data to look at, which seems to be kind of a trend over and over and over. I ask for information and I'm not provided it. You don't like the fact that I keep asking questions. And Mr. Leonard obviously has some sort of problem with me asking these questions and continuing down this line of thinking.
I don't. I really wish you would have asked the questions in executive session. And the fact that you were suggesting that that question did not occur to you until the public asked the question about it is, I find, baffling.
Are you calling me a liar?
No, I'm questioning your motivations because we sat in and I went
Is
over
it your job
every,
to question my motivation,
I
sir?
went over every single...
I understand that, but please answer that question. Is it your job to question my motivations in my job as a board
you tell
director
me.
of the Kent School District? Do you get paid to be here? Are you continuing to get paid here?
I
This is
really,
again
I
not
really
about
wish I wasn't.
6.02.
I really
I am
wish
getting
wasn't.
paid $50. Maybe I got 100 today because it crossed over into 2 days.
All right, so-
I feel like maybe my questions should be answered regardless of what you think of me.
I didn't put in my reimbursement either, by the way. I still showed up at all the board meetings.
I'm sorry that you don't want to do the procedures to get paid. That's unfortunate, and you should be paid for the miles that you drive. Same as our
it doesn't-
superintendent.
But it doesn't change the fact that I still was here. So not putting in reimbursements doesn't change the fact whether you're here or not. I still existed.
Yeah, and you made the choice not to get paid for it.
And that's totally fine, and that's true, and I've made that choice.
And instead of
And we could
going
also
through
have,
the-
I am still talking.
Thank you.
And when the superintendent chose not to put in reimbursement, it doesn't change the fact that he still is visiting our schools. He still is going to events. I can name many, many of them that we ended up doing together because of following procedure and process, we end up going to schools together and to the Special Olympics together and to our Martin Luther King assemblies together and visiting our schools on Saturdays. We did a ribbon cutting together at Canyon Ridge. I can go on and on and on and on. So yes, in looking at the contract, looking at what is out there, looking at the mileage reimbursement, $5,000 more is probably completely conservative for what our superintendent does for our district.
I'd be happy to wait for you to calculate that up for me and provide me actual data instead of anecdotal information if you are able to.
Again, I did the math for you, and we are...
No, you didn't. You gave a bunch of different places. You didn't give me like how far away they are from each other, how much he would have been paid. You didn't bother to do any of the homework. So you're expecting to get an A for nothing. And sorry, but that doesn't fly with me. If you're not going to provide me data, then I'm going to assume that there was no driving because there's no other data that I can show. I don't know that he didn't drive a district vehicle. I don't know that he didn't ride with a friend. I don't know any of those things because none of them are provided, which was a choice that our superintendent made when he chose not to supply us with that information, but asked for us to approve an additional $5,000. He could have gotten as much as he wanted had he actually submitted it. He wants a free paycheck that he doesn't have to do any work for. I don't like paying people for doing nothing. I don't know how you do your business, but that's not the way I do mine. And so for me, I want actual data, not just he probably drives more than 13 miles a day. I mean, sure, he could drive negative 13 miles a day. I don't know how that would be possible, but it's the same argument that you're making because you don't have any data. You're just making things up. I ask you to provide the data. I give you the opportunity to go and research, come back and provide me this data, but you don't want to. You just want conjecture. I understand that. That's okay. It's just not going to be enough because I want actual data. If you can't provide it, just say it's $0 and we're increasing his pay by $5,000. That's okay because that's exactly what's happening.
So knowing that that data is not available, is there any other additional questions that you have on mileage?
No, I asked those questions and I am okay with that at this point.
Great. Next question, please.
Sure. Sorry, I'm going to move down through some of the exhibit stuff here. It does talk about dispute resolution. So if our board were to choose to do something to change something in our district, it obviously states that we can do that at any time. How are we able to admonish the board director that the superintendent has chosen to claim is making, I guess, things difficult, is doing administrative interference? At what point would we know that that's the case? Is it just we have to wait for him to say so? Do we have any indication as to what it is that is going to mitigate that? So where we can say, okay, well, if it crosses this threshold, that's the point where it's going to bring something against you. And that's what I would like to know. What is the point that I can't go past? Because this is tying my hands to some extent. It's tying all of your hands as well. I don't know if you realize that, but it is tying your hands. You are not able to do everything that you may think you can do because if it does go against administrative interference, communications, and relationship, I don't know. It seems to me like that is pretty broad. So if I were to send an email to a constituent that has reached out to me, is that going to cause a problem? You negotiated this, correct?
I did. There was many, many questions and a lot of conjecture within that. And so administrative interference would be against a board member or against the board would be brought up by the superintendent.
And if I were to, say, email a constituent that had reached out to me separate of the board here directly, what is going to indicate that that's going to come against me?
I'm not going to answer any hypotheticals.
Are there any examples that you can give me?
I'm not going to answer in any hypotheticals.
So we have no idea.
Again,
So
this is an existing board policy, part of the sorry, take that back. This is an existing contract that we've had many, many, many months, again, since, and Mr. Leonard has said this from the day that you have sworn in that you could answer this, because this has not changed. The only thing that has done is give us a different opportunity for being able to look at any disputes in a more collaborative arbitration method as opposed to going only in a judicial route.
All right, are you finished? Okay, so I was actually asking about Exhibit 1. As far as I understand, Exhibit 1 was not in his previous contract, is that correct?
You're talking about Exhibit 1 on, sorry, my computer has reset. Hold on, let me pull that up again.
It's
problem.
attached to the addendum.
I'm sorry, what?
It's attached to the addendum.
No, I think at the end of the night,
Oh.
it just resets, and so I have to re-pull up everything just a second.
I'm happy that we're able to give you that time to sort this out.
Do you have it pulled up by any chance? I can look at it really quickly. The addendum.
Mr. Leonard, do you have the addendum up on your laptop? Or you have it? Yep.
I have it.
Question?
Well, it was for the president, but
Thank you. Okay, so I'm sorry, what was that?
so I had asked if I were to get information from a constituent or a staff member, and they contacted me separately, not including the entire board, and I respond, does that fall under the communications section of the dispute resolution process, indicating that I would then be required to go into the JAMS rules, which I
I'm
don't
not going
fully
to answer any hypotheticals.
Okay. So with the dispute resolution process, is there a point where a board member is able to bring this against the superintendent, or is this only one way? As far as I understand it, it's just one way. Is that correct, President Margot?
Correct.
Okay. So given that, it looks like we have to have this done a one-day mandatory mediation. What would happen if we didn't meet that? Like, is that going to automatically
Question's been asked and answered probably 3 hours ago.
And?
Question's been asked and answered 3 hours ago.
Okay.
Director Clark,
Call for the question.
Yes, sir.
is there a second?
You lost him again.
close debate?
You already did by calling for the question. We've determined that that is one and the same.
Oh, I haven't heard that.
Yes.
And just for clarity, if Director Farrar is not able to be brought back on and this vote goes half and half, what is the situation at that point?
It has to be a 2/3 vote.
No, I'm talking beyond that, because we would then take the vote, unless you're not planning on actually voting.
Oh, here he is.
He's back.
Here
Okay,
we go.
well, that's good. That removes that.
Okay, a call for the question has been made and has been seconded.
I ask for a roll call vote again.
Director Song?
No.
Director Cook?
No.
Director Clark?
Aye, that's a controversy, actually. You seconded a motion and then you voted against it.
Yeah. Am I not allowed to do so?
I'm just pointing out the irony.
I was just trying to move things along while we waited for Director Farrar to come back online.
Director Clark, your vote?
Oh, I'm back.
Yes. Director Clark, your vote?
Yes.
Director Farah?
What am I voting on? I'm sorry, I just came back on.
To close debate, calling for the question.
Yay.
I vote yay. The motion fails. Debate continues.
Thank you. All right, let me move back to where I was just a moment. So with the dispute, if this is going to be brought against me, because it does seem rather targeted, and we have to go to Jan's.
Remember, this was written and part of his contract before you were even on the board, before I was on the board.
Oh, again, I'm talking about the exhibit, President Margell. Are you tired? Would you like to maybe postpone until tomorrow?
Again, you're talking about the communication only?
I'm looking at the dispute resolution process as
Okay.
it's written in Exhibit 1.
Okay. Please continue.
Thank you. So because as far as I understand, maybe I'm incorrect, Mr. Leonard, were there any indications to JAM's rules in the previous contract? No. Would you mind going up to the mic so that it's on the record, please? Thank you.
No.
Thank you. So with that being the case, if we're going to have something brought against us, what happens if we don't have the time? Say you're like Director Farrar in this situation, if he was not able to call in, does that mean that it just goes forward, or do we have to wait? Because it doesn't seem to spell out what the process is if someone's not available to be able to take that.
Again,
Or does it state that somewhere that I'm missing?
Again, I think it's hypotheticals, and the spirit and the rules in here are detailed.
They tell what?
The spirit of the contract and the rules of which are spelled out in here are there to read.
Oh, that's great. Would you mind explaining it to me a little better? Because obviously I don't understand it very well.
I believe that any questions that could have been asked have been answered. Is there an additional question?
But I mean, you keep saying that. I just don't, you didn't actually answer anything. You say that it's been asked and answered, but I'm sorry, I don't remember you answering it.
Not every iteration of every single thing that could or could not happen is going to be enumerated in a contract. That's impossible. It's an impossible thing. And so the contracts are written in a way that the spirit is put out there, the rules for which it would be followed are part of it.
Would it be appropriate for me to ask possibly the superintendent what his thoughts are on how I could best avoid making this mistake in which I would require all of this to happen?
I think you can ask. I believe he's answered that question already and declined to answer, but you can, of course, ask.
Yes, let me just clarify. You had an original question related to timing and date, 5 days, correct?
Well, it says submitted to a
5 days.
one-day
What would happen if
mandatory
someone
mediation.
was not able to?
Yeah.
Yeah. Mr. Leonard, can you answer that? Again, I believe that was President Margel's point. Was answered before, I believe, in section 3 of the addendum. Yes, that the dates can be mutually agreed upon. I believe that you've mentioned that.
Correct.
And so I know they talked about it being that it could take, multiple months at times to get this done. And it seems like that's a lot of time if it's something that's so important that we need to pull a board director out of what they're doing to be able to go into this mediation. If we go into that, is the board director barred from anything outside of being required to go to mediation, or is there no other mechanism to force the board member to acquiesce to the superintendent's request?
I would ask Mr. Leonard to address that.
Could you repeat the question, please?
So my concern is that if, let's say it was brought against a board director and they tried to get an idea of what's going on, what is the punishment, I guess? Like, what is the consequence of that not happening? Like, what to the individual, not to the board as a whole? Obviously, the board as a whole can make whatever choices they want. Is that right? Because it does state that elsewhere in the contract.
What is your question?
So as far as the consequences to an individual board member, would that just be that they're required to go into mediation and to have good faith? As far as the good faith goes, the parties agreed to participate in good faith. The parties would include individual board members. Is that right?
It can.
And so what would be the consequence if there is no good faith? Or if there is good faith, yet they still are not following whatever that procedure is? Like, let's say they get through mediation, it doesn't work, they go on to litigation at that point, and then what would be the consequence after that? So say I end up in court, right? What is my consequence for breaking that contract?
Breach of contract?
And what would that mean for me individually?
I don't think there would be anything for you individually. I think that would be predominantly a question about the board and its collective role.
Is the board able to punish a board director themselves if they aren't following what the board likes?
Generally, no, with the exception of maybe a censure.
Mm-hmm. And censure, as far as I understand it, is basically the board admonishing one of their members saying that they're not doing what they're supposed to. Am I understanding that correctly?
That's fair.
And there's no additional punishment, there's no downside to it other than you have to take the reputational harm, I suppose. Is that right?
Your words.
Okay. So when we're going through that, and we're going through a lot of this stuff, and the end goal is that we're able to bring things against the board or individual board directors, and the most that can happen to them is just admonishing them. But we're putting this all in writing so that we have to go to court and mediation and spend all of that money so that our one employee is able to force us into mediation and possibly bring legal things against them. Am I understanding the purpose of this, right?
Again, the contract as it stands today already has the legal remedy. Today is coming up with an additional option that will give a more collaborative and non-judicial method for being able to hopefully resolve matters more in a quicker manner and a less costly manner.
So I understand that purpose, but I keep hearing that it's not, that it's already in the contract, which, okay, that's fine. But the contract ends June 30th, correct?
Correct.
Currently? Mm-hmm. So on July 1st, it would no longer be in force.
Correct.
And so it is definitely different. I would have to keep myself in line if I wanted to avoid that whole procedure until then. But after that point, this would no longer be in place, and we would start all over with theoretically a different superintendent, maybe this superintendent, and we would start over with that process if it were to get to that point. Am I understanding that correct? So
You would never want to go into the last year of a superintendent's contract without having something in place.
yeah, I understand that, but the claim that it's not changing, like that it's not changing the earlier contract and you're already stuck with that. Well, yeah, but I'm only stuck with that until the end of June. And so that seems like a substantial difference because it's including another 2 years that all of the board members, including new board members at that point, who haven't been elected yet, if they end up running, would have to be held to this, correct? So even though they had no control over it, they would then also be held to this, I assume, Mr. Leonard?
Correct.
And so with that, so the entire punishment, the entire crux of this is so that if the superintendent wanted to cost our district a whole bunch of money, he could sue us for this and also force us into mediation, costing additional money, which seems like a faster resolution, but if it didn't end up causing the resolution to happen and it had to go to litigation, it would just mean additional money coming out of the district to then go fight that in court. And so after all of that's done, and there's tens of thousands of dollars spent on both sides, the very end of that would be that you'd say, don't do it again. Am I understanding all of that correctly?
Your words.
Okay, but it's not like substantially wrong. You nodded your head. I don't know.
I don't know if there's a question there, sir.
Okay, well, I mean, you said your words. I don't know. What do you mean by your words?
That seems like your conclusion.
How is my conclusion wrong?
I don't know if I have a comment to that.
Is there anything about what I said that was incorrect? You'll have to verbalize because there are people that are listening.
No.
Nothing that I said was absolutely incorrect. It's
Correct.
Okay, thank you. And then, so the problem with that is that we are also going to be paying, the board itself is going to be paying all these fees and costs. So that, my thought on that is that we are now going to, instead of punishing the board director in a way that actually is substantial, we're just going to point at the fact that he or she is costing the district this additional money. And at that point then, that seems like an argument, I guess, but what purpose does this serve? Let's say there was a board director that didn't care and I mean, you can't get rid of him. You can't remove him from office if he's not doing anything illegal or she for that matter. As long as they're not going against RCW law, even if they break policy, that doesn't have the weight of law behind it. We could go to court, but the most you would be able to do is admonish that board director. So you really feel that it's so important that we get this done tonight and we don't allow our public to weigh in on anything more because you want to be able to admonish a board director for not doing what you want them to do. That's how I understand this. And maybe that's not correct. If it's not correct, maybe you can correct me and say that the big reason why we're doing this is because it's going to affect a change in behavior of that board director. And this fictional board director does not care. And then they go ahead and do it anyway. All that happens is it takes up time, kind of like this evening, taking up so much time of ours. And yet, we think that that's an appropriate use of our time and money. We want to add that in there so that we can have a board director that is not responsible financially, not responsible really in any capacity other than for you to censure, which you could do at any moment, at any time. There's no requirement of anything for a board to censure one of their members, correct? They could censure a board member anytime?
Again, this is not for a board member to use against another board member. This is the superintendent against the board,
Yeah.
particularly one. And so your questions are being directed as if it was board member to board member.
Well, it would have to be. The only actual consequence is censure, as Mr. Leonard pointed out. So the only actual consequence is censure. That, I mean, at the end of the day, other than all the money that's been spent because we've decided to allow this to continue, all that happens is you censure a board member, which you could have done at any moment, but you wanted to waste all the money first before you did that.
But again, a censure is the board against a particular board member.
Yes.
This is not. This is part of the superintendent's contract to give him or her a remedy for, no, I forgot the word, interference, administrative interference.
Yes, but the whole consequence, so the entirety of everything here, is that that board member would have censure. That's the end. Like, no matter what, there's no bigger consequence to that board director other than censure. Is that correct?
Again, two different processes. One involves the board against a particular board member. The other is the superintendent against the board or a particular board member. Again, I've
But
now
there's
asked
no-
that question 3 times and I've answered it 3 times.
Okay, I'm getting to the point of, we are doing all of this, and the worst that you can do to that board director is censure them, even after they've done all of these things as you say they've done, and they've caused administrative interference in whichever way you believe they're doing it. And after all of that's said and done, everything takes months, 6 months, who knows how long it takes. And 15,000, 100,000, who knows? As much money as it takes. And after all of that, we've just wasted the public's money to be able to censure a board member that you could already censure. That's the whole crux. We're literally just writing something in here to give ways.
Can we pause, please?
Yes. Oh, sorry.
Thank you.
So I guess that's my point here, is that you have a whole bunch of words. You have 6 pages of them here. Plus, I mean, I don't know how long this other one is. It's the superintendent's contract for the rest of it is 9 pages with an additional 6 over here. And after all of that time, after all of that money that we are authorizing the superintendent to use to do this, all that the board member is going to have against them is censure. And that seems to you and this board like a good idea. And you have no answer to me why that requires this.
Call for the question.
Question has been made and called. Is there a second?
Second.
It's been made and seconded. We will vote now.
I'd like a roll call vote, please.
Director Song?
No.
Director Cook?
No.
Director Clark?
Yes.
Director Farah?
Yes.
I vote yes. The motion fails.
So I guess the question here is, if I am trying to get to the bottom of why you think that it is so important that you're able to provide that sort of consequence, where do you believe that that's going to go? Do you think that,
It was
do you
part
have
of
it?
the negotiation, and this was where the negotiation ended up.
I understand, but you're voting for it. It doesn't matter how the negotiation went. They can ask for whatever they want. You can respond with whatever you want. You have to come
And
to.
as you could, as
Yeah.
all the board could.
Well, I mean, but we weren't asked, just
But you were.
I wasn't. When this
All
started.
5 of us were.
I was
in
not.
3 different executive sessions.
After you'd already done the negotiations with no other board member involved. That's just a plain fact. If you can prove that that didn't happen in the way that I'm saying, please provide it.
That
I'm
is
happy
that
to
is that is incorrect. Negotiations continued after the executive sessions up until fairly recently, after conversations with the entire board.
So can you provide me the date of our first executive session where we discussed the contract, not the review, because that was a separate issue, I assume, right? Like that doesn't give authorization by having the review done of anything. So when was the first executive session done with this board where we discussed this contract?
I'll have to find that for you.
Thank you.
It won't be tonight.
What's that?
It won't be tonight. I'll get that for
Oh.
you at a future date.
So another piece of information that I'm denied again. And you claim that you did ask and we provided your authorization to go in there and do these negotiations. Yet when I ask you to prove it, you say, well, we'll get back to you when we want. And to me, that seems like you don't really care about this board. For me, I feel like I have not, since I've been on this board, have I had any sort of reaching out to try and make things better. It's always just something that you're trying to push through. And when I have questions, I expect answers. And I don't know why you don't. I don't know why there are so many here who have no interest in providing the oversight and direction that we are supposed to be doing as board directors. And our public expects that of us. They expect us to come here and have real debate, for you to come up with whatever it is that you are voting for, not because it's a contract and we need a contract, or because we need to do this quickly because March is coming up tomorrow. None of those things are really what's affecting here. The issue is that every time I come and ask a question, I am almost universally admonished for asking it. And then when I ask questions and I don't get the data that I ask for, you say, oh, well, you didn't ask it in the right way. Or when I ask a question and I ask it in the wrong time, or I ask it in some wrong context, or I go to provide the support that I'm supposed to as an elected member of this board, and I'm admonished for attending the schools that I'm supposed to be in charge of. And
Not attending, just not allowing for people to know that you're going ahead of time. You can attend. That has never been a question. You just need to let people know ahead of time. You know you were supposed to let, as a courtesy, the president of the board know. That's been known since the beginning, and you still didn't do that.
even so, even if I don't do that, why is that important to you? Why is it that you are so concerned about what any board member is doing, assuming it is not illegal or immoral, like nothing that I've done is? Any of the things that I've done are not either of those things. You can think that they're weird, I suppose. I think it's weird that you don't go out there and do these things. And no, I don't think you should have to go and ask permission every time. When I
Not permission, prior knowledge. Those are two very different things. There's also been a number of other falsehoods that you've just said during your monologue. One is that I don't care about this board, and
oh, I said I feel that you don't care about this board. That's different.
Then I will move on.
Thank you.
That there was I'm not sure if the word was used as an election or a chosen of who would be negotiating the superintendent's contract. Again, that's not required. It's through process, procedure, and historical, not just at Kent School District, but every other district that it has been the board president that's done that. And so no, there was not a decision on that one. It again is just through history and process. But again, that starts, and the entire board has been, at least for 2 months, have been available to be able to comment, question, and have conversations, which have been taken advantage of. And again, questions, I have no problem with questions. What I have an issue with is when people bring up false narratives and then expect for people to disprove them. It's a false narrative. It is not my responsibility to disprove your false narratives.
You'll have to explain that one to me.
If somebody says there's corruption, and we have had time and time
Has
again.
someone said that?
Yes, you've said that to me. You said that there is corruption in the district and you are going to prove it.
You need to provide receipts. If you're going to make claims like that, you need to be providing receipts. So please show me in whatever capacity I've ever said
I
that.
heard it from you
Yeah.
tonight.
About what now? I said that there could be corruption, and I used that as an example of another board that is not this one. I'm using that as a way to say, how do you combat that? And my answer from the answer that I'm given every single time is, well, that's not what's happening here. How the heck does anyone know if you don't, like, I believe
We're
in trust but
audited by
verify.
OSPI and have passed every single audit.
You know who else did? Those schools up north that they ended up having to get rid of their superintendent. Or maybe Richland. They had something similar. Those boards also passed their audits. So I guess if you want to put all of your weight into the audit team, okay, but they make mistakes too. And I'm not saying that that's happening here. I've said that over and over and over. But what I am saying is that when I ask questions, every time, just about,
We would have loved your questions for the last 3 executive sessions and the personal questions that you had with Mr. Leonard. Again, your questions are not the problem. The questions are that, and today's questions, if they were as a productive way to get the information that you need to be able to make a decision, I would have no problem with that. You have already said out loud that you're going to say no or abstain. And so
I said that if I were to abstain or to choose to not vote yes.
And so if there is any possibility that you're still looking at a yes today,
I am. I'm waiting for you to tell me. I'm waiting
there is
for you to
no
explain.
new information that is going to be given to you. All information that has been given, we have had, we're coming up on 10 hours here, of being able to give the information in addition to the months and months and meetings that we've had to be able to discuss this.
I feel like I've addressed that over and over.
As I feel like I have too. So is there any additional information or questions that you have that can get us closer to a vote on item number 6.02, superintendent's contract?
I believe Mr. Leonard was going to be providing me the base salary of the other superintendents so that we could compare. I don't remember him providing that.
What other questions while he's getting that do you have?
Well, I guess I'll read the administrative duties here and get to that because, well, unless Mr. Leonard has that stuff pulled up.
Seattle School District, 335,000 base, 387 total.
Can you tell me the
Lake
qualifications of each of those, or do you have it?
What's
I can
that?
try and look it up. The qualifications, I'm just curious.
No.
No? Okay.
No.
Thank you.
Lake Washington, 348,997 base, 440,554 total comp. Tacoma, 295,678 base, $354,002 total comp. North Shore, 327,692 base, 402,316 total comp. Puyallup, 251,742 base, 352,043 total comp. Federal Way, 323,554 base, 424,778 total comp.
Mr. Leonard, we're starting to get into districts that are much, much smaller than ours.
I understand. I simply pulled all the data from Puget Sound ESD, which is the information that we used in our negotiations. And there are quite a few districts that are included. Issaquah, 344,000, 284. Total comp, 391,390. And it goes on and on. There's quite a few districts in Puget Sound ESD. But I do have that data, and I had it with me in executive session. In all 3 executive sessions, I've had it at the tip of my fingertips, and would have loved to have had this conversation at another time.
Yeah, I wish our public had that information as well. I wish that they had a chance to speak to this before now, but we are where we are.
Well, and
I had one question about that, because you provided all those numbers. What's the total, because you were able to pull that up fairly quickly for all of those other districts that you aren't actively working for right now. What's ours? What's the total?
Oh, I have that too. You just
great.
You didn't. I have that too.
Fantastic.
355,000, and total comp 371.
So, did you not say that it was 23,000?
This is current contract.
Oh, I see. So,
Current contract.
But we still don't have a total for what we're voting on, correct?
$394.
Thank you. And so we're paying $394, and that obviously falls in the upper end because many of those numbers were lower. I understand some of the districts are smaller. That makes sense to an extent. I don't understand that the 27% raise that he got before, or how they justified that, or how we justify continuing to give more raises, given that the district is no better today than it was a year ago. But that's, I guess, just the way things are. I'm disappointed, but at this point, I'm glad to have gotten the information that I requested, however many weeks ago. I'm sorry that I didn't think to ask the questions that came to me in the days since it was presented to the public. But, yes, sir.
Please finish your thought.
Okay. I just feel that us choosing to do this is wrong, and I'm sorry for keeping everyone here, but you're claiming an emergency that we must get done today, and in 2 weeks wouldn't be possible. And I want to remind everyone that I tried to send everyone home hours and hours and hours ago. I tried, and I was voted down. And I just wanted to get to the bottom of all of the information that I could. And I still don't feel like I was provided everything. I still don't understand why this is needed, why these changes are necessary. But I'm done talking about it. I had hoped that in some way the data that I got would somehow sway others' votes in another way. Maybe they'd understand what I'm trying to get at or what our public is trying to get at. But obviously that's not the case. So I'll finish here and we can continue on.
Is there any other discussion? Seeing as none, we have a motion on the floor for the approval of item 6.02, superintendent's contract.
Can I get a roll call?
Director Song?
Yes.
And I'm going to be abstaining. Is there anything I need to do for that? No? Okay,
Just
thank you.
abstain. Director Clark?
Yes.
Director Farah?
Yes.
I vote yes, the motion passes. We are now on to item 6.03, gifts, donations, and/or memorials acceptance.
Move approval of 603 gifts and donations.
Is there a second?
Second.
We are now open for discussion on item 6.03, gifts, donations, and memorials acceptance.
We had some corporate sponsors did very nicely by the school district. Costco came through for Kent School District Teaching and Learning with $500 towards backpacks for students and another $500 for supplies purchase. Kent Ridge High School got a gift from Seattle Aquarium of $588 to pay for field trip costs, transportation. That's all. Thank you.
Thank you. Is there any other comments on item 6.03?
I just want to thank our donors. It's great that they find a value in providing additional funding due to the fact that our legislature has not fully funded schools yet.
Any other comments? There's a motion on the floor for item 6.03 of acceptance, of approval of item 6.03, gifts, donations, and memorials acceptance. All those in favor, please raise your right hand and say aye.
Aye.
Director Song, I'm sorry, was that?
Aye.
That was an aye, okay. Director Farah?
Aye.
The motion passes 5-0.
Madam Chair, I move approval of the consent and count agendas, items 701 through 704.
Is there a second?
Did we lose Director Farrar?
Anybody could second.
Well, I understand, but if he's still there, I just want to make sure he's still there. Okay, yeah.
Is there a second for approving the consent agenda items 7.01 through 7.04?
Second.
The motion's been made and seconded. We are now open for discussion on the consent agenda items 7.01 through 7.04. Seeing that there's no discussion, we move for approval of consent agenda items 7.01 through 7.04. All those in favor, please raise your right hand and say aye.
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 The motion passes 5-0. There's no final communication from the audience.
I had one question on the informational item.
Yes.
A member of the public had reached out to me and asked about which it doesn't seem to have happened yet, so I'm not saying that this is something that is happening, but the fact that it points out that we're putting student voice first, it's not that it's only student voice, it's student voice and then others, right? That was my understanding of it. I didn't know for sure.
On the procedure?
Yeah.
Ms. Holly's gone for the day. I'm here. Oh, there you are. Do you want to come and talk about procedure 1420P? Aren't you glad you stayed? May I invite you up?
Good morning, members of the board.
Good morning.
President Margell, Superintendent Villa, Ms. Curry. We just moved student voice up in the order so that kids could go first.
Yeah, but it doesn't stop others from commenting after them, right? Still at the beginning of the meeting?
No, they can, we have the 30 minutes to begin with. And that's, we'll start with the students and then go with any adult after that for the 30 minutes.
Yeah.
And then at the end.
That's what I thought it was. Just someone had asked because it didn't specify that there were others going to speak during that time, and that's all I had a question.
The other part of that student voice is when we have presentations and that type of thing, I think our intent was to move students to the beginning of the list.
Yeah, that's what I thought it was. I just wanted to speak to it so that the person that asked me the question, I could say definitively, yes, people are still going to be able to speak after the students.
Absolutely,
Thank you
as
very
long
much.
as it's within the 30 minutes. And if not, then at the end.
That makes sense. Thank you very much.
Right, you're welcome.
Appreciate it.
If I may, I'm looking at the red line that was included in our agenda and published online. So first items are the opening. Second is the if recognition of outgoing board that happens once a year, or once every 2 years, I guess. Oath of office for elected board directors. For reorganization of the board, again, this is only once in December. Then student voice. Then any recognition presentations, and then communication from the audience, which is 30 minutes.
I see.
So that was item number 5. And so what we're doing is taking the student voice and putting it in front of the presentations in case we have some very long presentations.
And that's, I just wanted to make sure, like, 'cause I don't know. I was like, I don't understand why this is an issue. It didn't make any sense to me, but I wanted to make sure that we addressed it just so that they felt like they were heard.
So, yes, and so again, that puts the student voice, what's really do is moving that out and having it as being a separate section in front of recognition, in front of presentations.
I appreciate the
Of course.
explanation there. Thank you.
Yep.
That's all
Okay.
I had. I don't know if anyone else had any questions.
Nope, I think we're good. There was no further communications. We have had all of them for the evening. So now we are on to 9.02, board reports and discussion. Director Song?
I'm sorry, I just trying to gather my thoughts. I'll just end it with thank you everybody who sat through this. I wanted to provide opportunities to ensure that we're encouraging and providing the opportunities that people need to voice their concerns, have their questions asked. I would have done the same for any other board member to have that privilege and the right to engage in the dialogue that they felt they were entitled to and that they thought was in fairness. So again, thanks for everybody for joining us tonight.
Thank you, Director Song. Director Cook?
Yeah, so I'll speak to that too. I'm sorry for keeping everyone here. I really was. It wasn't with malice. I wasn't trying to do this to hurt anyone or anything like that. I just felt that I wasn't able to get my point across, and I was trying to get information, and I kept being told no. And I appreciate Mr. Leonard taking the time to go through and get that data for me. I really do. Thank you. And I appreciate everyone taking the time to answer my questions throughout. I did go to the ice cream social, like you talked about earlier. That was at Sunrise Elementary, where my wife works. And I planned on going to Millennium. I apologize to Millennium staff there and the students and parents. I ended up having a flat tire, and so I had to get that fixed. And so that was the only reason why I didn't show up. I was planning on going, and then it just took like 20 minutes too long. And so I apologize for that. And as far as reaching out to the district, I apologize for not providing that information more timely. It was kind of a last minute thing. I hadn't realized how hot it was until it was already that day and it was so hot. And I might have reached out the night before or something saying that I would try and do that. It wasn't my intention to try and catch anyone or anything. I just wanted to show the public what it was because everyone was upset about it. They were a little bit concerned, and I was hoping to be able to assuage some of their fears somewhat. And I hope that that did so, or that it brought up issues that maybe we can address. And I think it's important that we show them these sorts of things. I really do believe in transparency. It's something that's core to my beliefs of how our democracy and how our government should work. And me doing those sorts of things is not me trying to punish anyone or me trying to catch anyone or anything like that. But if I do come across things, that's when I bring up questions and I accept the answers that I'm given. I don't go and fight you on it. I don't know if anyone's ever noticed that, but I don't. I do ask questions, and sometimes they're hard questions, but they are there so that I can make sure that I'm doing as much as I can to provide the service that I believe I should be doing. And I know that that's different than some others and how they provide theirs, but I feel like it's something that is important enough to hopefully try and provide the public with what it is that they feel they need to make the choices they're making in going to the ballot box and making choices there, right? And so they're asking for more transparency. I was asking for more transparency before I came on the board, and I'm trying to push in that direction. And I know it's a little bit sticky getting through that, but once we get to a point, I feel like where that's just normal, the public will see it, and then it makes it much easier. And I know that me doing it makes it a little difficult at times, but because it's me, they know I'm not gonna lie about it. They know that I'm gonna go in there and I'm gonna tell them however it is, whether it's good or bad, whether it's something we should be upset about or something we should just accept. And I'm hoping that by doing so, people will believe more in us doing our jobs. and will see what we're doing and think, maybe I could do that too. And I hope that it encourages people to get involved in their government. But outside of that, I just want to thank all of you. I know you all have jobs to do. Thank you very much, and have a good night.
Thank you, Director Cook. Director Clark?
Pass.
Thank you, Director Clark. Vice President Farah?
I just want to start by thanking the community that came tonight and thank the board and the superintendent governance team. That brought something to my heart to let us know that we're doing something right. A lot of times we get pushed and criticized, and you tend to forget the community really appreciates us. And this is coming from someone who had 4 kids in this district and moved to Kent School District because of the quality of this school district. So, and I really appreciated them to come tonight and let us know how much they appreciate us. I also want to thank Darius and the rest of the team. I'm sorry I couldn't see them, who came and shared the bullying that they experienced. And I just wanted to let them know that this is against everything KSD stands for. Bullying is not okay. And we will make sure that they don't have to feel that way, especially those who are LGBTQ face extra that we have witnessed before. So I just want to thank them for coming forward and letting us know. I also want to talk about visiting some schools since last meeting we had, and I can't express enough how much work that goes into and the love that the staff has for our kids is just staggering. I also share the same with the superintendent, the remembrance of 9/11. I've heard so many insults that have been hurled towards Superintendent Vela, and I just want to warn us. Sometimes when you say things like he has reached his ceiling, things like he can't go beyond this point, we need to get someone who has more. This man has spent in this district over 27 years and knows inside out. So if you don't think that he's capable, sometimes it's really best to, you can criticize the work, but when you talk about personality, it seems that it's personal. It's not about the work that is being criticized. So as a person who led teams, I always make sure that I don't personalize when I'm telling someone that they need to do better. I always talk about the work. So when you talk about the person, then you're not really being a leader that want to encourage or inspire them to do better. So I really want caution us using those kind of language and making sure that we don't do that. And not last but least, I want to thank the dedicated staff that has stayed until now, and those who are in the schools to always serve our kids. I can't thank you enough, and I will always be grateful to what you do for our kids. That concludes my report.
Thank you, Vice President Farah. My report for tonight is I wanted to thank the board for coming up with our WASDA priorities. I look forward to hearing throughout the year the advocacy that all of us can help bring to that. I also wanted to talk about the work sessions. That was a new thing we, at least since I'd been on the board, that we had tried to make sure that everybody got their voice in for what we want our work sessions to look for, and beyond the schedule for the remainder of the year, and it looks like we got some really good topics out there. And so I look forward to learning more about the many different aspects of our district as prioritized by our board during those sessions. I also wanted to say that I'm just encouraged by the innovation and new things I hear happening in the district. I know that there are some schools, and much to the chagrin of my 8th grader, that are doing no cell phone policies in their school and looking at the research and doing research-based decisions on why we are doing what we are doing within our school. And I know that sometimes it's hard when you have a whole bunch of students that don't like it and still sticking to what the research says. And so thank you to our principals, our administration, and our teachers for trying things new and continuing to move our district forward in making us better every single day. I would also like to encourage all of you to come out. We did have a meet for Kent Ridge Girls Swim today, that unfortunately due to Highline School District's challenges right now, it is not going to happen, but alas, that is okay, because next Thursday, Kennedy, and that is a big school to be able to compete against. You can watch them at Foster, or if you'd like to just get doused with all of girls swim from the Kent School District, Kent Ridge, Kent Meridian, Kentwood, October 3rd at Lindbergh Pool, because Kent School District does not have our own pool. And with that, I can, oh, nope, the most important thing, the reason why we do all of this. Thank you, students. We are here for you at 2 a.m. We are here every day, and our heart and soul goes into this. Thank you very much. You are the reason, you're the reason for all of it. So it is 1:59, and we are adjourned.